Welcome to Judiciary Non-Civil. We're going to go ahead and get started. We have a full agenda today. I'm filling in for Chairman Leverett. Representative Gullett, if you wouldn't mind leading us in a word of prayer to start us off.
Bow your heads. Thank you, God, for this day. Thank you for the ability to be here. Give us the wisdom, strength, courage to do what's right for Georgia, and bless our decisions as we make them for what we feel is best. In your name we pray, amen.
Thank you, Representative Gullett. I've got several DAs here and Solicitor Finch, I believe, is hanging around. So there he is in the back. Good to see y'all. Glad to have you with us. So thank all of you for taking time out of your busy day to come and be with us. First bill we're going to hear is House Bill 231, Representative Gullett. You want to present from right there, you're more than welcome to.
Thank you, Chairman. Thank you, members of the committee. This is a bill that we've passed, I think, 3 times last year, and it got caught up in, we did a conference committee report with the Senate, and it kind of got caught up at the very end with just some politics, some other things. And so we're trying to do it again. It's primarily the same. If you were here last year, it's primarily the same. I'll go through it, obviously, though. The only difference is in this year's bill, I think, is what's made it better, and that some district attorneys I've worked with additionally this year to try to ease some of their concerns, and hopefully some of them talk to that today. And we'll get started. So what this does is LC 480866S is a substitute. It creates a commission that has the power to discipline, remove, and cause involuntary retirement of appointed or elected district attorneys or solicitors general. Just for your knowledge, there are 49 district attorneys, I believe, and 66 solicitors in the state. Someone will correct me, I'm sure, if I'm wrong. And what we're trying to do, or what I'm trying to do here, is address willful misconduct like sexual harassment, misuse of funds, as well as persistent and blanket refusal to prosecute charges based on political modifications. What it does is it creates a 5-member investigative panel, and I'll go through the bill in a second, just kind of give you a summary here. A 5-member investigative panel and a 3-member hearing panel. The investigative panel will be responsible for the investigative, prosecutorial, and administrative functions of the commission, and it's made up of 1 attorney who is or used to be a district attorney, 1 attorney with prosecutorial experience, 2 practicing attorneys, and a former DA or Solicitor General. The hearing panel is responsible for adjudicating formal charges filed by the investigative panel, issuing disciplinary and incapacity orders, and issuing standards of the commission. Its makeup is 1 citizen member, 1 district attorney, and 1 former judge of a superior court, the appellate court or Supreme Court of Georgia. The commission, with the assistance of PAC, will promulgate the standards of conduct and rules for the commission's governance, and they will be adopted by the Supreme Court. And then I think from here, if someone files a charge, and we'll go through what those options are, or what the possibilities, the grounds for discipline are. They do an affidavit, and if the complaint is with the commission alleging something is wrong, the complainant will be required to file a sworn affidavit detailing the personal knowledge of the facts supporting the complaint. Again, we'll go through that. It also allows the commission to bring a complaint on its own without a complainant. But basically, and then we also have an area in there that restricts baseless complaints about charging decisions and trial decisions. And then we talk about what happens to filing a formal charges. Let's just go through the bill here. All right, so we start off basically from what the actual commission is made up of. Like lines 21 talks about the 8 members of the commission, and we go through, it's divided into 5-member investigative panel, which I said what they're responsible for, and that's below that. Hearing panel is starts at line 33. Adjudicate formal charges filed by the investigative panel. They issue disciplinary and incapacity orders and formal advisory opinions, as well as the standards. Then we go to line 49. This is where we talk about prosecuting attorneys counsel, PAC, may recommend to the respective appointing authorities a list of names of individuals for consideration to serve as the attorney commission members. So we want PAC's involvement, and that's where we get that from. 52 talks about the investigative panel, and this is how they are appointed. It's one attorney with prosecutorial experience as an elected district attorney. That's by the governor. One attorney with prosecutorial experience by the lieutenant governor. 2 practicing attorneys by the Speaker of the House. And then 1 former district attorney or former solicitor general by the Senate Committee on Assignments. That's line 69. And then they elect their own chairperson and vice chairperson, line 73. Then we go to the hearing panel. That's line 75. 1 citizen member by the governor. 1 district attorney, that's 79, appointed by the Senate Committee on Assignments. And then 1 former judge of Superior Court, Court of Appeals, or Supreme Court. That's line 83, and that's by the Speaker of the House. We then talk about whether commission members are eligible to serve, that they got to be a citizen, an attorney, and how to deal with vacancies. Additionally, we have in here line 100, just that they have to, the governor's appointees have to be confirmed by the Senate. And then we talk about lines 112, members of the staff shall not engage in ex parte communications. So this is just talking about what they can do while they're on the commission itself. 131, we talk about a quorum. The investigative panel is 3 members, so 3 of the 5 have to be there. And then, how they get paid for expenses and things like that. That goes through line 144. And then line 145, I think is a good one. The commission, with assistance of Prosecuting Attorneys Council, State of Georgia, shall promulgate the standards of conduct and rules for the commission. And along with the subsections I and J, those are pretty important. We'll get to those in 1 second. And they should be effective only upon review of the Supreme Court. And we also recognize that there are bar rules. So line 153, any standards of conduct adopted shall be an aid of the judiciary in performance of the functions and shall function jointly with the Georgia rules of professional conduct of the State of Bar of Georgia. Standards shall include the list of actions that will be grounds for discipline of a district attorney or solicitor general, or for his or her removal or involuntary retirement from office. So that's where we recognize the bar. As well as Rule 3.8 there. This is a pretty important one. This is the grounds for discipline. So this is basically what we're holding district attorney and solicitor generals accountable for. Number 1, mental and physical incapacity interfering with the performance of his or her duties, which is likely to become permanent. This is really just restating law today. I think it's 15 Section B. This is if you have a stroke or an accident or something, or you're in a coma and you can't perform your duties. Line 163, number 2, willful misconduct in office. I'd argue that this is really kind of seen across Georgia. Paul Howard, I think, was a great example in Fulton County. And, after the Paul Howard incident, former Representative Bodie dropped a bill related to Oversight Commission for district attorneys and solicitors. I think this would also be like misuse of civil asset funds, things like that. Line 164, Part 3, willful and persistent failure to perform his or her duties as provided by Code Section 1518.6 and 1518.66. Those reference code sections were requested by district attorneys, and they ask us to include those. And basically, that is the duties of a prosecutor, the code section, and also the duties of a solicitor general code section there. So willful and persistent failure to not do their duties as defined in code. Line 166, number 4, conviction of a crime involving moral turpitude. This is already in code. Line 167, number 5, conduct prejudicial to the administration of justice, which brings the office into disrepute. I'd argue that that's similar to my situation in Paulding County, which is really the reason I brought this bill. We had a district attorney who's not our current district attorney who sexually harassed repeatedly someone from his office, so much so that the community was really torn up over even the things that he did well. People didn't trust, and so when you don't have a prosecutor doing right things, and the community believes that the office is not respectable or respected, then justice is really not served, even when justice is served. Number 6, intentionally instructing, authorizing, permitting an assistant district attorney, solicitor general, or assistant solicitor general, or any other staff to commit any act involving grounds for removal. So this is basically, I'd argue that DAs should be aware of the conduct of their attorneys and staff. And we had that's different language than was last year. I think last year we had like knowingly and permitting. We also didn't have staff. We just had ADAs and assistant solicitor generals. But talking to the district attorneys, we changed that wording to intentionally instructing, authorizing, or permitting. And they also asked me to include staff on there, which I did. Line 172. This is, again, recognizing the bar, violation of the rules, professional conduct of the state bar, including but not limited to Rule 3.8. And then line 175, any complaint filed with the commission alleging a violation of subsection I, which is those items I just covered, and requesting investigation, that's you get a sworn affidavit, and that sworn affidavit is where you have personal knowledge of the facts. So we're trying to limit just the people just trying to cause, baseless complaints. That's what that section is doing. 183 is the commission might not, this is the restrictions on what people can complain about. We're not just allowing them to complain about anything. One, we have these items in section I that is the basis for complaints. And you also, in section 183, line 183, we're talking about what you cannot complain about. You can't complain about charging decisions, plea offers, continuances, trial calendars, unless you can prove that the solicitor general or district attorney that it was likely. So we had plausible last year. We moved it to likely that they knowingly authorized a decision, and it was based on the items 188, undue bias, 189, undisclosed financial interest, 190, an undisclosed conflict of interest. And we also include what a conflict of interest is for a district attorney. I think that was kind of open, a little too broad. So we said where a district attorney or solicitor general are related. Any party interested in the result of a case or matter with a third degree as computed according to civil law. So that's similar to like a grand jury, how you would dismiss a grand jury. That's kind of where we got that language from. How a grand jurist would be have a conflict. D, factors that are completely unrelated to the duties of prosecution. E, a state of policy that's written or otherwise, which demonstrates that a district attorney, solicitor general, categorically refuses to prosecute any offenses which he or she is required to prosecute by law. So that is the items that we did remove one there. We had another one. I can't even remember what it was at the moment, but I'll get that for someone if they ask me that when they have a question. That the district attorneys asked us to, or asked me to remove, and I did do that. It was willful misconduct in office. So we did remove that. That was not one anymore. And then we talk about line 198, keeping things confidential. And so these things aren't just out there, but the reports are filed with Supreme Court. And then that's really it. It was talk about it being open records. The matters after things are resolved, for things that can be open records and things that are just passed along, nothing happened to them, or it was an invalid or non-valid complaint. Those are not part of subject open records. I think that's primarily the gist of it. I will say that we did change also, just one other thing. We changed the dates on this because it's a new year. And additionally, we talked about everything now. So like on 246, it says the hearing panel's order in a disciplinary incapacity matter shall be reviewed by the Supreme Court in accordance with its rules and the rules of the commission. So we're requiring the Supreme Court to actually review all of these. I think last year we had may in there. We did move that to a shall, just for making sure that we're covering our bases from a legal standpoint. Happy to entertain any questions, Mr. Chairman.
Thank you, Representative Gullo. I think we've got a question on 16. Is that Chairman? Chairman Smith?
Thank you, Mr. Chairman. Thank you, Representative Gullett, my friend from Paulding County. Glad to be in y'all's delegation. A couple of questions, if you'll indulge me for a few moments here.
I'll give it a go. Sure.
Every one of those district attorneys you mentioned, they're now out of office, correct?
No, I would say not. That's not the case. So I mentioned Paul Howard. I mentioned Dick Donovan. So those two I did mention are out of office. There were others since I even did this bill 2 years ago that they're still under investigation and accused of wrongdoings. So the two I mentioned are out of office, yes, but that's not the totality of the problems.
District attorney in Glenn County is out of office recently, correct?
I'll trust you if you say so. I believe so.
All right. So, sounds like a lot of these DAs that there were issues with, they were either voted out of office or didn't seek re-election, correct?
Some of them, that's the case. I would say that's not the case for as you're in our delegation in Paulding County. He is out of office, but he wasn't. His term expired, and he didn't run for re-election. But he did get paid for a number of years. For that.
Okay, thank you. Let me ask you this. Have articles of impeachment been filed against any of those district attorneys we just discussed?
Yeah, I don't believe so, no.
You know why that is?
Well, one, I would say because when we're in session for 40 days, an article of impeachment is very similar if you went through the process as it is in D.C. So, one, I think that the word impeachment means something different than it used to mean. Impeachment has been overly abused, and I think in D.C. and I think it makes it something that it shouldn't be. It's kind of numbed down what an impeachment is, and it's made it a hyper political thing versus a right versus wrong thing. Additionally, because there's a trial in the House, or there's evidence that's presented in the House, and there's a trial in the Senate, that's a number of legislative days. I think 7 as a minimum if things just flew by. And so I would argue that most people, that the body of the House wouldn't be willing to give up 7 of the 40 days to do it. Just in general, it's been talked about. I know it's been talked about. It was in Paulding County. It was talked about. I know it's been talked about in other districts, but the reality of an impeachment is different than talking about it and having that opportunity.
When's the last time we had an impeachment trial in the House?
No, I have no idea.
I knew one of the gentlemen on this committee had a little bit of a...
I might be off by a year, but I'm pretty close.
Okay, let me ask you this. How much legislative business did we take up the first 7 days of the legislative session this year?
Yeah, very little.
Okay. So under this bill, we are taking legislative authority and giving it to an unelected body.
I wouldn't say it's legislative authority. I would say if you're talking about an impeachment, but the Constitution of Georgia gives us the ability to regulate district attorneys by state law. So I would say we're not giving up that. We're actually executing our abilities.
Okay, so we still retain impeachment power.
We do.
Do you think we'll ever exercise that impeachment power once we do this, creating a new board?
I would hope we wouldn't have to, but I have no idea. I mean, impeachment, again, means something different now than I think it did, say, 20 years ago. I'm sure it definitely means something different than it meant in 1967. So I have no idea what the future holds, but right now I think it's just it's more of a word now than an action.
Would that not lend credit to the liberal thought in law that the Constitution is ever evolving and that words take on different meaning as we progress as a society, though?
You're the lawyer. I'm not. I don't know. It's a good. That's a good philosophy question.
Thank you.
Sure.
Thank you, Mr. Chairman. I gather from the way in which you phrased the sort of doctrine of evolving law, you may not really think that much of it, so I appreciate your comment. I think, is Representative Kendrick, you have a question? Yeah.
Thank you, Mr. Chair. I have 2 questions. So on line 87 and 248, the commission is starting in October, and then the members are going to be appointed in December. Is there a reason for a 2-month that the commission is starting before the members are?
87. I don't know. Could be an oversight of changing the dates when we change the dates. Where do you see the October one? That's further down back, right? Looking
October
back.
is line 248,
Yeah.
and then members are going to be appointed in December. So this line 87.
Yeah. That probably is an oversight of fixing the bill. So that's probably a good catch.
Okay.
That should probably move back three months. I guess October 1st.
Okay, and then my second question is, so there's currently 2 articles in the Georgia Constitution and about 6 statutes that currently cover the behavior and hold DAs accountable for their conduct. So could you tell why this bill isn't covered by 2 constitutional amendments, 2 constitutional articles and 6 statutes that we already have in law?
Yeah. So I'm taking you're probably reading from the district attorney's their letter. So I can't because I'm not that familiar with it, and I didn't go into detail on that. But what I'll tell you is what is happening today is not working. There are communities that the justice system is not working in their communities, and it's a really as gone through a community that's had that happen. That is a difficult thing to manage. As far as there's a lot of talk about Rule 3.8, but Rule 3.8 does not cover what people say that it covers from the bar. So the bar doesn't. I'm not sure when the last time the bar has removed a district attorney from practicing law. I don't even know the last time they removed someone who was elected. So I don't know that that's working. But no, I can't speak to that. I would say that the Constitution does give us the ability to regulate district attorneys by general law, though, and that's what we're doing here. Other laws may be doing the same.
Any follow-up, Representative Kendrick? Okay, thank you. Representative Reeves.
One tidbit from Georgia history, Judge Griffin Bell was the post-Watergate Attorney General and helped, restore trust and integrity in the Department of Justice after Watergate. And, weaponized prosecution, that's scary, and it's just not something to have in Georgia. Most of our DAs do a good job, but, since the last session, the Columbus DA got removed for bribery, corruption office, and other problems. How has this bill since last year, if at all, addressed that situation that happened in Columbus, and how would this bill do anything differently than what removed him from office, that procedure? Because, he was in office for a year or more before he got removed, but how could this bill tighten things up and have people like that in office shorter?
Yeah, so conviction of a crime of moral turpitude. So this would allow them to remove him also after he was convicted. I don't know if he was convicted or not. I think that's what you said he was. Number 2 is willful misconduct in office. I think that would fall into place. And so before it taking a year, I think this panel here could adjudicate that process faster, where Columbus isn't not having a district attorney who's causing the problems he's having for a year in Columbus. It could have been handled quicker.
Does that handle your concern, Representative? All right. Representative Saints. Chairman Saints, I'm sorry.
Thank you, Mr. Chairman. Representative Gaullett, is it not true that the circuit that I represent, the Brunswick Judicial Circuit, currently has a former district attorney that the Attorney General indicted for violation of oath of office, and no action has been taken on that matter after that event? So this commission would address the ability to more quickly resolve issues of violation. And though the voters and the best way to look at an oath of office violation is our elections, but this would give an added and possibly quicker resolution to those being governed under circuits that face these kinds of issues.
Yes, I 100% agree with you.
Thank you.
Thank you.
Thank you. I believe back to Chairman Smith.
Thank you, Mr. Chairman. Representative Gull, I'm sorry I didn't ask you this question before. Actually may have a couple for you. As far as the impeachment process, that would be open to the public to see all that the House and the Senate would do. House as far as our side of it and the Senate doing their actually trying them. Is that correct?
As far as I know, yes.
And under this process, it puts it under seal and would not be open to the public, correct?
That's correct until it's resolved, adjudicated. What we don't want, basically what's not open records is the false complaints. So anyone complaining about things that aren't true, that's would not be. But once the things are adjudicated and final, then it would be.
So we're going from an open process to a closed process.
We're going from both because the impeachment's still there.
Thank you, Mr. Chairman. Representative Kendrick?
Thank you, Mr. Chair. So I'm trying to clarify who has the authority as it stands right now to remove Attorney General. So, excuse me, DAs. So correct me if I'm wrong. So we have the state Attorney General that can remove district.
No. An Attorney General can't remove a district attorney.
Was made a charge.
Oh, okay. Okay. So we have the State Bar of Georgia,
Supposedly, yep.
the
Never happened as far as I know.
the legislature,
No, we cannot. We can, well, through impeachment.
Right.
Okay, sure.
and then the voters.
Well, sure, yep.
And so this is adding, I guess you said a 6-person,
Eight-person panel.
eight-person panel.
Right.
So out of all those people that I named, did I miss anybody else who can currently remove district attorneys from office?
I don't know. I'm not sure if the Supreme Court could or not, but I'm not sure.
Thank you.
Sure.
Representative Neal?
Yes, sir. Thank you, Mr. Chairman. So I guess, this isn't really my space, but I definitely have to make sure I get all the questions out for the people I do represent. So from what I'm gathering from the testimony, everything I've read, been emailed. So I guess the first question is necessity. To the point that some of our members have made, I'm trying to understand the necessity of the bill, considering everything that was mentioned as far as other DAs who've had issues, who've either been taken out of office by election, and even some of the other ones I've been checking on while everyone was talking. So Mark Jones out of Columbus was disbarred. Dick Donovan was convicted out of Paulding County. Jackie Johnson is under indictment. And the citizens are doing their job. If they're displeased, they've been getting them out of office. So when it comes to these different departments being kind of strapped for resources and funding, giving right to legislative authority, and just the things that we already have in place now, I guess my biggest thing is the necessity. The question is the necessity of this. Because if we have certain things in place already, and to the point of the chairman across from me, if he's going where I think he was alluding to, if people aren't using some of the appropriate measures that are in place to remove people, I guess I'm trying to see the true benefit of this particular bill.
Sure. So, remember, let me ask you a question back, and then I'm going to try to answer your questions. When you pass a law here, do you expect the laws to be executed?
Yes, of course.
So if district attorneys and solicitor generals out there are deciding to not prosecute laws that you've passed, are you okay with that? Blanketly?
I think it depends on what discretion they're given. As far
Okay,
as
so
what we
I'm
give-
and so political and prosecutorial discretion, I think, is a huge going to be probably a conversation amongst a lot of people here. What we've tried to do, and what I think that we have done, they're going to say this affects my prosecutorial discretion. It does. Prosecutorial discretion is to say, hey, legislature, you did this bill, the governor signed it, this law. We're not going to prosecute any of those cases ever. Not going to look at it case by case basis, and you can look at it by case basis, and you can say, yep, this case does not have evidence. This case does not have evidence. I can't convict this one. That's allowed. In this bill, this is allowed. What you can't do is you can't say, every super speeder, I'm not going to prosecute those today. If you super speed in my area, I'm not going to prosecute you. If you deal cocaine, I'm not going to prosecute you. That's going on in the state of Georgia today. And I think if you're one of these communities who is facing that, there is a need for what we're doing, because what we've done so far has not worked. It's been insufficient at the end of the day, and this is just drawing attention to that. There's other things, willful misconduct. The only reason my district attorney got caught up was he didn't get removed from office for what he did. He got removed from office because he lied about what he did when they were questioning about what he did. It's not for what he did. It's for lying about it and covering it up. That's a problem for me. This person, it cost our county hundreds of thousands of dollars in lawsuits and for what he did. The community no longer believed in the court system, no longer believed in the district attorney's office. And it's caused a lot of grief for not only is that person removed, but they've caused damage that the next district attorney or solicitor general has to resolve. It's going through in Paulding County. There's people who they lost trust in the system, and that's one of the worst things that can happen if people don't believe justice is served. That's one of our founding principles as a government, and so they have to go and clean that up. Not only is it it takes a long time, but it took ours years to be removed, and it was because he lied about it. Then the whoever follows him up or follows her up has to deal with the problems that they've laid out there. So there is a need for it. What we have, the tools that we have at our disposal today just aren't sufficient, and that's why I'm doing this.
Okay. Mr. Chair, follow up and the question. So one thing I do want to make sure, that's the beautiful thing about the law. That's why I love this committee, is the fact that, and even to your point, the person in your district, they eventually got caught. And that's the beautiful thing about our processes here is you don't typically go too long or you eventually get caught. And whether it's through a process, it's through questioning, and then like you even referenced some of the other things like super speeder and things like that. When it comes to even law enforcement has discretion. So granted, we say, hey, you're supposed to get arrested for this, that, and the other, but you know what? On this day, you're going to get a warning. And so I feel like in so many facets of law, or the practice of it, no matter if you're an officer, an attorney, a judge, everybody's granted a level of discretion. And when it comes to this matter here, if there are a number of things in place, and when it just comes to less government and everything related to that, I just feel like this is just muddying the waters, and there's a question of affordability. I just want to, I know you referenced some of the political issues that were related to some of the other DA issues. But based on everything that's been testified today, as far as the questioning is, all those DAs were either disbarred or removed, or
but they're not. There's still some right now that are being investigated on right today.
Right, but the thing is, the process is working, and a lot of times this is a process.
I would argue that it's not working. There are district attorneys today who are not executing their duties and enforcing the laws that we have written. And through blanket statements, like on day one, say I'm not going to prosecute this. That is not prosecutorial discretion, and so that's not working. They're still there today. That is wrong in my eyes, and that is one of the things that we're addressing in this. So some things get worked out over an extended period of time, and I think that's great. But in that interim of the time, there are severe problems. Additionally, there are things that are not being worked out today. There are still district attorneys, solicitor generals who are not going to prosecute cases on both sides. This is not a political thing. We have a lot of bad Republican, but not a lot. Most district attorney solicitors are good. The ones that are bad cross both sides of the aisle. It's Democrat and Republican. This is not a partisan thing. So much so that Democrat, I'm not sure what he was, minority chairman maybe or whip, I guess, Bodie, dropped a bill. I talked to Beth Moore about the issues I'd have in Paulding. We talked about an oversight commission. When it was convenient for him to drop a bill related to what was going on with
Auburn.
Yeah, but Fulton County, he drops a bill for an oversight commission.
Oh, okay.
And so this is not a partisan thing. This is it really is a bipartisan thing of issues that we have in a way to solve it, to come together to solve it, because this is in our ability to do.
Okay,
So.
I just want to err on the side of caution of us in this room here through this type of legislation getting involved in that side if there are other mechanisms in place. So.
Appreciate that. Thanks.
Thank you, Representative Neal. Chairman Smith.
Thank you, Mr. Chairman. Representative Gullett, a few questions here. Would you be open to us having legislative council pull the records on the 1967 impeachment proceeding here?
You're the chairman, man. If you want to do that, I'm perfectly.
I want to know if you're open to it.
Sure, I don't care.
And,
Yep.
if we share all that information with all the members of the committee, be
Sure.
interested in seeing what that process was like. Follow-up question, probably gonna have several. Since we created, I say we, I wasn't here, but since we've created the equivalent for judges in our state with a commission to oversee their discipline, or the disciplining thereof, how many judges have been impeached by this House or have been attempted to be impeached?
I do not know either. I would say 0, but I don't know.
Okay. You're familiar with Cincinnatus from ancient Rome, correct?
No.
Okay. Mr. Chairman, indulge me real quick. Cincinnatus.
I'm now curious, Mr. Chairman.
Cincinnatus was the reluctant protector of Rome. He had been a soldier and had fought many battles for the Roman Empire. And if I'm not mistaken, I want to say that he preferred to go back to his home, which was, of all things, a farm, finding solace there. But reluctantly, he was the protector of Rome. And although being a reluctant leader, we saw subsequently with Caesar's coming to power that they abused such protector of Rome status. So my question is, as long as we have somebody that is good at the heads of the House and the Senate and the governor's office, we can rest easy that good folks will be appointed to this commission. But are you not concerned with this commission one day being weaponized if less than noble and admirable individuals are appointed to this commission?
I don't want anything to be weaponized by either side in the future or now. I don't believe that it will be, though. I believe that we have really structured what the rules and regs are, what the things that apply are. And at the end of the day, if whatever side, this is just a law, and if it's weaponized or if it's not weaponized, the law can be changed in the future to be weaponized. So I'm not really worried about that, because if we don't do it now, the citizens and communities are going to hurt now. And if something changes in the future, the legislatures of that future can change it back whether we do this or not. And so the law can be weaponized, I guess, in general. So it doesn't matter whether this is there or not, in my mind.
Okay. You made a comment earlier I'm curious about. You were talking about our measures being insufficient.
Yeah.
How are they insufficient if we haven't even attempted to use the powers we have granted to us under the Constitution?
Well, this is a power granted to us in the Constitution to regulate by general law. So I think we are using the powers in the Constitution to do this right now. This is what I'm doing. District attorneys can be I'm not sure regulated is the right word, but we can oversee district attorneys by general law.
But
and so
have we not legislatively been negligent in exercising the power that's given to us by the Constitution?
Sure, but this is a power given to us by the Constitution. So do I wish we had, did I talk about impeachment for my former district attorney? I did. Is it a reality to do? It's not. And I'm exercising my other power by the Constitution by doing this.
Okay. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Chairman Saines?
Representative, thank you, Mr. Chairman. In terms of us using the very limited history of our impeachment, are we bound? I'm assuming that we could be called into a special session, but the practicality of it is we would be bound by a very limited 3 months out of the year to call that an impeachment. Would that not be true?
Yeah, so I have a special session. It's within the 40 days, and in talking to leadership during my time period, it's not a reality.
and this council would not have that similar restriction to ensure that the citizens of Georgia had able top law enforcement officials in their circuit.
That's right.
Thank you.
Thank you. Representative Reeves.
Representative Gullett, in the time you've been working on the bill, do you know if anybody has pursued a constitutional amendment to make district attorneys nonpartisan throughout the state? Seems like a lot of these people who are getting elected, causing problems, are getting elected in a contested primary where they've sort of played to a certain audience and don't have the accountability that a nonpartisan race where everybody in the county would get to vote on them would bring.
Yeah, that's correct. And yes, I co-signed a bill this year to do that exact same thing, to make district attorneys, solicitor generals nonpartisan. Thank you for the question. One other thing, man, can I add? I know district attorneys and solicitors, I'm sure, will testify. I did receive a letter. I'm not sure. Hopefully, the members of this committee did too. Just from 21 district attorneys across the state who support oversight. And I've worked really hard to try to make sure that concerns from district attorneys, I'm not going to. There's some who are just principally opposed to it, and I can't make them like the bill or get on board. But 21 do support it. I would argue that the association themselves, they're going to tell you they voted to oppose it, but my argument, I think, would be that they haven't voted in a long time to oppose it. Because when they opposed it was last year when I had 2.5 district attorneys who supported it. And a half was because, supported it but wouldn't come on record. This year I have 21 who support it. There's 49. There's a number of district attorneys who haven't stated where they're at. And the reason that this is Joseph talking, not, I believe that they haven't voted on it is because they don't have a majority anymore on the association. So they're going to say associations, your majority is going to vote against it. But they haven't taken a vote in a year and a half. And so because if they take a vote, they're not going to be a majority against it is my feeling. And so, that's they'll talk to it. But there's 21 district attorneys who support it today. Should be more after we made some changes in the substitute, I would think. But again, this is something I feel like we have to do. I think there's something that the members who have signed this bill believe that we have to do. There are other means like impeachment and things. Those just aren't reality. And what's happening today is communities are being torn apart. The signers on my bill and the signers on Chairman Gaines's bill are communities that are struggling with their district attorneys. This is, again, not a partisan issue. It was only Republicans who signed onto the bill, but last year in the vote, we had, I think, 6 or 7 Democrats also vote for the measure. It is not a partisan issue, and that's something that I do want to put out there also.
Chairman Smith.
Thank you, Mr. Chairman. If our communities are struggling with their state house representative, they can get rid of us at election, correct?
Yes, every 2 years. That's right.
Okay. District attorney's on a 4-year term, correct?
Yes.
So if this is a political problem, in which we've seen evidence within the last several years that this political problem has been solved by those people that are suffering in these areas, correct?
I would say that's not correct all the time for everything. People blanket not prosecuting bills hasn't been solved in areas, and that's usurping our power as legislators. Some issues have been resolved there. Some issues haven't. And I'm sure there's some issues we don't know about yet. To say that, blanketly they've been resolved I don't think is true.
So Columbus has removed their political problem because they had consternation over that DA. Glenn County has, and Paulding County's situation, Lyon took care of his situation as well, correct?
As far as I know, that's right. Yeah, for those 3.
So it would
but there's others.
So it seems like there is evidence that if a DA is not getting the job done, that crime is rampant and criminals are being released without being held accountable, that the political solution seems to have been found at the ballot box.
So I would say that's not true. My district attorney, his issue was not found at the ballot box. His issue was found differently, and it wasn't even about the issue that he did. Sexually harassing a worker to the point where he's putting things in the newspaper. He's making deals with other district attorneys when she got in trouble. And then the only reason he was brought to justice wasn't because of all those things, which I think are really bad. It's because he thought he was the smartest person in the room and wrote a 100-page deposition where he lied and didn't know she recorded some of the conversations. And so that was handled, but it tore the county you represent apart. And I think the current district attorney there who stuck with it, and thank God he did, in Paulding County, he supports this measure. I think all the district attorneys that you represent support this measure, or support oversight. Maybe this measure is broad, but support oversight. And I don't think it's always handled. There's people who are, I don't want to call it cases, but there are cases today that I think there are accusations that hopefully get handled, but I'm sure there's accusations of things we don't know today. These are just ones we're talking about because we know them. There are issues that could be going on we don't know about.
Right. That's interesting you bring up my district attorneys. Did you know that none of them have reached out to me in support of this bill?
Well, I think that they sent you this letter. I hope that they sent you this letter.
Would the gentleman know that they do reach out to me on several bills in our committee? I actually owe one a call here in a little bit on a bill I'm supposed to have heard today. I hadn't forgot about you, Jack, if you're listening. But I have not heard from them on this legislation, so just wanted to see if you knew that or not.
I did not know.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Any other questions for the author? All right, I think we'll proceed with hearing from some of the witnesses who wish to testify to the bill. First witness we have is James Woodall with the Southern Center. Just be sure to pull one of those mics in close to you. There you go.
Thank you, Mr. Chairman, to the members of the committee. First, let me thank the sponsor of this legislation for bringing it. I want to name that, Mr. Chairman, your impetus for bringing this is well received. There are communities that are struggling to understand what's happening when it comes to the harm of what some prosecutors are doing. But I really want to approach this from a different perspective, because I think one, the methods of prosecutorial oversight that are currently provided for in Georgia's Constitution and the official code of Georgia are sufficient ways that can be done. Now, the question of whether or not individuals use those measures, that's a totally different question. But the members that signed on to the letter that you referenced, the 21 or so prosecutors, there are actions that would not be covered under the bill that you bring forth, that some of those prosecutors, quite frankly, have conducted and caused harm in their communities. And so insofar as saying we have an issue with prosecutorial oversight, I don't think that's the right question. I think it's an improper frame. Secondly, I want to also raise a few examples of how this has been done in other states. One, in particular, the state of New York, there are two cases that I want to lift that the legislature there wanted to provide oversight via a more similar mechanism. And one is the case Soares v. State, in which the Supreme Court of New York said that its statute did not impermissibly interfere with the DA's constitutional authority to determine whether, how, and to whom to prosecute, but that it did violate constitutional grant of exclusive jurisdiction over attorney discipline to the Supreme Court. Secondly, the Supreme Court of New York held in Staten Island branch of the NAACP versus the State of New York Grievance Committee for the 2nd, 11th, and 13th Judicial Circuits. In matters of first impression, the committee lacked the jurisdiction over the complaint involving discretionary acts of the prosecutor to bring forth an indictment against police officer Daniel Pantaleo, who was accused of causing the death of Eric Garner. The reason why I bring those two cases up very specifically is because, as I've personally been engaged in these issues related to police brutality or prosecutor misconduct, you mentioned Representative Sainz, Jackie Johnson. We were very engaged then when I was state president of NAACP. And we very much so believe that we have issues related to, actions taken, not just with the prosecutor, but just courts in general. We have a case in Statesboro where a young lady who was a domestic violence victim was literally sentenced to prison for killing her abuser. that's an action a prosecutor took that currently under the law should not have happened. But under this bill, she would not be held to be responsible for sending someone to prison for defending themselves. And so I would rather have 100 people who should be prosecuted but aren't prosecuted than to send one person who should not be in prison and send them to prison for the rest of, at least for a long period of time. And so I wanted to lift that because it is important that we were not just talk about the political realities of what's happening, but also the real impact of the lives of the citizens of Georgia. The last thing I'll say is that at the Southern Center, we want to find ways to reduce the harm that's being committed. But I would urge the sponsor to submit a bill or an article of impeachment. You have the ability to do that. And if you think there's probable cause to suspect there's misconduct happening, we would recommend you do that as opposed to this bill, which one would be in violation in our estimation of the separation of powers clause of Georgia's Constitution and the equal protection clause of the 14th Amendment, because district attorneys and solicitors are not the only prosecutor in the state of Georgia. And under this law, those other prosecutors wouldn't be having or be subjected to that same oversight, if that makes sense. So with that, I'll yield, but I will have our memo shared with you, and we would love to talk further about this issue. Thank you, Mr. Chairman.
Thank you, Mr. Woodall. I think we have a question from, is that Representative Fleming?
Okay.
Thank you, Mr. Woodall, for being here today. You said this violates the Georgia Constitution. This is Article 6, Section 8, Paragraph 2 of the Georgia Constitution. It's entitled Discipline, Removal, and Involuntary Retirement of District Attorneys. And here's what it says. Any district attorney may be disciplined, removed, or involuntarily retired as provided by general law. Now, we're the legislature and we make general law, so how is this law violative of the Georgia Constitution?
Thank you for that question, Mr. Chairman. Well, one could argue, and obviously it would ultimately be up to to the Supreme Court to decide this matter. One could make the argument that the Supreme Court and not the General Assembly has final disciplinary authority on all prosecutors and all attorneys in general as provided by state law. Now, in comparison to what the Judicial Qualifications Commission is able to do per general law, again, even in the case of JQC, which is a totally separate entity or a totally different body that's constructed via statute, but the final authority does not rest with the General Assembly; it rests with the Supreme Court of Georgia. And so, therefore, if the General Assembly, let me actually correct that. The General Assembly has the ability to detail who's on the commission, how the commission is composed, which under this legislation it would be similar, but the difference would be the General Assembly would have the final say-so. And so if the General Assembly, per the Georgia Constitution, already has impeachment power, we already have statutes, I think it was about 4 or 5 statutes that provide ways in which a attorney general can prosecute this case under Georgia's code, and then ultimately the ability for voters to be able to submit a recall election. Those are methods that's already provided in Georgia's statutory, within Georgia's code, in addition to what's already in practice. And so hopefully that answers, it's going to be an argument, and it's one that people are making. But the question is, because this is not an area of law and I did the research, I have not seen not one case brought before the Georgia Supreme Court that wrestles with this question. And that's why we referenced the cases in New York, because that same question came up there. Of course, their constitution is a little bit different, but the court did rule in those cases that it did violate that constitutional authority.
I've seen you testify down here a lot, and you do a good job, and you're usually well prepared. And so if I didn't know you and I didn't know that, I would accuse you of being disingenuous today. I know you're not. There has never been a constitutional provision more clear than what I just read to you. The General Assembly clearly has the power to remove, and we can even do something, I don't know what it is, involuntarily retire. I'm not sure how you involuntarily retire somebody, but we can do that and remove them by passage of general law. So I hear what you're saying, but there's never been a constitutional provision clearer than the one I just read to you.
Well, I appreciate that, Mr. Chairman. I think we can maybe disagree a little bit on that front, but I do respect the gentleman for raising that point.
Thank you.
Thank you, Mr. Chairman. I guess voluntarily retired is when you're voluntold to do something. Maybe it's a similar kind of process. All right. Any other questions for this witness? Thank you. All right. Thank you so much, Mr. Will. Is Representative Gaines still there? Yes. Representative Gaines, why don't you come forward?
Well, thank you, Mr. Chairman. I first want to thank Representative Gullett for his hard work on this bill, and I'll be really brief. I know that there's a lot of people who want to speak on it, but I do want to just highlight a couple things because this has been the number one issue in my community in the Western Judicial Circuit, where you have a district attorney who is just completely shown a lack of ability to do her job. And it's been a real problem when you have a DA's office that only now has 3 assistant district attorneys out of 17 full staff. You have somebody who's lost several homicide cases. Finally, she tried her first case personally. She's and lost that case. So we have several issues. I'll read a headline in the paper earlier this week. The case of an Athens man accused of shooting a person in the neck was recently dismissed because proper court procedure had not been followed. That's the second time this has happened on a speedy trial motion. So we've had issue after issue after issue. And to the question of impeachment, it requires a constitutional majority in the Senate, which the reality is to the point earlier, these are partisan offices. I would be surprised if you're able to get a constitutional majority on a partisan race when neither party has a constitutional majority in the Senate. So I don't believe that is a realistic path forward to remove DAs who are not doing their job. There was also the point brought up about state representatives. Well, state representatives have, anything that we pass also can be vetoed by the governor. Even a city council person, if they pass something, the mayor is typically involved. This is one office, and I've been thinking through other offices where there's just zero oversight, and there is none for our district attorneys, and that has created chaos in my community, and it's become a challenge where cases aren't being able to be processed properly. We have it. I'll give one final case here, just to outline the severity of the situation. Our district attorney's office lost a homicide case just over a year ago. Well, a year later, that individual, who actually the law enforcement agency had found the murder weapon on the individual, of course, innocent until proven guilty. But now this individual has been arrested again for murder and killed somebody else just up the road in Jackson County. And so there are real consequences for waiting till the next election. We can't afford to wait 2 more years in Athens to get a new district attorney because lives are at stake in our community. And so I'm so hopeful that we can get this bill through. And again, I just want to thank Representative Gullett for his leadership. And I want to thank the 21 DAs who've worked to gather support for common sense oversight to make sure that we are enforcing the law. And to Representative Gullett's point earlier, the job of the legislature is to write the law. The job of the district attorney and the solicitor is to enforce and prosecute the law. We have to preserve prosecutorial discretion. But when you have DAs who on day one, just like my DA on day one, put out a memo saying, here's the laws I'm simply not going to enforce, that is not the job of a district attorney. And right now there's nothing we can do about it. The state bar has shown no appetite to go after DAs who aren't doing their job. Impeachment, again, I don't believe is a realistic path forward. And so my hope is that we can get this bill passed and make sure that there is proper oversight for our DAs. Probably went on too long, but if you can't tell, I'm a little passionate about it.
No, Mr. Vice Chairman, that was I appreciate your comments. I think we have a question from Representative Fleming.
Thank you, Mr. Chairman. Representative, you talked about the case that was dismissed because of improper procedure, and looks like to me you read part of the headlines. But isn't it true this is a part that you didn't read about somebody who shot a man in the neck who got off on a technicality because the DA didn't know what they were doing, and here's the rest of the article. Clark County Superior Court Judge Lawton Stevens dismissed the case because the district attorney failed to bring it before a grand jury. Rather, the criminal case against a 38-year-old Smith had been initiated by filing what is called an accusation, which solely uses the DA's information about alleged crime to initiate a criminal prosecution. In accordance with court rules, cases involving serious felonies must go to a grand jury so the panel of citizens can decide whether there is sufficient evidence for the cases to proceed to trial. My suspicion is somewhere in the history of this state and this country, some DA didn't know that. But I've asked several DAs, have you ever heard of a DA in their office not understanding the difference between having to go to a grand jury on a felony or not? And so far, the answer is going to be no. My suspicion is in the room. Maybe somebody else remember it. But I'm sorry for you and your community that you have to put up with what you're dealing with over there. And I hope like heck this legislature, this House passes the same bill practically that we passed last year, except this year with even the support of so many district attorneys. And I appreciate
Amen.
you being here today.
Thank you.
Thank you, Representative Fleming. Any other questions for this witness? Oh, I think Representative Kendrick.
It might be a question for the author. I apologize, but you might know the answer to this question. It seems like one of the issues that you're trying to solve with the bill is the speed of getting to removing the DA. Could you help me and point to the lines where there is a guarantee in getting to what you're trying to get to faster? And that
So
might be a question for the author.
Sure, and I don't have the bill right in front of the latest version because I know there were changes on the dates of appointments and those sort of things. But I believe the commission would commence in early next year, which that would be the time where someone could file a complaint and the commission could take action at that time. So it would be in early 2024. Which again would save a year at least until our district attorney was hopefully removed from office in an election cycle. Again, we can't wait a year when you have someone who was murdered because of her and her office's incompetence. You can't wait a year, and so that's this legislation would hopefully speed up at least a year. I do have a separate measure, House Bill 229. That hopefully we may hear at some point that also would address recalls of DAs to make sure that there may even be an earlier opportunity. But we have to address this issue because communities cannot wait for these DAs who aren't doing their jobs to be removed from office.
Can I ask a follow-up question? Because I'm still not getting the answer. So I understand when the commission is going to be appointed and the members, but I'm saying if the purpose of your bill, as I understand it from the what you have said, is to speed up the process of removing the DA, where in the bill is it accomplishing what it seems like your objective is to speed up that process?
Sure.
Like, because there's no dates to say, within 10 days of a complaint, this is going to happen. Within 15 days, this is going to happen. So I'm trying to understand how your objective of this bill is being materialized in the bill, because I don't see it.
Sure. Well, and Representative Gullett may want to speak to this some, but certainly you want to leave the rules and regs to be promulgated by the commission, which that would be approved by the Supreme Court as written in the law. But it is not a guarantee, of course. You have to also have an investigation. We're not going to just because you don't like somebody, you can't remove them from office. There has to be proven incompetence under the guidelines that Representative Gullett has put in the legislation, which I think our case in the Western Judicial Circuit is pretty clear that this individual has failed on a number of items that would fall under this legislation. And my hope and my belief is that the commission will move swiftly to remove her from office, and any other DA that's not doing their job should be removed at that time.
Thank you.
Thank you, Representative Kendrick. Representative Neal.
Yes, sir. Thank you, Mr. Chairman. And well, maybe I can ask it to you. It might be more so for the author at the appropriate time. So I guess my first question is, and please pardon my ignorance on this, but why not just do the process? So whether it's articles, impeachment, you name it, regardless of how long we're down here for session, why not just do the process? Now, granted, almost all of the DAs that have been mentioned today have already been removed, either by the voters or some other means. Why not just do the process? Like,
would you vote for impeachment of our DA in the Western Judicial Circuit?
I'm not as familiar with that whole situation. I don't want to.
I mean, I don't. If you can help me find the votes in the state Senate to make sure that we have a constitutional majority, then be open to that conversation. But instead of, as Representative Gullett outlined, during the session, you have to actually take up legislative days full time for an impeachment process. That the reality is, in a partisan office, the votes are not there to have an impeachment process.
Well, for me, I know why I got into this seat. And if impeachment came up as a part of this process, I'll be here as long as you need me to, and I'll come back if you need me to. So I guess my question is, and you probably, I'm not sure how much of this you can answer. Why not just do the process? That's what it's here for. I guess that's my only question.
And again, it takes up time during our regular session, but Representative Gold, I think, maybe had some comments too.
Yeah, Representative Gold, let me pull you up here.
I would just say that this is part of the process. The Constitution gives us the ability to pass laws, and that's what we're doing here. So in my mind, this is part of the process in order to create this oversight. So my ability to pass this law, or to try to pass this law to create this oversight commission, is part of the process.
My apologies. Let me clarify. Why not do the processes we already have? Like some of the things you mentioned, just people have not done. They just have not filed articles or what have you. Like I think you said 1966, 1967, 1968.
Yeah, it could be 65.
Okay, in the 60s, in the 60s. If they're already there, I just don't understand why
So-
we're just not using what's there already. That's all my
Yeah.
only question.
When you talk to someone about doing it, and sure, I get what you're saying on
Yeah.
this. It's just not a reality. And so we can do it all day. It's just not a reality. And so that is, at least in my situation, it wasn't a reality, not because of the cause, but because of the reality of what it does to the legislative session. And when you're told not to do it, it's just it's a tool in our toolbox that sometimes you don't control. This is a tool in the toolbox. I think that is the right thing, and that tool in my toolbox is the Constitution gives me the ability to do this commission, and so I'm trying to do this commission.
Okay.
Thank you, Representative Neal. Representative Fleming.
Thank you, Mr. Chairman. Representative Kendricks, I believe, asked a very fair question, as she often does. About the time frame here and why do you think this will happen faster? I'm going to propose a scenario to me, and you can tell me if you disagree or not with me. We have something in the state called the JQC, the Judicial Qualifications Commission. It's been around a long time. Now, the Superior Court judges will say it to you publicly, but privately they will tell you the last call they want is from an investigator with the Judicial Qualifications Commission, because they know that there's a reason why they're calling and something's up. And I would suggest to you, if you did research on that functioning oversight board, which is very similar in my mind to what we're proposing here, you would see time and time again when the investigation begins, the judge resigns. And they do that because they don't want to go through the process and they know where it's going to end. Just the idea that you have an oversight board, I would suggest to the representative, will give you not only the ability to avoid problems, because nobody wants that investigator to call them when the process begins, but will also get you to the end of the process quicker, because they know that they're going to have to see the judge, and the judge is this panel. And every lawyer in this room knows a lot of cases get settled when it's time to go see the judge at the courthouse. That's why we get the term settling on the courthouse steps, and that's what this commission will do for us, I believe. Do you agree?
I would agree.
Thank you, Representative Fleming. Representative Reeves.
Vice Chairman Gaines, you may not know, but I'll put it out there. It looks like under Georgia law, at least still in part, the legislature has grounds to impeach judges. And despite that power to impeach judges, 1517 says if you take gifts from the railroad or phone companies as a judge, you can get impeached. That's still good law. There may be others, but you've got the JQC, which is an authorized body to investigate and remove judges, even if there is still concurrent jurisdiction for impeachment. So in the cases of these DAs who could be impeached, would this not give a tool to get them out of office quicker?
It would. It would.
Thanks.
Thank you, Representative Reeves. Any further questions for Vice Chairman Gaines?
Thank you, Mr. Chairman.
Thank you very much for your testimony. All right, let's see. All right. The next witness on the list here is Wright Barksdale. Thank you. No, it's just poor eye-ship. That's on my part.
My name's Wright Barksdale. It's a pleasure to be here this afternoon to speak to you. I am the district attorney for the Okmulgee Judicial Circuit. We're an 8-county circuit in the central part of the state. I am one of the 21 DAs out of 50 that signed on to a letter that hopefully all of you will get this week. But essentially, I want to give you some background. For the last 2 years, I've been opposed to the efforts, and the reason was we needed more time to iron out the wrinkles. And we did that starting in January. there was a group of DAs that met with Representative Gullett. He was receptive to some of our concerns and ultimately made several changes to the bill from last year. Even as recent as this week, there were changes made. So I ask everybody in the room, why would you be opposed to doing your job? Why would you be opposed or have a problem with somebody calling you to the mat if you commit a crime of moral turpitude? Why would you be opposed to somebody looking into decisions you made because you had a financial interest in the case? There's several things about this bill as we've looked over it over the past couple of years that concerned us. And for the 21 that signed this letter of support, our biggest was maintaining the ability to do a case-by-case review, prosecutorial discretion, which we believe is at the very core of what we are tasked to do. Follow the law, follow the evidence, and be able to make decisions on a case-by-case basis. I will tell you that if I gave you a fact pattern, there's 50 DAs, you may end up having 50 different answers on that particular case. It's important that we maintain that discretion, and I commend Representative Gullett for meeting with us, taking our phone calls, and making the necessary changes that we asked for. So before I leave, there's one other piece that we would like to have everyone consider, and that's going to be on page 4, and the lines may be a little different because I have yesterday's version, but it applies to the one former judge of the Superior Court, Court of Appeals, or former justice. I would ask that it say one former or current judge that has, in addition to being a current judge or former judge, in addition to that, has former experience as a district attorney or, Solicitor General. It is very, very important for the members of this commission that will be formed, hopefully, to have a firm understanding of what DAs and solicitors are faced with every day. With that, I'll just say I appreciate your time. We are all 50 of us, in my opinion, doing the very best job that we can. And I know that may be up for debate, but I'm very proud to be a member of the 50 DAs and happy to answer any questions you may have.
Thank you, District Attorney
Barksdale.
Just to clarify, the change you're requesting, it looks like you're talking about in lines 83 through 86 of our version, where it says the 3 members of the commission's hearing panel should be appointed as follows, and then there's A, B, and then C. It says one former judge of the Superior Court or Court of Appeals or former justice who shall have at least 10 years of service as a judge or justice shall be appointed by the Speaker of the House and shall serve a term of 4 years, and successors to such members shall serve terms of 4 years. Is that the provision you're
Yes,
referencing?
sir. Yes,
And
yes, sir.
what was the specific change you were proposing?
One former or current judge of the Superior Court or Court of Appeals or former justice, and I would ask that additional language be added to include that judge have former experience as a district attorney or solicitor general.
As an elected district attorney, or
Yes, as an elected district attorney or solicitor. I will tell you that I was a assistant district attorney for 8 years before being elected the district attorney. There is a big difference between being an ADA and the district attorney, or an assistant solicitor versus the solicitor.
So I assume you're fine with the language that he has 10 years, or he or she would have 10 years of service as a judge or justice, but you would add, and who shall also have some number of years of experience as a district attorney or solicitor general?
Yes.
Okay. All right. You've got a couple of questions. I believe Representative Fleming was the first one to hit this button.
Thank you, Mr. Chairman. Mr. DA, appreciate you being here today and appreciate you signing that letter with your 20 other colleagues. On that issue that you brought up, which is a fair question, this particular appointment is the one that the Speaker of the House makes. And I started thinking in my mind, okay, we got to have a retired judge basically with 10 years experience. That's probably not hard to find. Then we got to have one that's been an elected DA. I'm sure there's a dozen, maybe more around the state that fall into that category. I can think of my chief judge over in Augusta would fall into that category. There's a judge, Stephen is his first name. I'm drawing a blank on his last name down in your area, who was a DA and now he's a judge, but he's not retired yet. So what I'm wondering here is that not only do you have to find those two things together, but then you got to find someone willing to do it. And my question for you, I guess, would be this: would you be okay with if it said shall have at least 10 years of service as a judge or justice and some prosecutorial experience?
Well, what I wanted added at the beginning of that was current or former, meaning it could be an active judge on the Superior Court bench, Court of Appeals, Supreme Court, that has that 10 years experience, but also experience as the district attorney or a solicitor general.
And this is just another question along those lines. That would open it up a little more. I can see how it would.
Absolutely.
Can a Superior Court judge who is active serve in that role?
That's a good question.
Yeah. I mean, we got obviously the judicial branch and the legislative branch and executive branch, and there has to be some separations. I know I can't serve as a sitting judge while I'm a member of the legislature. I wonder if a sitting judge can serve on a panel that is appointed by probably on a panel. I don't know. I'm not sure.
The aim for us, the 21 that signed the letter, was to try to get as many people as we could that have prosecuting experience as the district attorney, experience as a solicitor general in their past, because it's a very unique position and oftentimes difficult to determine what is the right approach on a case-by-case basis.
And don't get me wrong, I think that's laudable, and that's why I like the bill as it's written, and I appreciate y'all signing on for it. I'm just trying to think of how big is that universe, and would we be making it slightly too small? But that's an open question.
I'm fine taking the 10 years experience out of it if we had to. I don't know if that would open it up to a larger group.
Well, 10 years is when you get your retirement. So that's why you got a good a group in that
Fair
area.
point.
Yeah.
Thank you, Chairman Fleming, for that lesson also, and rules that are all important to to all of us, very much so. Chairman Smith.
Thank you, Mr. Chairman. Good to see you again.
See you.
I was going to ask, you ever read any about President John Adams?
Very little.
You know his involvement in the Boston Massacre or the aftermath of it?
Not in great detail to speak to you about it today.
Okay. He actually defended the Redcoats that were accused in the Boston Massacre. He's a defense lawyer. One president. Would you vote for him today if he were running?
Probably not.
Yeah. That's fair. That's fair. Well, that leads me to my next question then. Under the current structure of this bill, and thank you, Representative Gullett, you could have someone here that used to be a defense lawyer.
That's correct.
And with what you're proposing, you could never have a defense lawyer on this, could you?
That's not true. There's a gentleman standing behind you that was a defense attorney for many years that's now the district attorney.
But you're excluding anybody that's not a prosecutor, so it's only prosecutors overseeing prosecutors, correct?
I think we would still have a diverse background of people, but I do think it's important to have people that know what this job entails as they're making decisions. But I believe also in this bill, if I read it correctly, there are citizen members on it as well.
Okay, let me ask you this, and if you're not familiar with it, that's fine.
Sure.
Everybody that's on the JQC, they're required to have been a former judge.
I've not spent much time looking at that. I've got 5 really good judges, and Hadn't really put much thought into the JQC.
I think Representative Fleming, Representative Reeves, and Chairman Leverett and Chairman Silcox, we would all agree
Smith,
with.
we'll be
I
sure
love
to
my
send the
judges.
video of this to your home circuit.
Anytime I can get brownie points, I'm
Okay.
trying hard.
Yeah, I'd just be interested. You know, we're asking about the composition here, and we're comparing it to the other one. So I was just curious, and I appreciate you indulging me. Thank you for taking time out of your busy schedule to be here.
We certainly appreciate everything y'all are doing.
Thank you, Chairman Smith. Representative Reeves.
I think on the JQC model, current judges do preside on those. Just from thinking of the Judge Coomer case recently, Judge McBurney, it seems like he gets called on for everything, but I know he was involved on hearing that. Would you be opposed to adopting whatever they're doing with the JQC, or do you think it's important to have a prosecutor?
I think what in our letter kind of outlines this. Judges, the law's there, and it acts as a guiding mechanism more so than some of the decisions we have to make. And what I mean is, and one of the lines that was removed from this bill was the language where somebody could file an affidavit and file a complaint against me because I pursued a case based on the case not having probable cause. I've got, I believe, 12 DAs in the room with us right now. Like I said earlier, you could give us all a fact pattern, and when we analyze it case by case, it's just very difficult. We're going to come down with what is there a crime, what should happen, what's the punishment, what's our resources, how do we tackle this? It's all going to vary. So I think it's very, very important because there's a gray area in part of what we do that is that discretion that we're so concerned about.
Thank you.
Thank you, Representative Reeves. Any further questions for this witness? I don't see any. Thank you very much for your
Thank
testimony.
you.
All right, we have, is it Jonathan Adams?
Yes.
You're not any relation to the John Adams that Representative Smith was.
I might vote for him, but I don't know that I'd see him at a family reunion.
Well, thank you for being here, and please proceed.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I am honored to be here, and I appreciate you taking the time to listen to us. And I appreciate the goals of this bill. I think that there are most district attorneys who are opposed to illegal, immoral, or unethical behavior, as I believe most in this room are. But I think that's the question, is we have to look at what is the goal of the bill. And I think the goal of the bill is to remove what we call bad DAs, those that are participating in the illegal, immoral, or unethical behaviors, and to prevent what we may be calling DA veto of legislation. And so when looking at the legislation, my question is does it meet that goal, or the goals that were presented in the bill? So the first question I want to tackle is the veto goal. Does it meet that veto goal? And perhaps it does. But what's the impact is the thing that I want us to look at. The second piece of it is the perhaps. To be quite honest, I can see a multitude of ways DAs could remove any written or stated policy and find a workaround to not prosecute cases. Our backlog is so big right now. I know of one circuit that had 70-something murders last year. If they tried a murder case a week, they would still have a backlog, and that doesn't count any of the other felonies that they have to prosecute, the burglaries, the thefts, the armed robberies, the aggravated assaults. So does a case that you don't like prosecuting sit to the side? If it's a misdemeanor, wait 2 years and we've passed the statute of limitations. Wait 4 and we've passed it on felonies. The second thing that I would say is when we talk about veto of enforcement of laws, You also have other agencies, and I think some of our representatives mentioned you have several law enforcement agencies throughout the entire United States. Several sheriffs have said, we're not going to enforce these laws. You have in Georgia, you have several law enforcement agencies that have no chase policies. Well, I will tell you, in my circuit, the law enforcement will chase you until the wheels fall off, and it is a felony fleeing offense, and it is prison. So I say on that veto piece, perhaps there's a workaround, perhaps there's not, but the impact is the important piece. Pretrial diversion is a huge program for every district attorney's office. I've got high schools in my circuit, I've got colleges in my circuit, I've got young people in my circuit that all have a quick path to pretrial diversion so that they can complete pretrial diversion and go on with their lives and get jobs and complete their schools. I am concerned about the impact this bill may have on pretrial diversion, because all of the cases that complete pretrial diversion in my circuit, those cases are dismissed. And if I say all the cases of a certain category, of a certain individual, of a certain age, all go to pretrial diversion for consideration, this bill, in my opinion, would have a detrimental effect to that. The second thing that we have is something the legislature has really done great things with, and I'm a huge supporter of: drug courts, mental health courts, and veterans courts. Our society is impacted daily. Our jails are the largest mental health facilities in the entire state. All of those cases, for anyone who participates in those programs in my circuit, those cases are also dismissed. I am concerned about the impact on that. Additionally, there are already laws on the books that, quite frankly, I may find abhorrent in the action, but I don't prosecute because I feel like they are better handled in the civil forum. And I will give you 3 examples: adultery, sodomy, and fornication. Sodomy being both oral and anal. I had a wife this September of 2022, demanding a warrant for her husband's adultery that he had no doubt committed. If not for our stated policy, the husband would have been arrested, gone to jail, perhaps even lost his job. And I don't agree with adultery. My wife's in the room, and I'm proud to say that I think his actions are abhorrent. But I feel that was best suited for divorce court and not superior court for a criminal case. Additionally, every college kid or young person in the state is going to be facing premarital sex under fornication and prosecution for those acts. I, quite frankly, am uncomfortable with the prospect of entering that private domain. Additionally, does it meet the goal of controlling or removing individuals who are participating in illegal, immoral, or unethical conduct? I want to start by saying any individual that's charged with those offenses should be considered innocent until proven guilty. So when we talk about fast-tracking these cases, well, there is a process. And if you are being charged with those offenses, I think we need to make sure we're not trying to speed up the determination of guilt. We're trying to make sure we do the right things. And I'm not saying that your goal is that, Mr. Representative, but that's a caution that I place out there. So I do think this bill has a great impact regarding illegal, immoral, and unethical conduct. My question, though, is at what cost? And I mean that as a taxpayer. As a taxpayer, I'm a fairly fiscal conservative. My wife back there may call me cheap. But we already have the state bar that can investigate us for the immoral or unethical conduct. We have the GBI and local law enforcement that investigate and prosecute all the time. 2 DAs last year we've already talked about were prosecuted in this manner, removed. There's a new law removing pay from district attorneys once they're indicted. And the state bar and the Supreme Court disbar attorneys every single month. We read about it in the Fulton Daily Report. So my concern there is we're paying millions of dollars for an oversight committee that I think is duplicitous of what we already have in place. Additionally, I feel that there's a question to be asked when there's a bill creating oversight that does not include other officials, such as the sheriffs, the attorney generals, or any other state level of elected official. Ultimately, DAs will still be able to selectively not prosecute cases for the good or the bad, and this bill will not and cannot remove those elected with bad leadership or management skills and generally do a bad job, because unfortunately that's not illegal, immoral, or unethical. And we have those individuals in all kinds of leadership, because unfortunately law school does not teach leadership, does not teach management. You have to gain that from perhaps military, perhaps your community as a business leader, a stay-at-home mom. But our job is not to convict. Our job is to do justice for whatever that may mean in our community. And the ultimate oversight for us, like you, comes from the voters each and every election. Local DAs should reflect our local community in that regard. Thank you, Mr. Chairman.
Thank you. And what circuit are you?
The Talladega Judicial
Talladega
Circuit, which is Monroe, Butts, and Lamar counties.
All right. Thank you. I think we have a question from Representative Fleming. You're right.
Thank you. Thank you, Mr. President. John Adams, right?
I was about to say.
So we forget, the room forgets what we were talking about earlier. I apologize. Poor attempt at humor. Thank you for being here today, though, seriously.
Thank you.
So the five-member commission investigative panel, as I understand it, has to pass on to the hearing panel if they think something merits their consideration. If they don't, it stops there. So in that five-member panel consists of one attorney with prosecutorial experience as an elected DA, an attorney with prosecutorial experience appointed by the Lieutenant Governor, two practicing attorneys appointed by the Speaker of the House, and a third former district attorney or solicitor general appointed by the Senate. So those five people are going to have to pass on to the hearing panel based upon what you're worried about for a DA sending people to pretrial diversion or for a DA prosecuting somebody from sodomy or adultery. You think they're going to pass that on to the hearing panel? You sit here and tell us today.
Here's my point, is I'm not taking that chance. You said it yourself. JQC gives you a call, I'm running for the hills. So perhaps now my policy changes and I'm prosecuting those adultery cases and you don't get a chance to hear it at the committee because now I'm doing what you've asked me to do.
So you're going to prosecute sodomy cases because of this? Is that what you're sitting here telling us today?
I haven't seen the bill once it's passed. Now, where it is right now, I will tell you, yes, I will not. I have a policy right now that I sent to the magistrate court judge that I can share with you that says we will not prosecute these adultery cases. If this commission is created in its current form, then I will be forced to remove that policy. That magistrate judge will then be issuing those warrants. Whether I prosecute those cases, we'll have to go on a case-by-case basis, certainly. But, yes, we will be considering adultery, sodomy, and fornication if it's a result of this.
So you mentioned the JQC. How long have you been practicing law, Mr. DA?
Just about 20 years.
Have you ever seen the JQC remove a judge who didn't need to be removed?
You know, in a sense, I have never seen one remove one who didn't need to be removed. But I have seen some who decided to retire because they didn't want to fight the fight. And that concerns me because to fight the fight, you may be innocent. And we all know that to be innocent does not mean to be proven not guilty. And so to face a JQC and lose your retirement and all of the other things that come with that, I think we have some judges that may or may not need to be removed that have left office. And to me, that's also concerning.
Well, we can change the JQC. Would you advocate that we get rid of it?
Absolutely would.
You would?
I would, absolutely. We have the same measures to remove judges as we do district attorneys. I have a judge now that is afraid to make certain rulings because he's afraid of what the JQC may think. He's a great guy. I like him. He's a very nervous person sometimes. So.
Thank you.
Thank you.
Thank you.
Representative Fleming. Representative Gullett.
So you're saying that there are laws on the books. Have you ever wanted to be a legislator?
That's actually the goal I had when I was a young person, and then I realized there was just too much politics involved in it.
As outdated as some of our laws are, the job that you have is to look at each case on a case-by-case basis. This is my understanding of it. I'm not a lawyer. Look at evidence for each case and determine whether It's a prosecutorial. You have the means to prosecute it, meaning there's evidence to support it. You can get a conviction. It's the right thing to do. The problem, I think, and it sounds like that's an option for you on the sodomy cases. So it's outdated. So do you believe that your role supersedes our role in the legislature? Because we pass laws that says this is a law. Now, it's an outdated law. It's probably something that needs to be addressed one day. But when you're saying that, you're not going to prosecute, and you chose a great example because that's kind of a stupid thing on the books in my mind. Today's world probably wasn't back in. It might be used for great uses today. I have no idea, but that's a law on the books that a legislative body and a governor signed into law, and you're saying you're not going to prosecute that. Do you believe that you supersede legislators?
That's a great question. I think that there are three equal branches of government: the executive, the legislative, and the judicial. And the Georgia Constitution squarely places the district attorneys in the judicial branch, and I feel for that very reason. My issue with the adultery, for instance, I don't have a problem with it being in a book. Perhaps there is some reason down the road that it could be necessary to go a exception to policy. But my reason why it's important to have my written policy was so that magistrate judge did not arrest that individual for committing that adultery. Same as in the fornication. I don't need my college students arrested because, and it wasn't that law enforcement was going to do it, because usually law enforcement have, I don't want to say better sense, but that they've got that discretion as well. What it's from and what this was from is in Georgia, citizens have the right to go to magistrate court and file an application for a warrant, and as long as it meets the letters of the law, usually the magistrate court judge issues those warrants and leaves it up to the district attorneys or the solicitors general to ferret out what goes next. So that's why I do on that one.
Thank you, Representative Gullett. Any further questions of this witness? I don't see any. Thank you very much.
Thank you, Mr. Chairman, and thank you, everyone. I appreciate the opportunity.
We have Bill, is it Bill French? Finch.
Thank you.
Come forward, and if you'll try to limit your testimony. I know I just looked, we've got about 5 or 6 bills left in about, I think, 18 minutes or before we have full committee. So,
Well, thank you, Mr. Chairman. Members of this committee, you'll be happy to know that most of my notes were covered by some of my predecessors here at this seat, so I'll try to limit it as much as I can. But when I looked at this thing, some of the things that I thought about immediately is, what about this speaks to limited government? What about this speaks to local control? And what about this piece of legislation respects the ballot box? And so as I was thinking about that, I thought, well, you know what? The party that is currently in power is not always so. As you can see by my gray beard, I can remember a time when the current party in power was not so. And I won't go back as far as Rome to give a history lesson. I will only go back to Senator Harry Reid, as he was attempting to get judges approved at the federal level. And he created a weapon that allowed the Democrats to get judges approved at the federal level by the elimination of the filibuster. And when Republicans came back to power, they perfected that weapon. And they did it with the Supreme Court. And what are Democrats so upset about right now? The makeup of our Supreme Court. So when we create a weapon, and when I say we, I mean the members of this body, be careful about who that's pointed towards. What I hear from this body is that they have this solemn power of oversight. And I understand it that they want to retain that power, specifically because they're mad at a few errant district attorneys and I think one solicitor general, and I'm just as mad as y'all are. if I wanted to be a politician, I would change my name tag for yours. I don't think I get to make the political speeches in front of the cameras that some of my errant colleagues have done. And that makes me mad. But I want to be very careful that we don't build a cure that is worse than the disease. Because this power that I've heard here that needs to be retained in the House cedes the very power that they say that they want to other people. Why is the governor getting an appointment here? Why is the lieutenant governor getting an appointment here? You're ceding the very power that you say that you want and need and is a necessity, and yet you cede it to the executive branch. Why? Now, I prosecute both for DUI courts and what we refer to in our county as care court. It's mental health court. And part of that is marijuana. Now, I know that the one Solicitor General that was within the crosshairs of this body, I understand, he made me mad. He wouldn't come to our associations, he wouldn't listen to our advice, and he got voted out. So there is power in that ballot box. I don't think we need to create a panel that will remove locally elected officials. Not in this manner, because he wanted to say that he wouldn't prosecute marijuana. Well, he's in a delicate position there, because even the state of Georgia can't decide what it wants to do. Are we in the business of being anti-marijuana, or are we in the business of being pro-marijuana? If we're anti-marijuana, why aren't we funding the GBI to give us the very tests that we need to prosecute those cases that we're mad at him about saying that he won't prosecute? I still have to prosecute him. My evidence is weaker because this body, not this committee, but that the House is not appropriating money to the GBI to test that substance. Still have to prosecute it. But I won't talk about, I'll mark off adultery and consensual sodomy because that was on there. But what about traffic citations? There's nothing in this bill that makes a distinction at all between some of the things that we're mad about most because prosecutors decided they wanted to be politicians and my prosecution of a traffic citation. I'm given limited resources, very limited, to prosecute what my local people want me to prosecute. And I get absolutely no money from this House to do that. And yet we want to have an oversight to remove me from office because I cannot, prosecute a case that y'all won't give me the funds necessary to prosecute. So I go back to, does this support limited government? Does it represent local control of the local voters who put me in office? And if we want to talk about the nonpartisan part, at first blush, you would think, yeah, it sounds like a pretty good idea because y'all give me a book and y'all tell me to go ahead. You unleash me into the courtroom and you say, prosecute these cases. Doesn't really matter whether I'm a Democrat or Republican when I go in there because, when I take that solemn oath, when I raise my hand and I say that I'm going to faithfully and impartially and without fear, favor, or affection will discharge my duties, that means something. It's got to mean something or it means nothing. Nobody has ever filed any charges against any of those DAs for a violation of the oath of office. Nobody. Nobody's done that. We're angry, but we're not doing anything. In my opinion, it's a violation of oath of office when you get up there and preach about things you won't prosecute. You got no business doing that. If you want to do that, change pens, become a state rep. And so, Mr. Chairman, I'm sorry I went a little bit longer, but I got going and I couldn't stop.
I could sense you on a roll, Mr. DA, so I didn't want to stop. I was afraid it might hurt you if I stopped you. You do have one question from Representative Fleming.
Thank you, Mr. D. I appreciate you being here today, and I'm sorry.
I'm the Solicitor General in
You're
Forsyth County.
Mr. Solicitor. Thank you for being here today. The previous district attorney told us he was worried that this panel that has to look at the complaint and decide to send it over for a hearing, one has an elected district attorney, one other has to have prosecutorial experience, two others have to be attorneys, and one of them has to be a former solicitor. He told us he was worried that because DA sent people to pretrial diversion, that panel was going to forward complaints to have people removed to the hearing panel. Now, that's what he said. You're sitting here telling us today you believe because someone didn't enforce a traffic citation that that 5 panel of lawyers who are former prosecutors mostly are going to send that to the 3-person panel to have that solicitor removed or DA removed?
I have no idea what they would do, and it makes me think back to the question Mr. Gaines, Representative Gaines, asked one of the members here, would you vote to convict? They hadn't seen a shred of evidence, and they're asking for a conviction. I have no idea, prior to the presentation of evidence, what anybody, and when I say body, I mean B-O-D-Y.
But you have enough concern to mention
Right.
that if somebody didn't prosecute a traffic violation, they would be removed from office.
Correct, and it's usually those things that we do not foresee that come back to bite us. Look at our Supreme Court and who makes it up now. It would not be the same makeup had Harry Reid not pushed the nuclear option. He chose it, and Republicans, I think, rightly perfected that weapon.
Thank you.
Thank you, Representative Fleming. Any other questions for this witness?
Thank you for your time again,
Thank
Mr.
you for
Chairman.
your testimony.
I again apologize for too much time.
No, that's quite all right. I apologize for calling you a DA. Instead of the Solicitor General.
We call it the JSC, it's just state court.
Well, I used to be a solicitor of a city court, not quite the same thing, but I respect the office very much and appreciate your time here today. Sherry Boston. And you're on the same line with, is it Dahlia?
Yes, DA Dahlia Racine. She could join me up here. Just in interest of time, I know we don't want to take.
We certainly have no objection to that.
We're happy to tag team. I'm going to start off while she's coming up. I'm Sherry Boston. I am the district attorney for DeKalb County, the Stone Mountain Judicial Circuit. I do want to preface some of the things that I also uniquely have had the opportunity to do. Prior to being DA, I was the Solicitor General for DeKalb County. And since I have been Solicitor General and DA, I have had the pleasure of doing a couple of things that have come up in this room today. I have been a special prosecutor before the JQC, and I've had the privilege of prosecuting a judge under the JQC where that judge was removed. I also have served on the Board of Governors, the discipline body of the body of the board for 10 years. And twice, for 2 terms, I was appointed by the Supreme Court of Georgia to serve on the state disciplinary board that is the investigative body that looks at disciplining all lawyers in the state of Georgia. I say all that to say is because there's a lot of discussion about what happens at the JQC, what the bar does. Because of those things, I was also tasked by the DA's Association to lead the change to Rule 3.8, which is Special Rules of a Prosecutor. And last year, I led the charge for the DA's Association, and as a member of the Board of Governors, the Board of Governors agreed to pass the change to 3.8, strengthening the disciplinary arm of the state bar. And as you know, that rule went to the Supreme Court of Georgia, and after comment, the justices adopted the bill that I had drafted from the ABA's rules. So I say all that to say is that I am very well versed in all of the areas when it comes to discipline and the rules of professional conduct, which all lawyers are responsible for following. And let's be clear, outside of the Attorney General, the only other elected office in the state of Georgia that requires you to have a law degree is District Attorney and Solicitor General. Those are two places. I'm not even saying judge, because as you all may be aware, there are certain populations of judges that a law degree is not required. But for the Attorney General, for DA, and for Solicitor General, we are the few that have to be lawyers in order to qualify, which means all of those positions. And that's why I want to make that distinction between judges, because we do have judges, and the judge that I prosecuted was not a lawyer. So I say that to say is that we are all governed by the professional rules of the Georgia conduct and subject to discipline and removal ultimately by the Supreme Court of Georgia. And I think that's an important distinction. The other thing that I want to talk about really quickly and briefly is the timing. There's been a lot of conversation about the need to have a process that moves quickly and swiftly. I have been a part of the disciplinary panel for 8 years. I was also a part of a prosecution of a judge. I can tell you emphatically, having been a part of both of those processes, all which require due process. As DA Adams stated, you are innocent until proven guilty in the context of criminal law, but also in these removal proceedings, disciplinary proceedings, there is also due process. And I know we're all aware that it's taken upwards of 2 years for a Court of Appeals judge to be addressed, and that judge is still in office. So I think we have to also remember that there is no magic pill or no magic bullet. And every single district attorney or solicitor general that has been discussed today has either been convicted by a jury of their peers or removed by the voters. Now, I can't speak as to why the others, and let me just say that the District Attorneys Association opposes this bill. And I can tell you that despite the conversation today that this hasn't been talked about since last year, I can tell you we have discussed this issue ad nauseum at every single meeting, and we meet 4 times a year for the last 3 years. So the DAs, the majority of DAs that oppose this, have done so because they are concerned about the problems that you have heard outlined by my colleagues today. With that, I will turn it over to DA Dahlia Racine.
Thank you. I just want to complete the circle. I actually am related to John Adams on my paternal grandmother's side. Don't know if it's Quincy or just John Adams. Yeah, I guess that is the benefit of having to go in this lineage of speakers, is a lot of it is what he said, she said at this point. But I would like to add, just to speak, I know there's been a lot of reference to the letter of the 21 of our counterparts within the DA's Association, but this has been voted on recently, and this is the official stance of the DA's Association to oppose this bill. Now, what I will say when it comes to the commission that Solicitor Finch did speak to, it feels like, for those that are familiar with the selection process of juries within the criminal justice system, it's as if the state, or for civil world plaintiff, has all the selection power in picking the jury that is going to hear and decide the fate of your career, the fate of what you are doing, how you are serving your community. And I will tell you, I've been a prosecutor for over 17 years now, and how we do things in one jurisdiction is never mirrored in another jurisdiction. For example, at a prosecuting attorneys council training in the past, they've had sessions on timber theft. I could tell you, as the district attorney of Douglas County, 20 years ago that may have been an issue, but no more do we worry about timber theft, which is why the autonomy of each individual district attorney, solicitor general is so important to serve the community in the unique way that it does need to be served. And handcuffing us to not be able to do that in a way where we are able to adapt and adjust to those needs and wants of our community can be very dangerous. Now, what I wanted to bring up was you've heard about the GBI crime lab testing. You've heard about the issues that we have, the adultery sodomy conundrum that we have faced and we have dealt with in our various ways in our various jurisdictions. If we want a fix to the justice system, if we want a fix to help DAs and solicitors do their jobs, what we could have is not just funding to our investigative entities. What we could have is additional funding for our mental health resources so that we are not left as prosecutors looking for an out way to take individuals who are arrested by law enforcement where prison jail is not the answer. They need resources, they need treatment. And we are left with the residue of society's problems and told, go fix it. And how DA Boston fixes it, how DA Racine fixes it, how DA Arndt fixes it are going to be 3 different ways because we have different resources and we have different accessibility. To then come and Monday morning quarterback our decisions on how we make that is grossly unfair based off of what we have to deal with on a day-to-day basis. We are consistently asked to solve problems we did not create. And having an oversight bill to add to that obligation, to add to the already heavy commitments we have to serve our individual organizations, it is unfair and it is unjust. We have seen time and time again, the dead horse has been beaten ad nauseum, that the issues of those that serve in these roles that are unethical, illegal, they solve themselves, period. Now, I know that there was discussions about several topics that came up and issues with our peers and our colleagues about letting speedy trial demands run, about issues of having different assets of legal parameters that take place. If we are to start to be judged based off of how many speedy trials run, how many deadlines are missed, how many different issues take place on technicalities, when there is not very many DAs or solicitors in this place right now or in the state that did not suffer from having 30% loss or attrition in their staff. We were in survival mode. And so then to come and say, well, how dare you say you're not going to do this because you can barely stay afloat. We are the epitome of making $1 out of 15 cents. That is our specialty in prosecution. And to then tell us you are doing it wrong just feels unethical and unjust. And I just wanted to say that I know that it was discussed like adultery and sodomy, saying that you say it may be addressed one day. But as prosecutors, our role is to address it every day. Our solutions are not driven by theory, but rather by addressing our community's reality day in and day out. And it is not easy. And so we just ask for the latitude, the permission, the trust to do our job in the best way that we see fit and let our communities hold us accountable, let the state bar hold us accountable, let the Supreme Court hold us accountable, and let us do what we do. Thank you.
Thank you, District Attorney Racine and District Attorney Boston. I think we've got 1 or 2 questions for you, if y'all will just stay there for me. First, I believe is it Representative Gullett.
Yeah. So I know you said that it's been talked about ad nauseum, and I think it probably has. When's the last time you guys took a vote? Do you know?
We had a DA's meeting in January.
Did you vote?
I was on the tail end of that meeting. It was once again discussed.
Did you vote?
And we voted, yes. That's our president sitting right behind us, DA
Sure.
Tasha Mosley.
I'll ask her too. So you guys voted in January?
At our January meeting, yes,
Okay.
sir.
All right. Thanks.
Thank you, Representative Gullett. Representative Fleming.
DA Boston, I got your name, but I'm sorry, DA
Racine.
Racine?
Yes, sir.
Racine?
Yes, like Wisconsin.
So, doesn't help, but I
It didn't help me
appreciate
either.
the effort. Yeah. And to answer one question I can't answer for you, if you're kin to John Adams or John Quincy Adams, you're kin to both because they were father and son.
Oh, look at that.
Yeah.
All right. Well, I claim them both then. I don't know
Second
if they claim
set
me,
of
though.
father and son presidents I think we've had. Let me ask this question of you. Did either one of you, when you were elected, release a list like Ms. Gonzalez did in Athens of the crimes you were not going to prosecute?
I did not on day one, but I do have a COVID backlog policy now that it's in writing and open to the public that indicates that based on necessity and resources that I'm reallocating those resources in my office away from nonviolent offenses.
Did you release a list when you were elected of crimes you were not going to
Not day one,
prosecute?
but similarly, I did let my law enforcement agencies know that we would not be prosecuting misdemeanor marijuana based on the limitations of GBI testing.
So based on let's go ahead and get it on the record. Tell me what crimes, Madam DA, you will not prosecute.
Oh, gosh. So I don't have the policy in front of me, but I can tell you personal use amount of drugs. There are also a number of theft cases, a number of financial fraud cases. I'd be happy to provide you with a copy of my COVID policy because it's open to the public. Our law enforcement's aware of it and is supportive of it.
Madam DA, what crimes will you not prosecute?
What we have to do is make an allocation and determination of the resources that we have, and based on those very limited resources, based on the experience level of the individuals that I have, based on the escalating amount of serious violent felonies, our lower level offenses are oftentimes, we are told, are not prioritized in our office.
So to
And
both
so
of
we have
you,
to-
I'm sorry, I didn't mean to interrupt.
No, I'm sorry. Go ahead.
Yeah. So to both of you, when your resources get back to where you need them to be, are you once again going to start prosecuting those crimes?
If I can get DeKalb County to 0 murders, I absolutely will focus on those crimes. But until I'm at a time where we're not having record number, or not even, I don't even want to say record because it's been going up. But in my community right now, what my community wants me to see is gun violence, youth violence, gang violence, murders, domestic violence, and sexual assault. Those are our highest priorities in my office right now.
Do you know if your list of crimes you will not prosecute differs from Ms. Gonzalez's?
I have no idea.
I saw it looked like it had 20-something things on it. That's why I'm asking.
I have no idea. I have not compared our policies. I will say that as it's been stated here, we have 50 DAs with 50 different types of jurisdictions. DA Racine mentioned timber theft. We've never had that happen in DeKalb County. I'm sure there are some things that are prevalent in rural jurisdictions that I don't see, just as I know that I have probably the second most number of murders, maybe the third, in Georgia. So everybody's jurisdiction's a little bit differently, which is why it's so important that local communities understand the values and what those DAs intend to do in their jurisdictions, because nobody's going to elect me, I don't know anything about timber theft. Right. So,
but I know where to go steal trees if I want to go. Though, so, but nonetheless,
hey,
if I need some firewood,
if that's the lease that I have in DeKalb, honestly, I'll take it.
I got you. But Mr. Chairman, my last question, I think, is, depending on how they answer, we talked about y'all having meetings and several meetings and taking votes. Mm-hmm. Have y'all discussed and taken a vote on Ms. Gonzalez's list that she released of crimes that she will not prosecute?
We've never discussed or taken a vote on the policies and practices of any individual DA. In as long as this, as I'm aware of, every DA operates in their own jurisdiction and has the ability to make decisions for their jurisdiction. And I don't judge anyone for what they do in their jurisdiction any more than I would want them to judge me for the choices that I make for living and working in DeKalb.
That was my suspicion that y'all have not addressed it. Thank you for confirming that. Mm-hmm. Thank you.
Any further questions for these witnesses? If not, we're going to let them get back to their respective jurisdictions. Thank you so much for your time today. Representative Jesse Petrie, are you still there? He is.
Thank you, Mr. Chairman. I'm going to begin by saying I don't know how you guys survive in here with the heat in this committee room. But thank you for having me, Mr. Chairman.
I'm very cold-natured.
You're very cold-natured. I got it. All right. Well, Mr. Chairman, I'll going to be very brief because I just want to make a few comments. I feel compelled to do because we've got some real challenges in my community. But let me begin by saying this, and then I'm going to tell you give you a couple of stories. I, for the life of me, cannot understand how an oversight committee is correct and appropriate for judges who have such vast powers to sentence individuals to life or dismiss a case, but not so for district attorneys who have their own vast discretion and authority. And so when a DA fails to follow their oath of office, and I'm going to give you some examples of that, and to protect the community and suggest that they are somehow protected under the guise of being an elected official, how long should the community suffer? And so let me tell you about some of the suffering going on in Chatham County. I represent Chatham and Bryan counties. Let me tell you some of what we're dealing with in Chatham County right now. We have had 30 murders in the last 2 years, reduced, dismissed, or pled to probation. We have a rapist who received 18 months for raping a girl. Victims have not been notified of court hearings and pleas in violation of the law. 143 employees we had 2 years ago have declined to 75 employees over a 2-year period. Our judges received a memo from the DA, similar discussion that just took place, that they would no longer be prosecuting whole classes of crimes such as, yes, marijuana, but also DUIs when they did not have breath tests, misdemeanor thefts, and shoplifting. Our DA's office was held in contempt by a sitting Superior Court judge in my county for not complying with numerous scheduling orders, resulting in delays getting matters to trial. We've had several just this month not guilty verdicts for murder in the last month alone due to lack of experience in the office now. And I've had mothers of murdered sons burning up my phone because we've got media attention on this. I've had one that's been calling me for 3 days, a lady from Atlanta named Sharon Starks, whose son was murdered on the Savannah State University campus while attending school there, on the campus murdered, and she has never received justice. Due to this high turnover, most of the superior courts in my county are understaffed, and one literally has no assigned DAs. I confirmed that today. And the list goes on. So my friends, these are the challenges. You guys are the right group with the right experience to make the decision regarding what I believe is this good bill, House Bill 231 by Representative Gullett. But I'm going to tell you, my job's to represent, somebody made a comment, one of the DAs earlier made a comment about, legislators making decisions about these affairs. Well, let me tell you something. Every one of us, Stephen Saines represents 60,000 people in southeast Georgia. He's not speaking for Stephen Saines. He's speaking for the people. I'm here to speak for the people in my community who are fed up with crime and the dramatic change that we've had in 2 short years. Now, I'm going to give y'all one final story. I'm going to give you a personal story now. A little hard to tell you, but I'm going to give you a personal example of another jurisdiction. I'm going to tell you about Evans County, Georgia, where my father died. About 3 years ago, my father was in a terrible auto accident. 8 a.m. in the morning, the other driver was drunk. They tested his blood alcohol at the hospital. He was good and drunk. He had multiple DUIs in his history. He was driving on a suspended license. He had no insurance, and the list goes on. Hard to even talk about, but I'm going to tell you all this. I called the county for months to discover when we were going to see this man go to trial. He went to trial. We never knew about it. We never got notice of it because of the incompetent solicitor in that Evans County jurisdiction. Never called us back. And then what we learned after the fact was that DUI, just the DUI, and even though my father was killed in the accident, was reduced to reckless driving. Reckless driving. When I spoke to the solicitor, he told me, quote, and I'm going to quote him, because I wrote it down in my notes when I spoke to him, "I did not know there was an accident in that case," end quote. My friends, here's the deal. We represent the people. The number one thing, most important thing we do is protect public safety. And I respect, to all the comments earlier, I respect that the people have a right to elect who they choose. And yes, there are jurisdictions, there are counties in this state who elect soft on crime judges and soft on crime DAs. Interestingly enough, that's where you have more crime. Isn't that interesting? But here's the deal. There comes a time when it crosses a line. Whether it's incompetence or malfeasance or whatever the issue may be, there needs to be some oversight in this position. And I know that that's what my community wants. This is a hot topic in my community now. And I hope that y'all will help us to get it. Mr. Chairman, I'm not going to keep you any longer. Thank you for allowing me to speak.
Thank you, Chairman Petrie. I think you have a question, though. Representative Neal?
Thank you, Mr. Chair. Thank you for your comments. I just want to clarify, if you believe that these decisions should be left to the voters of those districts, I guess I'm assuming based on the comment you say when you mentioned let the community that this is what your community wants as far as this bill per se, and you referenced soft on crime DAs or others that might be soft on crime that are elected in those districts. Do you believe that if that's what those citizens wanted, someone that was softer on crime for their community, that is their right as voters to put those people in place?
To be clear, up to a point. I wasn't suggesting that. So my point is, there is a point when you cross the line where you're violating your oath of office. Someone needs to be oversighting that. So yes, I understand that nothing here is going to change the fact in this proposal that Representative Fleming's judges and district attorney is likely going to continue to be different in how they view some of these measures than yours. But there comes a time when your community is suffering and you have someone who is absolutely failing to execute their oath of office and to complete the job they've been elected to do. And yes, I believe there should be oversight of that. That's my opinion. And that's what I'm here to speak for my community.
Okay, would your community prefer to vote for their own DA based on their own decisions and they're in the process of voting?
My community is going to be doing that again. They do it every 4 years, so we'll see what happens in 2 more.
Okay, thank you.
Thank you, Representative.
Thank you, Mr. Chairman. Thank you all for
I
having
was
me.
talking to Representative Neal, actually.
Oh.
You still got a few questions.
Oh, well,
that's the price. If you want to talk to us, you got to answer our questions.
I was trying to rush for you, Mr. Chairman. I
No,
know y'all been here a long time.
I appreciate
I'm glad to take
that.
as many as
I
I can.
appreciate that. I just want to allow everyone to ask their questions. Chairman.
Thank you, Mr. Chairman, for stating that. And this is not a perfect equivalent, but to the effect of voter choice, another personal decision. Let's say when you choose a doctor, we have the choice if you're going through a surgery to choose a multitude of skilled surgeons. Correct?
Absolutely.
Would you say that even though we have that choice, you'd still want a system to ensure that if there's malpractice, that individual were filtered out of your selection? Would that not be true?
Absolutely, sir. I think that's a great analogy.
Thank you.
Thank you, Representative.
Thank you, Mr. Chairman. Representative Reeves?
You mentioned a statistic of 30 murders. How recent was that, in a year or so?
In the last 2 years,
2
we've had
years,
30 murders.
30 murders in Savannah. The representatives from Columbus mentioned there were 17 shootings over weekend. One question, just connecting dots, maybe on this issue or maybe another. How many of those were drive-by shootings or gang-type activity?
I can't
like
speak
that?
to that. I have the data because we've actually had WJCL, I should say. WTOC, I apologize, investigating this.
But some of them rise to that level.
I can give you the data on the numbers. I can't tell you the detail about each crime. I can tell you about certain crimes where I've spoke to the families, and they are standing with signs out in front of the courthouse because they're dissatisfied with the lack of justice that they've received.
From emboldened criminals.
From emboldened criminals. Thank you, sir. Thank you, Representative.
Thank you, Representative Reeves. Chairman Petrie, thank you so much.
Thank you, Chairman.
I don't see that you have any
Thank you
other questions.
much.
All right, I think the only witness I see on our list for this bill is Keith Higgins.
Thank you, Mr. Chairman, for allowing me the honor and privilege of speaking before you today. I am the elected district attorney for the Brunswick Judicial Circuit. I can speak directly to issues that have been brought before this committee, but I will not do that today. I want to briefly just echo the comments of District Attorney Barksdale. I am in favor of prosecuting attorney oversight. I was one of the 2.5 in favor of it last year, and I still am. I appreciate Representative Gullett and other members of this body being willing to talk with my fellow district attorneys and make revisions to this bill, which I believe address the concerns that the district attorneys had. It does allow for prosecutorial discretion. And I do not believe that it would affect a DA being able to put a case in pretrial diversion or handled through drug court, because that's still prosecution. It's simply a different type of disposition. So I do not agree with that assessment of the bill. I do want to specifically address the references that are made to elections being a way of calling an errant DA to task. I will tell you that if I had not run for office, that would not have happened in the Brunswick Judicial Circuit. So an election is not a way of calling a DA to task or having them removed for office if that district attorney is not opposed. If I had not run in the way I had run, my predecessor would still be district attorney. Plain and simple. A point made by Representative Reeves earlier with regard to the nonpartisan election of DAs. As a general matter, I believe that district attorneys should be treated the same way as Superior Court judges. They're elected as nonpartisan. They're subject to the JQC. They can be removed from office. And that's my view. And I thank you for the time. I know it's short and I'm the last speaker, so I will entertain any questions that you may have.
Thank you. We have a question from Chairman Saines, with whom you may be familiar.
Thank you. Would you agree you had the longest drive of any person testifying today?
Yes, sir. I drove up from Brunswick this morning.
Appreciate you making that. You noted a little bit, so in terms of pre-trial diversion, do you believe that there is anything you're prosecuting or any policy of your office in terms of laws on adultery and et cetera that you would change as a result of having this council formed?
No, I don't believe this bill would affect prosecutors or district attorneys' ability to prioritize cases, to emphasize cases over others, and to decline to prosecute certain cases. One of the code of ethics that we're under with regard to as a district attorney is to seek and do justice. And sometimes that involves declining to prosecute a case, even though there may be sufficient evidence to prove guilt of that offense. So I don't think this bill would affect a prosecutor making a decision not to prosecute an individual for consensual sodomy or fornication or adultery. I don't. I believe this bill would allow a district attorney to exercise his or her discretion in that regard, to decline to prosecute those types of cases in the interest of justice, as well as with regard to the resources that are available in that office.
Thank you. For the record, I wasn't lobbying one way or the other on those crimes.
Thank you, Chairman Saines. Florida Hong.
Thank you, Mr. Chair. Thank you, Mr. DA, for being here. I know we've had a lot of conversations about different professions having oversight. We lawyers have the state bar. I'm a criminal defense lawyer, so, and many of my criminal defense lawyers get complaints, most of them frivolous, get letters from the state bar, et cetera. Do you know if prosecutors are just not getting those complaints, and or is the state bar not prosecuting those complaints? Why is the state bar not looking over the prosecutors as much as they do as far as looking at the complaints for the defense lawyers?
I can't really address that because it's hard for me to testify as to why somebody else either is or is not doing anything. But prior to becoming the elected district attorney, taking office in January of 2021, I did serve as an assistant district attorney in the Brunswick Judicial Circuit for 23 years. I will tell you that during that time there were some complaints filed from defendants with regard to how their cases were handled, and the state bar summarily dismissed those, if you will, or resolved those cases. With regard to, I did, after leaving the district attorney's office in November 2010, I then was a criminal defense lawyer for 10 years as well, such as yourself. So I'm in favor of this bill based upon my experience as an assistant DA, as well as my experience as a criminal defense lawyer.
Thank you.
Thank you, floor leader. Do we have any other questions for this witness? I don't see any. So thank you very much for your long drive and your testimony today.
Thank you, Mr. Chairman.
All right. Is there anyone else who wanted to testify on this bill? I don't see any. Well, thank you to all the witnesses who came and testified. I believe we've had some discussion about a substitute, and there were some suggestions made. I think this is just going to be a hearing only today, and we're going to try to address some of those issues. I also would like to declare a brief break because I've got to take one very summarily. Mr. Chairman, do you want to go ahead and commence your meeting? All right, so we're going to go ahead and then sort of suspend, I guess, the subcommittee meeting and commence with the full Judy non-civil hearing. Okay. All right, so thank you. We'll just be in recess very, very briefly.
All right. We are going to move into the full Committee of House Judiciary non-civil. We will be taking up, yeah, we'll give you about 5 minutes. But just so y'all know, we will be going into full committee here shortly in 5 minutes. And just so everyone knows, we will be taking up House Bill 332 and House Bill 88 in full committee. Thank you. Just so everybody knows, we will be coming back into subcommittee as soon as full committee takes up the two bills. And just so everybody knows, the two bills that we will be taking up in full will be House Bill 332 and House Bill 88. All right, we have a quorum. We're getting back rolling. Okay. First bill up that we're going to hear will be Representative or Chairman Parrish's. You want to come down to the hot seat? Good to see you, Mr. Chairman.
Thank you, Mr. Chairman, members of the committee. Looks like y'all are having a long afternoon, and I'm going to do everything I can to help you get through quickly. Okay?
Thank you, Mr. Chairman.
Appreciate the opportunity to talk to you about House Bill 332. For you that are returning members, you'll recognize this, that we do it every year. This is just the annual drug update bill, and it comes to us from the Georgia Drugs and Narcotics Agency working with the GBI just to update our state law so that it concurs with the feds as it relates to controlled substances. Just allows our law enforcement folks to work more efficiently and effective in what they're doing. And as far as I know, there's no controversy, and would certainly appreciate supporting and moving this bill on.
Thank you, Mr. Chairman. Everybody take notes from Chairman Parrish and his presentation. That's brilliant. That's right. That's right. Number 4, is that you, Representative? Okay. All right. Okay. I'll let me make sure I get my process right. Okay. No question from the committee. I'll entertain the motion.
Do pass, Mr.
All right. Do pass. Second. Motion second. Do pass. All in favor say aye. Aye. All those like sign. Congratulations. We'll sign that for you and get you on the rules.
Good.
Mr.
Thank you,
Chairman.
Mr. Chairman, members of the committee.
Thank you. Next, we have Representative Gaines. Welcome back. I know you've been with us all afternoon. Thank you. We're always glad to have the gentleman from Athens with us. So
Appreciate you.
Tell us a little
Always
bit.
good to be back.
Yes, sir.
House Bill 88, this is a bill you all have seen before and that was voted out of committee, but there was a concern brought forward that we have addressed on line 106 and 107. That's the only changes in the bill since you saw it last. Just clarifying that the statistical information, the reporting on these cold cases is in the aggregate, not individual names of suspects potentially, which we believe wasn't necessarily. We just want to clarify that it's only in the aggregate, and that's all the changes.
Any questions from members of the committee? I want to thank Chairwoman Ballinger for helping us on this. This was a great fix, so I know we're all for being open and out in the public and showing what we're doing, but on stuff like this, character assassination is not something we want. So, anyways,
Amen.
With
And
no
thank you, Mr. Chairman, for your help and Chairman Ballinger.
Good bill.
Good teamwork.
Yes, sir. Yes, sir. That's what it's all about. Number 4. All right. See no questions. Entertain a motion.
Second.
Motion second. Do pass. All those in favor say aye. Aye. All those opposed, same sign. Congratulations.
Thank you, Mr.
We'll
Chairman.
send you back to rules.
Looking forward to it.
Yes, sir. All right. At this time, we are going to go back into the Leverett Subcommittee of Judiciary Non-Civil. I do want to take this moment and recognize a couple folks out in the crowd. Former Attorney General Owens, it's so good to have you with us. Appreciate you taking time to come and be with us. And then Representative Emeritus, Representative Reeves.
I'm just here for nostalgia reasons.
I
miss this. I really do. I miss this.
Security's always been weird, Mr. Chairman.
Yeah. We'll see it. We'll see if that still stands at 6:30 this evening. So we're gonna get. That's right. That's right. We're gonna get back to it. I'm gonna turn the chair over to Chairman Leverett for the subcommittee. Full committee members are dismissed unless you want to sit here and listen to good legislation that may be coming to full committee next week.
All right, thank you, everybody. We'll resume the subcommittee meeting, and as the Chairman Smith said, if you are not on the Leverett subcommittee but you're on full duty, you are free to go, as we say in the legal business. So we love to have you stay, but you're welcome to leave. All right, I think the next bill, the next bill on our agenda is House Bill 181. Is Representative Townsend? There he is. I believe this is coming back to, we had a hearing on it some time ago and you're bringing it back.
Yeah, so we had a hearing on last week. Substitution based on committee feedback and talking to quite a few people and seeing what kind of the mood was. We originally called for a scheduled ban. I'm talking about LC 3394336S. You should have it in front of you. If not, I've got a copy. And originally we were talking about a full ban, but based on the feedback, the team was concerned about, let's go after the bad actors, let's control the substance, make sure everything's properly labeled, and not hold the consumers as felons or something like that. So after doing some research, if you look at the, you'll see, if you just start off reading it, it talks about the violations. One thing we kept in there, even during testimony of the Roman couple, they talked about, I think nobody really liked those elixirs, how they were mixed, the little bottles you see or whatever else. That was a big problem to everybody. So that is still a Schedule 1. Then going from there, if you look at Section 2, it defines kratom. It gives you the substance. And that came from, let me get my notes out. The scientific reports, it's published, research published, journaled. It talked about the leaves. And so basically what we're going to do is, where it's legal to have the leaves, we're going to sell it over the counter, and it'd be behind the counter, of course. But basically it'd be legal to have the leaves or the powder in this purest form. And at that certain ratio, anything above that would be illegal, but it'd be like anything else. You could buy more. It's like you go to a store, buy a case of beer, you choose to drink it in 1 day or 12 days. There's a big difference. And so that's up to the consumer, though, and that's not holding them as a felon or whatever else if they do that. And so that kind of takes it there. You have to be 21. Also put that in language as well. And then it goes after the bad actors. If you look at Section 4, it goes after any manufacturers, distributors, or people who sell it who do not properly label it. Quality control. If you remember the whole thing, we talked about quality control. This will make sure everything's labeled correctly. People know what they're buying. It's not buyer beware. It's not going to be where we had the one wife who testified. Her husband did it while working out, mixed it with an energy drink, and zap, had a heart attack. And he didn't know. You weren't sure the levels of concentrate or whatever else. And so this proper labeling, going after the bad actors, and that's what I've been told before, actually by everybody, let's go after the bad actors. Let's not go after the consumer, protect the consumer, and that's what we're trying to do here, but we're not outlawing it. It still gives people a way to use it, even a situation if you want to put a tea leaf in your coffee or tea or whatever else, that's fine. That's their decision. But let's keep it at the substance only. I believe there was testimony that day from the director talking about the importance of not, I'm not sure how it's the correct way of saying it, but adulterating of the original form. Let's keep it in its original form so it's at the safest level for our consumers. And basically those are the highlights, and I'll be glad to answer any questions, and hope you realize I took your feedback to heart. I passed out whoever I could. I saw it at 11:30 this morning when these came hot off the press from council, so I know you got it late, and I apologize for that. But it took a lot of work on this to get this worded correctly and everything else, and council was great help. And Mr. Chair, that concludes my presentation. I do have, let's see, one more thing. I kind of said this earlier too. With regarding the makeup of how it was determined how to make it up in the research article. So if you have questions, just please let me know. But again, Mr. Chair, I appreciate you inviting me back and look forward to doing something to help our consumers out in the state of Georgia and my community.
Well, thank you very much. You do have a couple questions for Leader Home.
Thank you, Mr. Chair. Thank you, Representative, for bringing this back, and it looks like you've cleaned up a lot. But I just have a question on Section 4E, which is the very last, or I'm sorry, page 4. I'm kind of confused as far as it says a person other than D who imports, manufactures, distributes, sells, possesses any kratom that violates this code section is punished by a fine. Who are you referring to?
Person imports, manufactures, kratom violation.
Because I know your bill is essentially allowing certain kratom to be purchased based on packaging, et cetera, meeting those things. I'm just kind of confused on line 88 through 90, who that would be.
Correct. Yeah, you're right. When I'm looking at it again, I was thinking it was the really. Yeah, and that part could probably be stricken. It is geared toward the regular consumers if they were. Yeah, that's a good point.
Okay.
No, yeah, I mean, I'm just looking at it now, at it, and.
Did you mean to put? What did you mean by it, or was it?
We just want to
was
make
it
sure at the end of the day, you don't go out, and it's okay to, like the lady from Rome that had the distributor there. They were doing the leaves and the coffee and the tea, and they would give the right amount or whatever else. That's fine, but we didn't want somebody buying some and then reselling it in quantity or in extra doses or whatever else without people knowing. So that's, we can amend that.
Yeah, I would think that your scenario would go into Section D where it's distributes or sells.
Yeah, that would be, yeah. Okay. I agree.
Thank you.
So I'm assuming your intention was not to make just mere possession
correct.
Illegal? Okay.
Correct. No, because that would be legal.
Okay.
That's my fault.
Okay.
Good catch. Thank you.
Okay. So, Representative Kendrick, are you first up?
Sure.
I'm sorry, I didn't keep track of who started blinking first.
I think we pushed at the same time. Okay, thank you. My question is maybe a matter of statutory construction, but on line 84 and line 56, I know we talked about a little bit about the intent element last time. Is the word intentionally or knowingly missing between the words any entity on line 56 and on line 84? Is that implied that it has to be an element of this crime that they knowingly doing it? I'm trying to.
That's where I'd probably ask council help with the law is there, because we're talking manufacturers, distributors, or anyone selling it. They
Right.
know the law. They will know the law. If you notice the date, it's going to be December 31st. Give them plenty of time to get the word out, plenty of time for people to use their resources and whatever else. But in this case, those actors will know what the law is, and that's, if I need to add a word to it, I don't mind adding a word to make sure. But yes, it would be if you're distributing it, manufacturing it, or selling it, it needs to be labeled correctly, and so we can have the quality control and the right amount of dosage in there and everything else. So if I need to add a word, I don't mind doing that to make sure that's specific. Is that what you're asking, Representative? I'm sorry if that's.
No.
Makes sense.
That's what I'm asking. But now that you explained it, maybe you have.
I just assumed since it was those three entities, they'd be part of that supply chain.
Yeah.
That would just be the law itself. I would assume it would be understood. But I'm not a lawyer, and I don't claim to be. And
We might need to ask, well, I don't see legislative council. Oh, there she is. Holly, you're hiding behind Representative Fleming.
I am here. I've had a murderous day and have not had a chance to view this bill. And I'm not the drafter, so I would need some chance. I need a chance to take whatever questions you may have about it under advisement.
Council Howington is the one who helped draft the bill. Betsy Howington is the one who helped.
I just wondered on this kind of regulation if sort of it's a strict liability standard.
All right, that's what I'm asking, yeah.
Yeah.
It's over my head, so I apologize.
It was over mine too, it's clearly.
Any further questions, Representative Kendrick?
No, that's
Okay. Representative Neal?
Yes, thank you to the chair and thank you to the author. I know we went back and forth a lot on this. And,
We did. We talked a lot.
Yeah, and you mentioned some things were changed, but I'm finding that some of the things you mentioned are not.
Okay.
Starting with in the section, I think it's section 1.
Regarding the elixirs.
Yeah, so anywhere in here where, actually it might be section 2, anywhere in here that it outlines something being criminal in relation to the serving size, the one thing we spoke about is we had all this testimony in the prior, what amount of a serving size was actually dangerous or not dangerous. And so us just picking a number.
We're using that research report to help out, and based on the testimony about the leaves, keeping it in its purest form, if that helps.
Not quite. Is there something else that's more definitive from another source? Because just choosing some random number to criminalize and turn into a felony and put it on the Schedule 1 is just not comforting. Is there a way that can be provided? Because we had all this testimony of everyone saying that no one knows the number or the amount that's harmful. There's not enough testing to justify what is. We've had all this testimony about most of the deaths coming from a result of improper use, cocktail use. And then we had reports that outlined toxicology reports that could not identify kratom as being the one item that killed that person. And then on top of that, just the numbers that people were talking about did not equate to the pandemic proportion that we're speaking about. And so the issue of not having enough information on what that amount is to justify it being criminal is just not comfortable. It's not comforting to me.
Any other question?
Okay.
If you would, state your name.
Sure, my name is Eli Cohen. I'm an attorney at the Weatherington Law Firm. I think the goal there was that even the American Kratom Association, one of their big things is that the natural leaf doesn't produce a problem. So the goal there is to get to the amount of mitragynine and 7-OH that is in the natural leaf, which is what that study presented. So the study that the representative is referencing looked at how much mitragynine and 7-OH is in the natural leaf. And then we actually increased that slightly to give some buffer room, if you will, so that you just somehow your leaf was more stronger. I think the number is actually 3x, but it's still over 10 times less than what is in the current extracts that you saw me hold up here last time. So the goal is to keep not criminalize the natural leaf while ensuring that we get dangerous extracts out of Georgia.
And that's kind of where we other day during testimony, that what came out, and that's when we saw the research there, and that's how it was all plugged in together.
And follow up?
Yes, ma'am.
So I think that's still problematic, because it's like the unintended consequence can be, because we don't know what that amount is for sure based on with enough research, we could be putting people in a situation where they're facing a felony offense, and when proper research does come in and say, hey, this was an amount that was appropriate for their health or what have you, but they got a felony for a Schedule 1 drug on their record.
If they buy it normally over the counter, it won't be a Schedule 1. It won't be allowed to be sold. That's the thing about it. A consumer will be able to buy it over the strength. So every time they go to the store and buy something, it would be legal. The only way it could be illegal is, and it wouldn't go after the person, if the person, let's say, had the kratom and decided to sell it themselves on the street or something, and made it stronger, then it would be a felony. Or if the manufacturer decided to up the strength and not label it, or up the strength and label it over the strength, that'd still be a felony. That's where it's going to. So it's not going after the consumer at all who's just buying it off the shelf. That consumer is protected, and they're assuming that label is correct. That's on that, what they're buying in the purest form. So the consumer is totally protected in that. It's just the bad actors who are not doing the labels. It keeps the bad actors from doing what they're doing now. They were told 4 or 5 years ago and agreed to label everything correctly. And even the American Kratom Society's own stamp of approval were on bottles that didn't have the properly labeled bottles. So you didn't know what you're getting. It was, as I called it, the Wild Wild West. As the head of poison control, Dr. Lopez called it Russian roulette. This takes that away totally. This protects the consumer. No felony one for them at all, unless they decide to make it stronger themselves and resell it on the streets. Then they'll be like a drug dealer because they're reselling it at a stronger level on purpose.
Okay, so
they're lacing it. It'd be like somebody lacing marijuana or something like that, and getting, hurting people.
Okay, so I just want to be on record. Like, I want to support and I want to find a way,
Yes, ma'am.
but there's certain aspects that's not comfortable for me. So let me just keep working through it.
Yes,
and
ma'am.
See how we go through this process.
Good, yeah. Thanks. Good question, and hope that helped too.
Representative Fleming.
Thank you, Mr. Chairman. Representative, thank you for your efforts to make this about labeling. I think we're heading in that direction.
Yes,
and
sir.
Behind the counter and several of those things that I thought were probably a good idea. The question I'm trying to figure out, and Councilor Cohen may be able to help us, but on Section 2 is basically the size of the pills and how potent it can be, right? I mean, that's what you're trying to deal with there. I think
Basically the leaves, the leaves, and you can turn
Just
that
the
into powder
leaves
as well.
there?
Yes, the whatever product, it's based on what you would get in the leaves, and then again it would be increased, I guess, 3 times the amount there.
But that
based on
is
the
where
research.
someone knows how strong the pill can be in the bottle,
Correct,
right?
yes,
Okay,
sir.
all right. That's my point. So if you violate that by selling a pill that's too strong, then you flip over to line 84 with the felony that we've also discussed. Any person who sells in violation of this code section shall be guilty of a felony, correct?
If it's a manufacturer, distributor, or seller, if they know, yes. If they know what they're selling, when they put it out there, it's like you, if
Well,
I'm answering correctly.
Now you're heading toward my question.
Okay.
I'm just trying to figure out this point. I'm
Okay.
trying to figure out who we're making a felon here.
No, it's
so
it's not the consumer.
manufacturer does a bad job. The seller, the store owner buys it. Let's say, for the sake of our discussion, they think they're selling the right stuff, but the manufacturer hadn't done their job.
Then it'd be the manufacturer.
Why not the seller? He sold it.
It would also be the seller, but that holds true with current products liability law as it sits in Georgia.
Well, this is criminal law. We're talking about a felony here.
I understand, but the idea that a seller should know what they're selling, especially when the whole idea is that this thing becomes a drug when it's too powerful and it's killing people. And so if you want to sell a drug, you should take a little bit of time to know what's going on your store shelves before you sell it to Georgians.
And so the store owner, who the manufacturer says it's 0.5 for lack of better terms, but it's actually 0.6, and he didn't know that, he committed a felony when he sold it.
So you're saying if it's labeled 0.5 and it's
That's
actually
right.
0.6?
Yeah, I mean that's my question.
That is currently how the bill is written. Yes, sir.
Okay.
Yeah. That would need to be clean. Yeah.
And so,
But that's it for all crimes, right? Intent. Going back to the question earlier, intent is always an element of a crime, right? You have to have that guilty mind. So, thinking about it again, it actually, and where's my defense attorney over here? Might actually not be a crime. In fact, if you don't have the intent, so that is the knowledge.
So
portion.
intent doesn't have to be in this language we're looking at for intent to be an element of the crime.
I think that's the $64,000 question.
Yes.
Because
Thank you, Mr. Chairman.
as I interpret 84 through 87, it's sort of a strict liability.
It is strict
Okay.
liability. I was saying intent is not an issue.
So that part needs to be cleaned up. I mean, if I'm hearing correctly, because the intent, the way I'm looking at it, and I'll take the hit for that one. But no, if it's labeled correctly, if it's labeled incorrectly and the seller still sells it, yes. I mean, if it's labeled, point 8, point 9, and they sell it anyway, yes, the seller's in trouble. But if everything's labeled correctly, packaged correctly, everything else, that's on the manufacturer. That's not on the seller. And so if that's not the way it reads, then we'll have to change that.
And the other thing, Mr. Chairman, that's already been covered, so I'll just mention it, is that this idea of how much is too much, I agree we need to drill into that. I do want us to limit too much, but I want us to make sure we've really decided how much is too much before we do that. Thank you.
Thank you, Chairman Fleming. I noticed one, Brian had brought to my attention too, on line 77, 78, I think the packaging has to have clear and adequate directions for consumption of the product, including recommended serving size in the amount that can be safely consumed. Is that something we're still not sure of, or do we know what that is?
I think the science is not there to tell you what kratom is safe, right? Which is why this is a problem in general. But I think if you're a manufacturer and you're going to put something on a store shelf, you should have to tell the consumer how much you think should be taking. And frankly, put your business on the line and stand by your decision to sell that product. Because if you can't even stand behind your product and say, this is safe, then you shouldn't be selling it in the first place.
Representative Reeves.
Representative Townsend, will you walk us through the decision to do the behind-the-counter provision rather than Schedule 2?
Yeah, originally one of the options was another substitute we were looking at based on conversations internally. If you make it a Schedule 2, then it had to be prescribed by a doctor. After Chairman Stevens spoke, we went to him again and a few others. Even though council said in Georgia we could do that, legally make it a Schedule 2, we still worried about the pharmacy and the license and the federal laws, if that would supersede what state law would say. So based on that, we didn't try to make it because FDA still hasn't recognized it as an approved drug or even a drug. So that's why we went that direction, Chairman Reeves, in that direction.
And Mr. Chair, if I could ask a follow-up. So the purchasers are going to get carded when they come in, and the products will be behind the counter. And you do have a bifurcation. You're going to have something in Schedule 1 that'll not be behind the counter. It won't be sold. And then the stuff that is sold, it's going to be behind the counter, and minors will not be able to get anywhere near it.
Correct.
Thank you, Representative Reeves. Chairman Silcox.
Thank you, Mr. Chairman. So we know that kratom is a poison, correct?
Yes, it's highly addictive.
And we know that it kills people.
It does.
Why should we sell it?
I agree. Because when we went through this process, I wasn't sure if this would make it through because people were concerned about the felony and banning it totally. So let's get the next best thing. Let's first protect the consumer, and let's get back to the table after that. What I want to do to make sure for now is, if nothing else we do in this session, is protect the consumer to where they know what they're buying. They know they're buying this dosage level. They know that. They understand that. So it's their choice if they buy it or not.
But to Representative Neal's point, if we don't know whether it's the correct amount for sure,
just that,
then it may still kill somebody, right?
It's based on that research article. There's no guarantees of any type drug or whatever else.
That's all the questions. Thank you.
Thank you.
Thank you, Madam Chairman. Any other questions for the sponsor? Representative Fleming.
It's Chairman Silcox's fault. She triggered another question. So I understand what Chairman Silcox was saying, but here's the problem I have with banning it outright. If you drink enough alcohol, it will poison you. Alcohol will kill you if you drink too much, yet we continue to sell it because when used properly, as the scriptures say, a little wine makes a merry soul. And so I've never taken kratom, and I don't intend to, but I have heard people testify that it has some properties that can help, particularly when people are trying to get off more powerful opioids. I know that's in the scientific discussions, which I'm not qualified to talk about, but that's why I am not willing to vote to out and out ban it based upon where we are now. Thank you.
Mr. Chairman, Chairman Smith.
Well, to my fellow Baptist friend, I don't think they're mixing that wine with kratom. back then. I tell you what, we might need to go to Bible study next week and see if Representative Gamble and them can enlighten us on what they were mixing that wine with.
I'll bring the snakes.
I'll be making a back door. Thank you.
Thank you, Mr. Chairman. Anything more, Representative? I think we've got a witness also to hear from.
Okay. Yes.
What I thought we'd do is we'll
there's
hear from the witness, and then if you wanted to propose any amendments or changes, we can then discuss those.
Okay.
Is Cody Smith stayed with us? All right, come on up, please, sir. Just have a seat right there and say your name for our viewing audience, and then tell us what you.
Mr. Chair, there are a couple witnesses. I'm not sure if they signed up or not.
I only see the one, but we'll be sure to get to him.
Yes, my name is Cody Smith, and I'm somewhat of a constituent of Mr. Townsend. I have a business in his district. My personal experience with Kratom, not my own, but people I know, they do use it to get off of opioids, correct, but a little bit is too much because it's highly addictive, and the tolerance, you build up a tolerance so quickly that you're constantly taking more and more and more, chasing that high or chasing that euphoric feeling. And when you take too much, you end up becoming lethargic, and to the point where you could, your heart and your lungs can slow to the point that you die. So that is definitely a big concern. I haven't seen the new bill as proposed. I saw the original, and I trust Representative Townsend's direction that he's going with the bill. I've seen the negative effects, and then also in my professional life, I have a hemp retail business, but we sell strictly hemp products, no nicotine vapes, no kratom products. But the unsavory clientele that comes in looking for it's people that are, they can't get their opioid fix, so now they're just trying to get their kratom fix. And we've had issues with the customers that come in causing issues with surrounding businesses. So we've never sold it, we don't sell it, and we don't plan to sell it. And I support the regulation of it. And I'm open to any questions as well.
Thank you. Thank you very much for your testimony. Well, don't go. I don't see any questions yet, but I want to make sure I give folks an opportunity. I don't see any. Thank you so much for your testimony.
Absolutely. Thank you all.
All right. Are there some other witnesses who wish to testify? Come on up and identify yourself for us back there also.
How are you, everyone? My name is Matt Weatherington. I'm an attorney. I've been with you a couple of times to talk about some legal issues. What I wanted to do today is talk a little bit about, number one, is answer any questions that you guys might have that you feel are unresolved. And number two, to talk a little bit about the pursuit of perfection. So here's what happened. Right this second that you have a bill that this body has already passed that says that all kratom on the shelves currently is legal, good to sell, everyone, let's go. That's what you've already passed. We keep talking about putting the cart before the horse of we don't know what the science is, we don't know what the safe dose is. Are we really going to endorse this product at this level versus that level? You've already done it. You've already said all kratom products currently on the shelves in Georgia are safe and can be sold. That's what you've already done. What we're trying to do now is pull that back and get to a safe place. The obvious answer is to ban all kratom products until they have met their burden of showing that it is safe for people to use. You heard from and I want to remind you of what has the testimony that you've already heard. You've already heard their paid scientists tell you there is no FDA-approved usage. There is no testing that supports it in humans using it. That's their own words, not mine. So that's where we are right this second. But I recognize that there are political realities and practical realities here, and we don't want to criminalize people who are using a product that may not have completed the full FDA testing yet. If they themselves find that it is useful to them, it's their body, their choice, whatever. That's fine. If that's what this committee decides is appropriate, that's your decision, and I support whatever you want to do. However, what you have here is a product that is sold at 10, 20, 30, 40 times its natural baseline. On the shelves, it is killing people. These are the extracts or the elixirs or the powders that are enhanced that you're hearing about. So what have we done? We went back to the limited science that is available, and we used AKA studies to say, what is the baseline of the actual plant that people keep talking about that they do find usage from? What's the level of metrogenine and 7-OH that's in that baseline product? Okay, if that's the bare minimum that you are saying is useful and safe, then let's give them a little bit of a buffer so you can use the plant if you find that that's appropriate. Let's put in some guardrails for labeling of that plant, and then let's get the stuff that has been synthetically altered to become addictive and deadly off of the shelves. This is a very light measure to just get the most dangerous stuff off. And I want to be clear on that that's where we are. Like, I understand and respect the questioning of why would we do this at all? Why would we say 3 times the natural plant? Why not 1.5? Why not just the natural plant itself? Those are reasonable questions. But what I think we can all agree on is that the pursuit of perfection is not the goal here when we've got products on the shelves right this second that are 10, 20, 30 times the baseline, and we all agree, including the American Kratom Association, including the doctors that they had testify before you, and all the advocates on our side as well, telling you they're deadly. At least get the worst actors off of the table. And so happy to answer any questions anyone has.
Thank you. You do have a question. Is it Representative Neal? Representative Kendrick, sorry.
So my question is for lines 84 through 87, and you might not know the answer to this, but let's take a drug that we already have, outlawed right now. So pick any drug that you want. What is the penalty for being guilty of a felony? Is it the same 15-year fine, 15 years and $100,000? Do you know? Is it comparable? Is this comparable to a drug that we've already have outlawed, or is it harsher?
I can answer that question in about 90 seconds, but I don't know off the top of my head. But I will circle back to you very quickly with an answer on that. But I can tell you that this was modeled off of an existing drug, but I want to make sure that that drug wasn't an exception too.
Okay.
Any follow-up?
No, that was it.
All right. Thank you, Representative Kendrick.
I will add as well to Mr. Fleming's comment on the specific intent. The easy answer here is on 84, to just drop a knowingly after a person who knowingly imports. So just change the element right there to knowingly. And then that would solve your concern about a person inadvertently getting something. And I might have your answer already too. Let's see. Okay, yeah. So Title 16, Chapter 13. Is that what you've got right there? Is that you already have Title 16 in front of you, don't you? Oh, sorry. 16, 13, 30. I understand. I thought you were in the code section for the solicitors earlier. I got you. The answer, though, is to Representative Kendrick is yes, it is similar.
So that was it is similar to
yes. The other drugs that are Schedule 1.
Okay. All right. Representative Reeves?
Question, since we're drilling down on 84 to 87, what about limiting that subsection D in those lines to the Schedule 1 kratom?
I believe that is what this does.
The 16, 13, 25 Schedule 1 kratom.
Then I'm going to have to defer to Mr. Cohen to answer that question specifically, because I think I gave you wrong information.
Selling kratom that's too powerful will just be a Schedule 1 and will track the normal violation of Schedule 1 drugs. That code section applies particularly to those who sell kratom, that is a drug that meets the dosage requirements, but do it in violation of 122.
Well, but okay, in 121, we're letting certain kratom to be sold behind the counter, right?
Yes, sir.
All right, but in 16, 13, 25, Section 1, we're saying that defined elixir, I think, is what Representative Townsend says. That's not going to be allowed to be behind the counter. That's off limits. That's Schedule 1. What about just having the criminal penalties on the Schedule 1 elixir, not, the behind the counter kratom. I mean, it looks to me like Section 4, lines 84 to 87 applies to any kratom rather than the Schedule 1 kratom.
It doesn't, and because it goes back to Section 2.
Goes to the
I believe.
definition in 1613
The
120.
definition, that's right, sir. The definition of kratom is kratom that is not Schedule 1. Uses more words than that, but that's what it is. And why those other provisions should have criminal implications is because there needs to be enforcement. We already know that just putting a kratom law in the books and asking nicely for sellers to follow it doesn't work. We need an enforcement provision to keep Georgia safe.
At the initial hearing, I think kratom was used for what is being defined as Schedule 1 and the elixir as well as the others, so I have concerns about that.
So, make sure I'm following this, and I apologize, I'm probably the slowest one here, so you're gonna have to spoon feed me. In the first section, you're defining Schedule 1 kratom, which is basically the higher concentration
Yes, sir.
of it. And then in Section 2, you define the kratom that can be sold legally, which is basically more of a natural concentration plus a margin to allow for some variations.
That's right. So Section 1 specifically says that any compound with these two drugs, mitragynine or 7-OH, with above this concentration is a Schedule 1.
Schedule 1.
And then in Section 2, we say what kratom is. In Section 2, that is 1613-120, already existed. We're just narrowing the definition from all kratom only to kratom that is not Schedule 1. That is meets
That can be legally sold provided
And
these
then it applies-
labeling and safeguards are followed.
And then it applies the existing consumer protection guardrails that are already in place to that new definition.
Okay. All right. Thank you. Representative Neal?
Although my counterpart thinks my recommendation is too hasty, I'm going to propose it anyway. So the number one concern that everyone that testified agreed on is that this should be a labeling bill. Like, that is what is the one thing that's definitive when it comes to absent of everything else. That's the one thing everybody agreed on. So,
May I push back on you a little bit before you get to the next point?
well, let me finish it and then
Then
push back
yes.
against me. Okay. So I'm thinking, if this is supposed to be, if one of the main goals of this bill is labeling, if we were to narrow our focus, with the exceptions of sections 1, 2, and 3, focus on Section 4, 53 through 53 through 83, and tackle the labeling portion only, add an additional section that criminalizes anything being unlabeled related to kratom, misdemeanor, felony, misdemeanor of a high aggravated nature, you name it, because drug deals will fall into that too. Bad actors will fall into that too. And that makes it where we can exclude having to worry about amounts and studies and things that are not there. We focus on the labeling and make it where the people that need it can get it because it's labeled properly, sold properly, and the people that fall into the bad actor category create a section for that purpose of the fact that if you don't have it labeled at all, that's the crime, instead of criminalizing something that hasn't been properly studied yet. Would that be something that anybody's open to?
So we certainly understand. I would say that there's actually two things that all sides agree on. One is that kratom should be properly labeled, and two, that enhanced kratom is dangerous. Right? My quote that I gave you guys last time was that Mr. Haddow said that enhanced kratom should be recommended to the FDA Department of Justice for prosecution. Right? So it's both of those things. We're trying to handle both of those things. We already have a labeling law in Georgia that's not working because one allows extra strength kratom to be on the market, and two, no one's following it. So I think we need to. I think that the right play is to deal with both of those issues that actually both sides agree on. That overstrength kratom is a problem and proper labeling is important.
Okay, thank you.
Thank you, Representative. All right, any other questions for these witnesses? Representative Reeves?
I'm not digesting this. All right, so Section 4, lines 84 through 87, says if you sell kratom, quote-unquote kratom as defined under this new statute in violation, then you're a felon. And then kratom is defined in Section 2 as the kind of kratom that is allowed to be behind the counter, right?
Yes, sir.
So Section 2 does not define the Schedule 1 kratom, right?
Correct.
All right. Then why are we not criminalizing the Schedule 1 kratom, which is now not defined as kratom?
It already is. It is already a crime to
sell Schedule 1. So, all right, in addition to criminalizing Schedule 1, you were saying if you sell the stuff that's behind the counter, apart from what's in the code section, then you're criminalizing that.
Yes, sir.
Okay.
This is part of the enforcement as well as the labeling piece. So to address Neil's concerns.
So the felony,
Representative Neil's
the felony applies both to Schedule 1 and the behind the counter under the current version of the statute.
The Schedule 1 is a separate kind of kratom. So you could, in theory, sell a kratom that it meets the correct dosage requirements, but fails to have the proper labeling that is required. And that would be that would not be a violation of the Georgia Controlled Substance Act for possession of a Schedule 1. It would only be a violation of Section 122 as written here. So in fact, you really couldn't violate both because either the kratom is above the dosage requirement or it isn't.
Thank you, Representative. Chairman Silcox.
Thank you, Mr. Chairman. So you just said that currently no one is following the labeling, correct?
Yes, ma'am.
So if we change the labeling, are they going to follow it then?
Not without an enforcement mechanism.
Which we have now.
Which we don't have in place at the moment.
This would give you, but this bill would give you that.
Okay, thank you.
Thank you. All right, any further questions? Sort of thinking it might be good if we could land the plane here in some fashion. I have a Chairman Smith.
Mr. Chairman, I'd like to make a motion at appropriate time.
Well, I'll go ahead and entertain a motion.
Do we have any additional witnesses?
Oh, well, that's right. We haven't signed up, but we did have two. Let's go ahead and hear from them, and then so we'll just hold that in your pocket.
Thank you.
Thank y'all. All right. Who wants to go next? You want to go?
Thank you, Mr. Chairman and members of the committee. My name is Jerry Keene. I represent the American Kratom Association here in Georgia. I would love for Mr. Haddow, who's texting me and blowing my phone up and watching this hearing remotely, who feels he's been misstated numerous times. I've got some remarks he's sending me. I won't bore you with all of them, or I could get him real quick on the phone and he could talk for 3 minutes, or I can read to you some of his remarks. But they oppose the bill for numerous reasons. They want to work with the author. We've had some language out there. We just got this bill, 2 hours ago now, and they're still trying to read it and digest it and respond to it. And so I don't know what the motion the good chairman's going to make, but if no final action is today, then we'll have a chance to at least respond, get with the author, and give him our comments.
Well, I don't know that I necessarily want to get where we're having someone testify by telephone.
Okay.
But if you would like to read his comments or just make your own comments, I certainly would entertain.
Yes, sir, Mr. Chairman. Thank you. As I said, we represent over 1.5 or 15 million Americans who use kratom and 200,000 in Georgia. If you remember, we had numerous ones here at the testimony. Just a couple of real quick things. The DEA has rejected multiple attempts by the FDA for the scheduling of kratom. The Assistant Secretary of Health at HHS rejected a second attempt and recommendation, calling it embarrassingly poor evidence and data. And finally, the Expert Committee on Drug Dependence at the UN Commission on Narcotic Drugs, of which the U.S. is a treaty partner, voted 12-0 that there was insufficient evidence to justify the scheduling of kratom. The thing about the 7H and the levels in that, extracts are also in powder form, not just liquid. They take on many components there as well. the packaging requirements, and we're all for labeling, would be larger than some prescription drugs, which would affect the size of the package and the ability to be understood without a pharmacist, all those things you go through when you go get a prescription drug. The language would ban basically all extract products that otherwise follow the FDA extraction procedures using food-grade solvents that assure safety by removing contaminants. Extracts are pure and deliver a standardized amount of ingredients that can and are properly addressed with labeling on serving sizes. I think the one thing, if I could make my own remarks, is we've heard a lot of things, but one of the things is there is not clear science. For people to say this is highly addictive, there's not a lot of clear science to prove that. We have lots of Georgians using it every day, friends of mine in my age group that use it every day for a lot of reasons and safely. And while we want to get rid of the bad actors, we believe this version goes way overboard and would really restrict access, legitimate access to legitimate users.
Thank you.
And don't ask me any hard questions because I won't know the answer.
All right, are there any easy questions for this witness? I don't see that you have any questions. Thank you very much for your testimony. All right, I think we had one other witness. You want to come forward? You'll just pick a microphone and lean into it a little bit.
Hi, I'm Doreen Barr from Fayetteville, and I'm just a mom. 6 years ago, I lost my son, Ryan, to fentanyl. Now we want to label poison. What message are we sending to our kids when they can walk into a gas station or a convenience store and they can purchase a bag of Kratom, you know, along with other things, Delta 8, we won't even get into that look like Oreo cookies? If kids can walk into a gas station and buy this freely, that the Kratom and the Delta 8, it's packaged sitting at the end of the candy row in a school zone with a daycare right next to the building. What message are we sending? If it's poison, it's not safe. How many kids do we want to die? I know I would do anything to get my son back. Why are we even selling this in the first place? I just don't get it. That's it.
Thank you, ma'am. Any questions for Ms. Barr? I don't see you have any questions. Thank you very much for your testimony. All right. Anybody else? Any other witnesses on this bill? Make sure I don't miss anybody this time. All right. Well, I think we've heard from the witnesses. Did you care to say anything, Representative Townsend?
The only thing I can say is, as part of the research, look at the Mayo Clinic, Cleveland Clinic,
Come on.
Harvard Health. We went over that research last time.
Microphone.
I apologize. If you look at some of the research, Harvard Health, Mayo Clinic, Cleveland Clinic, went over some of that earlier. If you've seen the DEA drug sheet, I believe was in the last package you had as well, you received. It tells you more about that. And when it's right now being shipped over the United States, if Customs gets it, they burn it. They confiscate it. What does that tell you? When they confiscate it, you can't import it, something's wrong. And so that's why I know I need to clean up the language for this. Part of me agrees with you, Chair Silcox. I shouldn't have switched. I probably should just go for the ban. But right now, I want to protect the prosumers. I've got people back home, and that's what it's all about. And so I'm going to try to do the next step. Then hopefully we can have conversations this summer, this fall. Last time, this committee did a study. Unfortunately, that main proponent was a member of the House who's also a paid member, Vernon Jones, of Kratom. And so, you know, let's get something in place now. I'll agree to amend the bill however we need to do it to protect the consumers if we can't get a full ban. But if we need to go further in that over the summer to really dive into it and get your help and everybody's help, that's fine too. I'd love to do that, either as a member or ex officio. So there's not a whether I'm so I can't, you know what I mean. I don't want to. I want to make sure it's on a legit level and it's above board. And so whatever the best way to do that is, we'll do it. But in the meantime, we've got to do something now to protect the consumers. And that's what I'm trying to do with this bill. And that's the biggest thing. There is evidence out there about the dangers, how it is addictive. There is evidence. Mayo Clinic, Cleveland Clinic, Harvard Health, pretty well-respected institutions. And they're not paid by anybody to say that. The one piece of research I've seen so far from another entity, Johns Hopkins, it wasn't the institution, it wasn't Hopkins. It was just an adjunct doctor who's probably a great doctor. That's fine, well-respected. But still, you've got to say, I'm being paid for this research project. And I'm not saying he did anything wrong. I'm just saying, let's be out front and say, I'm being paid by this organization. And so that's where, that's all, Mr. Chair.
Thank you very much. All right. So that'll conclude the testimony part. At this point, what's the pleasure of the committee? All right, I've got two up. Representative Fleming.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to make a motion to table, and I'd like to explain why, if you would allow me to.
Yes.
I want to vote for a bill that regulates this. I want to vote for a bill that enforces it behind the counter. I want to vote for a bill that sets amounts, but I would like for the folks who sell this and know a lot about it to weigh in on that and give us a bill that we can vote on. This section 1 up here about the amounts, which I'm not clear on. This to make sure that we have the proper language about not making this a felony for someone who sells it because the manufacturer gave them something wrong. We can attempt right now in subcommittee to do some of that stuff, but I know that the clock is ticking, and if a sub is reached between the folks who know a lot about it and the author, and they bring it back to us, we could, if the chairman would allow, we can always hear it in full. It doesn't have to be heard in sub again now that we've hashed out some of these questions. So if the chair would entertain for those reasons, understanding that I want us to pass a bill, I'd like to make a motion to table at the moment with the goal of coming back to full committee with a bill after all the parties have had a chance to look at it and work out this language.
Thank you, Representative Fleming. I think what I would like to do is first entertain a motion to pass and see if there's a consensus to do that. And if there's not, then we can consider motions to amend or to table. Representative Saines.
Thank you, Mr. Chairman. I believe that the bill's been weighted and that there could still be a sub brought to full committee if this sub brought it to there in the meantime if there's a necessary item. But I'm comfortable with the bill as is, so I'd like to make a motion to do pass.
All right, thank you. So I have a motion to pass. Now, do I have a second? Second. So I have a motion and a second. All right. Any further discussion?
Thank you, Mr. Chair. I'd like to make an amendment at the appropriate time.
I think right now I don't want to consider the amendments. I want to see if we're going to pass it as it is. Well, no, I'll tell you what. That wouldn't make sense. Let's go ahead. What's your amendment?
My amendment is for on line 84 to insert the word knowingly after between who and imports, so that line 84 reads a person who knowingly imports, manufactures, distributes, and owns forth up to line 87.
Okay. So is just to be clear, is the amendment just the insertion of the word knowingly?
Yes.
Okay. And you said between who and imports on line 84?
Yes.
Okay. All right. Do I hear now I see Representative Neal's.
I have a motion for an amendment, but I think we need to do hers first.
Yes, that's what I would prefer to do if you don't mind. All right, so let's go ahead and consider that amendment. Is there a second?
Second.
A second, all right. So do we have a motion on the table to amend the bill by inserting the word knowingly between the words who and imports on line 84? And we have a second. Is there any discussion? If not, I'll call the question. All those in favor, say aye. All opposed? Nay. Nay? Where was the nay? Oh, okay. So Cox, so I think unless anyone needs a division in committee, it sounds like the ayes have it on the amendment. All right. Is there another amendment? Yes. All right, Representative Neal.
Indulge me, please. Okay. So, cutting sections 1 through 3. Keep section 4, lines 53 through 83. I'll repeat, cut sections 1 through 3. Keep section 4, lines 53 through 83. Adding and replacing section 84 to the end. And in that section, adding something that is along the lines of this. Any unlabeled kratom, over the counter or not, will be a misdemeanor of a higher aggravated nature upon second offense, a felony, or any version of that. The goal is to do this. Accomplish the goal of having an enforcement mechanism for the current issues of labeling not being addressed. The second issue is to misbar the witness. It's already illegal to sell this to 18-year-olds anyway, and what you showed us would violate the bill as I just amended it. It would also criminalize the bad actors you're trying to catch currently. But what it also does is it protects this body and this committee from having to agree to a bill that has amounts and numbers and all these other areas that we're not comfortable with. I feel like this is a blanket way to accomplish all the goals. And then once we get more information about the numbers and everything else, add those penalties later. But I think that can get this out of the committee and solve the initial problem and immediately start capturing the bad actors without having to wait another year to get it done. So I repeat, cut sections 1 through 3, keep section 4, line 53 to 83, add a section and replace the 84 to the end of any unlabeled kratom, over the counter or not. Make it either misdemeanor or make the second offense a felony or any combination of that. I'm okay with it. And I think that protects this committee and what we're trying to do here.
Okay. But I think if you're going to make an amendment, you can't say, I'm not sure that I have definite language.
Correct me where
to
I'm
you
wrong.
on lines 84, what you're proposing to replace 84 through 90.
Okay, yeah, so cut 84 through 92, add a section that addresses any unlabeled kratom, whether it's over the counter or not, either misdemeanor, felony, whatever this body chooses. But it protects everyone, it catches the bad actors, and it makes it where this body is just not picking random numbers out of the sky as to how much is bad and how much is good. It doesn't matter. If you label it wrong, if you label it properly and it's over the counter, you're fine. If you label it wrong or you don't label it at all, you're in trouble. That's it.
All right. Again, my only concern is I think we need some specific language for the amendment rather than whatever you want. So
any unlabeled kratom, and I'm sure the attorneys in the room can fix it for me. Over the counter, I know over the counter or not, shall be convicted of a misdemeanor or felony. I'm open to whichever one. Upon violating, the unlabeled aspect.
Okay.
And if the legislative council wants to chime in on language, I'm completely open to that. Or if it's something we can work together, I'm completely open to that as well.
All right. Let me, Representative Reeves.
Mr. Chair, I have an idea. What about voting yay or nay on the cutting those sections before we start lawyering the thing that would depend on that?
That's a good idea.
If
try
we
that
keep
first.
that in, then that we may not have to get into that.
Right.
So.
Gotcha. Okay.
So I would suggest we vote on your proposed amendment, which I think is to delete sections, basically to delete sections 1, 2, and 3 from the bill, and then to delete lines 84 through 90 of section 4. Or do you want to leave those in for purpose of your amendment?
Can we leave them in for purposes of adding my section?
Yes.
Okay.
So we would just delete sections 1, 2, and 3
For this first
for
amendment,
the,
yes.
for this amendment. All right.
And keep the, well, we can do it separate, that's fine.
All right, Chairman Smith.
I'll wait.
Okay. All right. So, so the amendment then is to strike sections 1, 2, and 3 and leave section 4 intact.
For now, yes, sir.
Okay. All right. So do I have a second for that motion?
Second.
We have a motion and a second. Any further discussion? All right. All those in favor?
Aye.
Aye. We have 3. All those opposed? Nay. All right. Why don't we show hands? All those in favor again were aye. We're 3 over there. All those opposed? I think that motion fails.
Yes.
All right. Do we have any other motions to amend?
We can go for sections cutting 84 through 92, or cutting and then replacing with unlabeling.
All right. So now the proposed amendment is to cut lines 84 through 90.
Yes.
But leave the rest of the bill intact. Is that correct?
I could be ambitious and add 1 through 3 back in there, but we've done
All
that.
right. Well, you're going to have to give me some specific
trying to
language,
give
or I'm
you
going to
two.
rule you out of order.
Okay.
So,
Cut 84 through 92 and replace it with any unlabeled kratom, over the counter or not, misdemeanor or felony, whichever way this body would prefer, as a violation.
all right. Any unlabeled kratom?
I'm not sure how any person who distributes any kratom, any unlabeled kratom, yes. I guess over the counter or otherwise, I'm not sure how we would properly put that in to the proper terms, shall be convicted of,
So any person who sells unlabeled kratom, whether over counter or not,
yes,
shall be guilty of a misdemeanor.
yes, and the second offense, a felony.
Upon the first offense, and upon second offense, a felony.
Yeah.
All right. All right. Do we have a second to that motion?
Second.
We have a second. Any discussion? All those in favor, raise your hands. Got 2. All those opposed? Okay, I think that motion fails.
It did.
All right. At this point, I would like to go back and rule on the motion. Chairman Smith?
I was just going to move. We call the question.
Yes, sir. I think so. So let's go back. I think we had an initial motion on the table to move due pass. One amendment has passed, which was to add the word knowingly on line 84, the Kendrick Amendment, as we shall affectionately know it heretofore. So is there any further discussion? I think that's the motion on the table. All right, no further discussion. I'll call the question. All those in favor say aye. Aye. All those opposed? Sorry?
Yes.
What was that? Opposed. Okay, so 1 nay. So Kendrick, so we had 3 opposed. So I think the motion passes. All right. So we have a due pass recommendation of the full committee. All right. Let's see, where are we now? House Bill 327. Thank you, Representative Townsend.
I appreciate the brevity of which your committee.
Yeah, I know,
moves.
sorry.
I miss the restaurant people. That's my favorite afternoon.
All right, Representative Cameron, thank you for being here today. You've got House Bill 327. Tell us about your bill.
All right. This bill comes about from my district attorney for Lookout Mountain District, Chris Laurent, who's with me today. He communicated with me that he had a case in the district that he could not prosecute. It was a case of incest for the step-grandfather and a step-grandchild. So from there, The Legislative Council got involved, and here we have House Bill 327, which seeks to add to Section 16-6-22 of the Georgia Annotated Code, the words step-grandparent and step-grandchild relationship, which was not in it originally. And that's the bill.
Okay. Mr. Day, did you want to testify to the bill also?
Yes, sir.
All right, why don't we go ahead and get your testimony, and then we'll ask questions of both of you.
Okay, thank you, sir.
Chris Arndt, I'm the current district attorney for the Lookout Mountain Judicial Circuit. The governor called me last week and informed me he's put me on the Superior Court bench.
Oh,
So
good news for you.
Replacement soon, but this particular case arose. We had a 16-year-old girl that her mom sent to live with her grandmother and her step-grandfather, who was in his mid-50s, who immediately began to manipulate this young girl into an unwanted sexual relationship with him, which went on for about a year and a half. When the young lady finally began thinking of ending her life, it finally came out. Luckily, we were able to get her in some good counseling with our Children's Advocacy Center and get her stabilized. The detective initially took charges, and when we looked at it, we had to dismiss them because the statute is very specific in the relationships that are prohibited, and there's case law that specifically says if it's not one directly set forth in this statute, then it's not prohibited. And step-parent is in there, but step-grandparent is not. So I called Representative Cameron and asked him to consider dropping a bill to fix that, especially in light of the relationships we have today, where you see so many families where they break up and remarry, and we see, again, because of that, so many grandparents and step-grandparents now involved in lives and having to raise their grandkids or sometimes great-grandkids. So the likelihood of this happening again and again is great. So I think we need to add that relationship into the bill. And in this case, again, we're not looking, this case there's real harm, and we're not looking to go out in situations where there isn't. My folks have 300 to 400 cases apiece, so we're not going to be going out searching for situations where there's not a harm like there is in this case.
Well, thank you. I think you've got a few questions. Representative Fleming?
Mr. DA, thank you for coming today. You said the young lady was 16.
Yes, so we couldn't charge her a child molestation if she's
Right.
over the age of consent.
So if this had been the grandmother's boyfriend living in the home and we changed the statute, would you have been able to prosecute?
No.
Thank you.
But that would, I think, I don't know if we could cover it broad enough to do that. But yes, there has to be some familial relationship.
Understood. Thank you.
Thank you, Representative Fleming. Do we have any other questions? All right. I don't believe there are any witnesses here to testify on 327. All right, so yeah, I will entertain a motion.
Motion to do pass.
We've got a motion to pass. Do I have a second? All right, I've got a motion and a second. Any further discussion? I'll call the question. All those in favor signify by saying aye. Aye. All those opposed? All right, the bill passes. Congratulations.
Thank you. So, sir, does it go on to full judiciary?
It would go on to full duty non-civil.
Okay, non-civil.
We try to take pride in that.
Yeah. Thanks.
Thank you.
And I passed the bill in the other committee too, so thank you.
Okay, good for you.
Hot shot.
All right. Representative Neal, did I see your light blinking? I'm sorry, I didn't. Okay, I just want to make sure I didn't miss you. Is Chairman Powell? Okay.
You want us to hand out the new version, or?
Yeah, it's Chairman Powell presenting. Does he have a substitute, Mr. Chairman?
I believe so.
Okay.
You want to use the new one? Motion for a smoke break.
Yeah, let's go on. I don't know if I've got one now. Mr. Chairman, good to see you again.
Oh, hell yes, good to see y'all. I'm sorry if I sound impatient.
All right. if you're ready, whenever you are.
I am. Ladies and gentlemen, I don't know which bill y'all want to use, since I've already been to this committee, the full committee, and I explained my proposition that we worked on for a couple of years. Y'all passed it out 3-9, and it's back in your lap now in the subcommittee. I think you should see a substitute in your file. Yeah. Substitute 9416S. And I'll be glad to answer questions from the first presentation to this committee. And I'll talk just briefly. I'm not going to be as lengthy as I was, because I've only been waiting for 3.5 hours outside. As y'all may remember, the first bill that I presented to this committee, we talked about the events of the last 4 years. Even more than that, when you go into the cannabis card, it was medical cannabis card. And 4 sessions ago, we passed this bill, and it has been the absolute worst exhibition of bureaucracy that I can imagine. I don't know anybody that disagrees with me, except for folks that might be a paid consultant for them that thinks certain things. But they've hired every lobbyist under the shining sun. Every one of them have. Which bears me to ask, this is a money issue, folks, like so many other things that we deal with up here. So, y'all may remember from the last bill, you had 2 Class 1s that were given a license before the TROs were filed. You have 4 Class 2 licenses that a TRO took into effect, while litigation is ongoing from just those protesters that elected to duly protest, that filed litigation. That's over in the Court of Appeals right now. It continues to drag on, and then there'll be the appeals and everything else. And all this was based on the failure of the Cannabis Commission, and this is what their litigation is about. I mentioned several things that there were problems with the Cannabis Commission. One was that they didn't think that they could to allow any information about how they operated to anyone, not even a standing committee of the House when questioned. To me personally, I have a lot of problems with that. When there's no sunshine and no APA in effect, that's what brings on a lot of bad things in the bureaucracy of this state. Now, that being said, the fix that we had was to put them under the APA, open records. We did have a section in there about creating an oversight commission. One of your members questioned that, you might remember, but it was basically Reg Industries for the House and Economic Development for the Senate. We added 1 dispensary to each location. They could have a dispensary at that location where they're growing on top of the other 5 dispensaries. We allowed them to sell other grow operations medical products. But most importantly, to get out from under the litigation, we figured that what we would do is allow them, the commission, to grant the 4 licenses already pre-approved and the 8 that had filed a protest. Is that a perfect solution? Nah, it's not. What we're having to do is make up for the inefficiency of a bureaucracy that just basically made a mess of things. Now that's the general gist of that first bill. The substitute that you see in front of you today, it's easier for me to tell you the differences in the substitute. And if you'll go to that substitute, Section 1, it does have, puts them under the APA, which that's the good news. If you look into Section 2, this means that they would then have to operate under the Department of Administrative Rules and Regs. If you go to lines 46 through 48, this would move any issues involving licenses to the business courts, statewide business courts. Line 62 to 67. This is the language that I spoke in the first bill that would provide for extra dispensaries of one on the premises of the folks that are doing the manufacturing. Line 106 is the same language I told you was in the other bill that I had, the original bill, to allows the selling of other manufacturers' medical products at their properties. Section 4 basically says that they still can't reveal trade secrets. Number 5, somewhere in between all of this, I'd be remiss if I didn't tell you, we took the legislative oversight out of it, the 2 committees. So that was taken out. Right now, under the current law, the Speaker can appoint 2 members and the Lieutenant can appoint 2 members. So apparently the powers that be decided they'd rather do that than allow a full committee to be doing an oversight. Section 5, this gets into the same language that I had talked about in the original bill, to allow up to 3 Class 1 productions, no more than 14. And then if you go to the next on Section 6, the same language again. Now, I would tell you that there needs to be a change in that, where you see on line 141, 3 licenses, that needs to be 4 licenses. And line 143, instead of 14, it needs to be 15 licenses to go to a maximum of 15. Because there's another company that has had litigation, but not with the original 8. So we've now ferreted that out since our last encounter here. So that makes it 15 licenses. The same on line 153, go from 6 to 7, and on 155, go to 15 instead of 14. And I bring that to your attention because if this new proposition that has been put forth goes, then that needs to be the correct number. So I would certainly recommend that. Section 7 deals with the open records law. Section 8. This is somewhat innovative. I would tell you that the language that you'll see in Section 8 is some language that I have been discussing with members for the last 2 years about how to go forward with other licenses. If the day comes or when it comes or whatever it may be, to go forward with more licenses. And what this says is that for every 5,000 patients of the low THC oil, there may be another license granted. Class 1 license for an increase of every 10,000 patients, there could be a Class 1 issued. And that would be may, not shall. And I would caution you about those words. As you know, there's a difference between may and shall. Section 9 deals with future protesters. I would recommend on line 209 where you see the word substantial, where it says the court shall reverse or remand any case for further proceeding if substantial rights of the appellant have been prejudiced. I would say change substantial to material. So it would read that if further proceedings, if material rights of the appellant have been prejudiced. Also on line 212, after the number 1 where it says in violation of constitutional statutory provisions, I would say or applicable procurement rules. Yeah, on line 212 after statutory provisions and add or applicable procurement rules. Section 10 and Section 11 deal with the appeal process as it goes to business courts, that it would be remanded to business courts and not the Fulton County Superior Court. So it would go to the statewide business courts. Line 253, Section 12, basically says every member of the commission shall file an annual financial disclosure statement, something that should have been done apparently 4 years ago. That, ladies and gentlemen, is the gist of the changes on this substitute bill. I do understand at the end of 128, I have been told that there has been some interest in some kind of other disease that I don't know how to pronounce. something about, you got it. You know, there's a lot of specific diseases in this bill, both mine and this substitute. We've got the ulcerative colitis, and then whatever this one, and that's the will of this committee, ladies and gentlemen. Now, that being said, I'll stand for the best questions I can. I think y'all all heard this bill before.
Thank you, Mr. Chairman. Just to make sure, you had recommended some changes, and we'll get to those later, but I want to make sure I kept good notes. I think was the first amendment to Section 5 to change on line 141 to change the word 3 to 4, and then down on 143 to change 14 to 15.
Correct.
Then on the next page, line 153, change 6 to 7, and on 155, change 14 to 15.
Correct.
And then I think the next change I saw was on page 9, line 209. This is in section 9. That line reads, reverse or remand any case for further proceedings if substantial rights of the appellant. We would change substantial to material.
Correct.
And then down on 212, which currently reads in violation of constitutional or statutory provisions, we would add the conclusion of that or applicable procurement rules.
Correct.
And then I
And
believe.
Then if it's the will of this committee, they want to add the other disease to it, have at it.
That would just be added as, I guess, an R. Was it myasthenia gravis?
MYASTHENIA, and then gravis is GRAVIS.
V or B?
V is in Victor.
Okay, V is in Victor. So I guess we would need also on line 287 to strike the or and then change the period in 288 to a semicolon and insert the word or there. And this would become R.
And then real quick, you want to strike or in this one too, in line 212. That would be in violation of constitutional, statutory, or constitutional, actually.
I think we can just add the phrase or at the end of that. In violation of constitutional statute. The question Brian was asking was on line 212 if we needed to add some commas, but I think we can leave that in violation of constitutional or statutory provisions or applicable procurement rules. I think it would make sense grammatically if that's the will of the committee. All right. All right. Thank you, Mr. Chairman. Any questions for Chairman Powell? I don't see. Oh, Representative Reeves.
Statewide Business Court, that's new since last time we heard it, right?
That is correct.
And none of the prior litigation ran through there?
No.
Okay.
Thank you. Chairwoman Silcox.
Thank you, Mr. Chairman. So is it true that this would still award the additional licenses to people who protested?
You know, since this wasn't my handiwork, it says may not shall.
Okay.
So, you know, everybody's got to judge for themselves. You know,
Okay.
I sound like I have a lot of angst about the handiwork of the Cannabis Commission. I certainly do. You know, I ferreted through this, our committee, Regulated Industries, ferreted through this issue for 3 years. No questions would be answered.
Mhm.
They stood behind their rights that they said the original legislation. They said that the original legislation said they couldn't. I disagree. I think that was more in the tune of trade secrets, because I find it hard to believe that the General Assembly of this state is going to give up their rights to pass legislation and then not have some say about what in the world has gone on. And I don't know that if there's anybody that's got any disagreement that this has been a dysfunctional process.
Do you think, Mr. Chairman, that this would prevent additional litigation?
You know, when I talked about at the start of what I was saying, I talked about this is a money business. You know, originally the General Assembly, what we were trying to do was to put this product out there to help sick children and citizens of this state that it had been deemed that this product was worthy to give them some kind of relief. I know that when we originally started it, It was supposed to be all Georgia-based companies. Well, we had some Georgia-based applicants out of the 69. We also had some out of Florida and other places. There's a lot of subterfuge that went on in that. So, you know, what happened, it happened.
Do you think it's possible, Mr. Chairman, if we gave out too many licenses, that the market would be flooded and the black market would take over and it wouldn't be regulated and safe?
No, ma'am,
the way
I
we
do
want it?
not.
Okay.
And the reason I say I don't is the black market is going to prevail anyway. We reached a certain point in here, and if you look at all of the specifications, even in their veiled attempts to do a rule and reg process a few weeks ago, my understanding the commission was going to try to tag a $40,000 license fee on the companies that test this product. That's kind of cost prohibitive, you know. But then I understand that only one of the licensees owns one of those down in Florida. When I talk about money, this has turned into money for these folks. So do I think that it's going to drive it to the black market? Maybe it will. Probably will, because of the price that you could probably go out and somebody could probably go out and buy this stuff cheaper, like these families that do these pressing parties on Saturdays. Some of these folks that have the children that they have found that the cannabis oil is good for, they do pressing parties like a Tupperware party. They go buy their pot or whatever, and they put it in. They try to do whatever they do, and they press it and get the oil out of it. That's regretful. That's an indictment on a failed system, ladies and gentlemen of this committee. It's a failed system. But to answer that one step further, I believe in the free market. I think that the more of these operations, if you had the 20 which would stand, if you looked across the country, across this country, wherever you have medical cannabis, these grow and dispensary operations, based on population, Georgia would be right at 20 if you looked at the calculations across other.
Over time, you mean? Over
Florida's
time.
got twice the population of Georgia. They
Right,
got
but
40.
right now we only have how many on the registry?
On the cannabis registry has dropped.
Less than 20,000, really?
Because of the failure of this system. When it did this 7 years ago, there were far more people who had paid the health department, their doctors for a prescription, and the health department to get a card. But 7 years into it, a lot of them have said, why would I waste another $35? So I'm a free market person. Let them operate, let them produce. One of the things I've learned more in the last year or so has been that with all the advances in the cross hibernation and all of this kind of stuff that I really can't tell you all about,
right,
was that a lot of these cannabis operations have specifically narrowly focused on certain diseases and illnesses. So you may have some that are doing certain type of diseases and others that may be doing others. That's the reason in the bill I recommended allowing them to sell the other companies' products if you're going to treat it truly as a medical product.
Thank you.
Thank you, Madam Chairman. Representative Neal.
Yes, thank you to the chair. So I guess the question for me is, you mentioned how this was changed from shall to may.
And the new bill,
Yeah.
or the substitute you're looking at, when it puts that formulary in there, basically it says may.
And that's not what you wanted, right?
It makes no difference what I want. I'm handling the substitute.
So, but I thought when it comes to accomplishing your goal, is it appropriate to switch it back to shall?
Can make that determination.
Where would the switch need to happen? Is it 140, 141, 152, 153? To put it back to the original?
It would be in that formulary, and that would be up to this committee, but I'm not asking this committee to do that.
Mm-hmm.
Please understand that I'm a product of the legislature. I understand politics, and I understand the philosophy that water runs downhill. There has been apparently discussions made that this is a better idea. I can accept that, because one of the things I accept is it's better to move forward with something than nothing at all. And hopefully during the legislative process, whether in this process or when it gets to the Senate, that there'll be some corrections made. But if nothing else, that we put this commission under the APA and open records so that we can see what's going on, that they'll be held accountable for the errors that was done.
Follow up. So, and I guess we can talk about this later. I'll pull you to the side. But when it comes to the goal, I thought one of the goals was because of the litigation with the 8 individuals. The switch of may to shall could be problematic, because I thought the goal was to give the licenses to those people specifically, also because they had a majority minority aspect to each of those entities as well. That was the reason to make it where it was shall, so we'll make sure they are granted the same benefit to include they have minority participation. So I'm trying to get an understanding of what the implication would be now, because if it switched from shall to may, they might not be guaranteed that, and so other people that don't.
As I understand it right now, by giving them the tools, the Cannabis Commission may, if there's enough pressure levered on them by the powers that be, they may decide to fix what has been created.
Thank you, Representative Neal. Chairman Saines.
In terms of, I appreciate you tying the demand to the patient number. In terms of if one of the current licensees were to say, if new licenses were issued, if one of the current licensees were to say that would violate their rights in terms of reducing their license, is it not true that they've signed a contract that prohibits them from seeking a reduction in value to their license?
You're absolutely right, and I would say a big BS
And
on that.
if they were to do that, knowing that what they've signed, could we have confidence that everything else they've signed to ensure that this product stays safe in the market and doesn't fall in the right hands, and that they've regulated correctly? If they can't be trusted to follow a simple line, could we trust them to follow the other regulations that we've accounting for them?
Thank you for bringing that point up, because I've heard all the veiled threats that's been made by the lobbyists, and I can assure you that this Cannabis Commission, they got more lobbyists hired than Georgia Power does. I mean, literally. And I've heard all the threats, and I've heard the innuendos that's been said. Oh, well, if y'all do if you go the path that my original bill, if you go that path, well, we're going to sue for diminished value. Oh, no, it doesn't work that way. There's plenty of case law. We are the General Assembly. And if we stay within the constitutional groundwork of things, we have a right to change the laws. I've always told people the reason the General Assembly convenes on the second Monday of every January is most of the time to fix the stuff that needs to be fixed that wasn't done right to start with. That's what we're doing. And I thank you for that question.
Thank you, Mr. Chairman.
Thank you. Any other questions for Chairman Powell? We've got a number of witnesses that want to testify, so I want to get to them. All right, thank you, Chairman Powell.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee.
All right, I'm going to ask witnesses, we have quite a few. I'm going to ask you to limit your comments to 2 or 3 minutes each. Jeremy, is it Jeremy Berry?
Yes, thank you.
Which microphone? Oh, there we go. I think that one's on for you. Just make sure you kind of lean into it a little bit.
Thank you, Mr. Chairman. Good afternoon or good evening, as it were. I'm Jeremy Berry with True Leaf Georgia, Inc. I'll try and be as quick as possible. And with me is Lisa Pinckney, who's the president of True Leaf Georgia. I'd like to offer a few clarifying comments after the subcommittee met a couple weeks ago. We have not had a chance yet to fully digest the bill, but we'll appreciate all that this subcommittee is doing and others are doing to move this along. I want to offer some initial thoughts and then I'll move quickly. But the first is True Leaf Georgia is ready to produce low THC oil and is ready to go in a matter of weeks. We need the dispensary license and can have product on the shelf in a matter of weeks. Additionally, we appreciate all that is being done, but, and to the earlier question, I remain concerned that litigation will not end if this bill is signed. In fact, the attorneys who testified in front of this committee just a couple weeks ago filed another lawsuit last Friday. That is the 26th lawsuit that has been filed by the protesters, the 26th. I'm going to go through some numbers in a minute, but I wanted to make sure that everyone understood that the lawyers who sat before this committee a couple weeks ago turned around and sued the state yet again. Again, TrueLeaf Georgia is a Georgia company. It's 60% minority-owned and 80% women-owned. TrueLeaf Georgia operations and businesses will bring hundreds of jobs to Adel, Georgia and surrounding counties and millions of dollars of revenue. TrueLeaf will be the largest employer in Adel, Georgia, and has already spent millions of dollars to construct the facility. Again, with me today is Lisa Pinckney, who's the president of TrueLeaf. She has over 30 years of experience in the healthcare industry. She's been a small business owner for 18 years, a disadvantaged business owner, and a minority business owner. Other notable members of TrueLeaf Georgia, first is Champ Bailey, the University of Georgia football star and Hall of Famer. Another is Tommy Dollar, who's a third-generation peanut farmer. If Georgia football and peanuts aren't more Georgian, then I don't know what else is. As I said, TrueLeaf Georgia is ready and able to provide Georgia patients with low THC oil and can do so as soon as the Cannabis Commission grants a dispensary license and lets that process begin. I understand the need and desire for bringing low THC oil to the market and know how many patients will benefit. A family member of mine has used low THC oil. I understand it. This is personal to me as well. It's not just about profits. Let me give some numbers. The first is 578. That's the number of days that have passed since the Cannabis Commission issued the Notice of Intent to Award 6 contracts. The next number is 154. That's the number of days since the Commission issued the contracts to the Class 1 companies, TrueLeaf and Botanical. The next number, one that this committee's never heard, is 284. 284, that's the number of pages that the protest hearing officer issued in the 7 decisions denying the protest. 284 pages of decisions from a judge. The next number is 26. 26, that's the number of lawsuits that the protesters have filed. There are currently lawsuits pending in the Georgia Court of Appeals, in Fulton Superior Court, other superior courts, and now the 11th Circuit. 26 lawsuits. The final number is 0. 0. That's the number of ounces of low THC oil that have been sold to Georgia patients since the Georgia Hope Act was passed in 2019. And I'm trying to be conscious of time. I'll move quickly here. The protesters received incredibly low scores, ranging from 6th place to 18th place in Class 1. Those low scores reflected serious concerns about their management experience, about job creation, about diversity, about the support from local government, about product safety, about the tracking system, and about their security. We should not reward those protesters with additional licenses. We should not. They knew the rules going into the procurement. They agreed to follow those rules, and they lost. As part of my practice, I do a significant amount of government contract work. Right now, I have a $350 million DCH protest pending. My advice, if this bill passes, will be to tell every one of my clients, just keep suing. We'll go to the legislature, keep suing. In 2014, I represented someone bidding on the state health benefit plan. My advice will be keep suing until the legislature throws you a lifeline, because that will be the message if this bill passes. There was an incredible, thorough, and deliberate process. As I said, there was one protest hearing officer, a judge with 17 years experience, who all she did was hear cannabis cases. All she did. 284 pages of decisions. The protesters had unredacted copies of our clients' proposals, unredacted copies of the proposals. They had hearings. They had opportunities to submit evidence. And without fail, the judge denied every one of those protests. It is time to move on, and it is time to bring low THC oil to the patients of Georgia who deserve it and desperately need it. Thank you.
Thank you, Mr. Berry. Do the members of the committee have any questions? Representative Kendrick?
Thank you, Mr. Chair. And maybe this is a clarifying question for Representative Powell. So it's my understanding that the reason that we are not getting the low THC oil to Georgians is because of the lawsuit. So I'm sorry if I missed that, but to the speaker that just spoke, isn't it true that if we don't do something to try and get rid of the lawsuit, then we're still at the same point where we're not getting the low THC oil to Georgians?
You're exactly right.
Okay.
And I think he answered his own question. He's a litigant. He's filed on behalf of a client. Everybody's got a right to sue if they've been wronged. Now, maybe I misunderstood it. He said that when the hearing process, that they got unredacted copies
Yes, they received copies of our proposal.
of every bit of it without any redactions.
We received as much of they received as much of TrueLeaf's proposal as TrueLeaf received of theirs.
But it was not unredacted.
I will say this, the rules, the
as
protest rules that they agreed to said that they could see the proposals only if they showed a need. The protest hearing officer therefore concluded they did not meet their burden and only saw limited parts of the proposal. We saw the same parts of their proposal as they saw of ours.
Which was it was redacted.
They were unredacted.
It was redacted. All of the information that we were able to ferret together in the committee was it from the protesters that came and talked to us and testified in committee, that everything was redacted, all the points. Remember that one of the problems of this is the process. There was a numerical process given, so that when all these people who filed, you could have had all of them that filed the same answer on security or job creation or whatever. But somehow, magically enough, it appeared that some of them got 1 point, some of them got 5 points. So there was no rhyme or reason to this. So, there was the purpose of the litigation. Now, the gentleman, I'll be as good as he is. He wants it to make it look like, well, woe is me. These folks are filing suit, and that's what's stopping the process of people getting low THC. That's not correct. If you ever abrogate your rights when you've been wronged in a process or otherwise, then it affects everybody.
Representative Kendrick, if I may, a couple thoughts. The Class 1s have signed contracts. Our client is performing right now, has produced cannabis, and is ready to produce oil the second they have a dispensary license. We're ready to go. The Class 2s have been held up because of the lawsuit. Our client has not filed any lawsuits. We're a defendant in every one of these. As I said before, there was a process. The hearing officer evaluated whether the protesters had shown a need to see our unredacted proposal. Unredacted. And let me step back because folks may not be aware of it. Every applicant submitted a redacted copy and a completely unredacted copy. One of the protesters, 96% of the protesters of a certain protester was redacted, 15 pages. The hearing officer said, okay, make a case to the protesters why you should be able to see an unredacted copy of the application, and I, the hearing officer, will make a determination. And she did. We had to produce the same proposal, the same parts of our application as they did, and in some instances, they saw probably more than half of our proposal. Some of it is security stuff and stuff, frankly, that I don't think anyone wants to share with each other. I mean, these are competitors, how you secure your business and whatever else. I will tell you, though, some of this was glaring. Our client, for example, in some situations, produced 35 pages in their response on certain sections. Other companies produced 4 pages. So the answers were not the same for each of these, and that's why the evaluation committee, who evaluated every proposal, scored the way that they did.
Thank you, Representative. Representative Reeves.
Thanks, Mr. Chairman. Mr. Berry, a couple of questions. On page 6 of the bill, line 140, it mentions 2 initial Class 1 production licenses. your client is
I'm
one
sorry,
of the.
will you repeat the
Sure,
line
page
number?
6, line 140, it mentions 2 initial licenses, Class 1 licenses. You see that now?
Yes,
All right.
yes.
And TrueLeaf, your client, is one of the 2.
Correct.
Right. And your client and then one other are the only 2 who got licenses without a TRO being granted, right?
Correct, and I would go further. We have signed contracts, and Mr. Olins is here from Botanical, the other Class 1 license.
Okay, so there were 2 who got actual contracts pursuant to the 2019 law. Your client, Mr. Olin's client, y'all have contracts already. There are an additional 4 who got awarded, and that's the subject of the 8 companies' protest, and now apparently there's a 9th company for a total of 15, right?
Sorry, I'm not sure if I followed the math, but
Sure.
yes, there were two were awarded. 2 Class 1s have contracts. 4 Class 2s, and again, they have representatives here who can testify as well, do not have contracts.
Sure.
The reason they don't have contracts is the protesters, without giving notice to the state, as they were required to do, sought TROs and failed to give notice to the Attorney General, as the law requires. They got TROs. Every one of them was dismissed because the courts acknowledged they didn't have jurisdiction to even hear the case.
But your client and Mr. Olin's client, the 2 initial Class 1 licensees, are not subject to a TRO and have a contract.
Correct,
All
correct.
right. Some follow-ups. Business court, is this the only instance where a party would be required to go to the new business court without 2-party consent?
Judge Walt Davis, who's I guess the former judge, is a friend. I haven't looked at that issue well enough, but I do know that has been a concern with the business court. That ordinarily I think both parties have to consent to end up in business court. So if that law remained as it is, then I think any of the companies dragged into business court could object, and we'd be back in Superior Court.
All right. The Court of Appeals case that's pending or being requested, is your client a party to that?
We are. Those cases have been docketed. Briefing is just now starting.
Who is the panel?
I don't know. None of that's known. The cases are just docketed, so briefing is literally just now beginning.
Okay.
I don't believe we know any of the panels.
How would this legislation affect your client and Mr. Olin's client who already have contracts?
It's an excellent question. I would need to sort of dig in further and understand. I think in part it would change the rules of the road. Everybody knew what the rules were going into the bidding process in 2019 and 2020. It would change that considerably. Obviously, it could allow for additional licenses, and it's not clear to me that need is there yet for additional licenses.
If you have your license, what's the difference in having 6 competitors versus 14 or 15 competitors?
I think it's a supply and demand issue. I think right now the legislature, when they passed the HOPE Act in 2019, determined that 6 was sufficient. Right now, if my math is correct, I guess there can be 300,000 square feet of grow between the 2 Class 1s and the 4 Class 2s. Oh, no, 400,000 square feet. The patient, I guess Chairman Powell said it was under 20,000. I thought it was 25,000, but I think it's a chicken and egg issue. Let the patient population grow as the licensees put oil on the shelf, and once we do that, then we would have more, more licenses. I mean, for example, I told you I'm working on a DCH procurement right now. It's for 1 contractor for DCH. Could 2 do it? Sure. Could 3 do it? Absolutely. But DCH made the policy decision to go with 1.
Thank you, Representative Reeves. Chairman Saines?
Thank you, Mr. Chairman. Thank you for coming to testify. I'll now be transparent. I was hesitant about this policy when we enacted it in the legislature, but to something that was said earlier, a little wine makes a married soul, I understood there could be some benefit. I'm more hesitant now that we've seen the repercussions. Who is JT? Do you know JT Burnett, and is he affiliated with TrueLeaf?
I have no idea who. I'm happy to find out. That name doesn't mean anything to
My
me.
understanding, in terms of what has been asked by Discovery, is that he's the CEO of TrueLeaf's husband. Do you know that to be false?
I don't recognize the name. Correct.
All
Yeah,
right.
I don't.
Okay.
I'm not agreeing or disagreeing. I don't
Gotcha.
recognize the
Well,
name.
if my information's accurate, the individual was sentenced to 3 years in prison with a $1.2 million fine in Florida for medical marijuana and leveraging personal relationships with the legislature. I know it has been asked, so I'm going to ask here. I guess you don't have that information available, but I wanted to know if he was a vendor in y'all's application, because to me that would put in jeopardy my confidence in terms of the ability to reputably regulate the.
Understood. I can say with full confidence he has no involvement with True Leaf Georgia as a vendor, as an owner, or anything.
Thank you.
Thank you, Chairman. Any other questions of these witnesses? Ms. Pinckney, did you want to say anything?
No, I don't.
Okay.
Thank you.
Well said. Thank you, ma'am.
Thank you all.
You're going to be the favorite of the committee. Thank you so much.
Thanks.
Is it Derek? I'm sorry, I'm not sure. With FFD Georgia?
Yes, sir.
Bauer.
Good evening, everybody.
Just lean in there a little to the microphone.
Absolutely.
So our viewing audience can pick you up there.
Good evening. My name is Derek Bauer. I am a partner with the law firm of Baker Hostetler. I represent FFD Georgia LLC, which is one of the 4 Class 2 presumptive license winners. They were the top scoring Class 2 applicant. And they are, as Representative Reeves pointed out, among the 4 who won the procurement in Class 2 but have not been awarded contracts or licenses because of the litigation. First of all, let me just say I've not been down here during the session before, and I'm just supremely impressed with how you all conduct your business. It's been a long day for me watching, but a very educational one. So thank you for what you do. FFD Georgia, it's a Georgia company. Its CEO is one of the University of Georgia 50, which, as I understand it, is the 50 fastest growing companies owned by University of Georgia alum. This is a Georgia operation. Mr. Powell said better to move forward with something than nothing at all. In this particular case, I will say I think the substitution bill is better, but it is still deeply flawed. I say it's better because the original bill, while perhaps well-meaning, was blatantly unconstitutional. You all are, as I've heard many times throughout the day today, a body that passes general laws, and the Constitution of Georgia says we can't pass specific laws. The original bill was very much so a specific law and unconstitutional, and it would have not ended litigation. It would have spawned, for the first time actually in the history of this procurement, meritorious litigation. And I'll circle back to that, but I say meritorious litigation because all of the appeals that are pending right now, all of the lawsuits that are holding up the completion of this procurement process, all lack merit. They will all be dismissed, as most of them already have, in due course. And so I think that's the right place to start. Mr. Powell talked about how horribly flawed this commission, how it's failed. And I feel like we need to start there because I don't think that is the reality in this particular situation. The commission worked really hard to evaluate 70 applicants. I think it's interesting that of 64 losers for a procurement that's unprecedented in the state, this is a nascent industry. Clearly, this is about money, right? Clearly, this is going to be a profitable enterprise for these companies. 70 companies wanted to be the first to provide this product to patients in the state of Georgia. 64 of them lost. That's how procurements work. Of the 64 that lost, less than 14 or 15 were the only protesters. So you had over 50, more than half of the people who applied for this, who accepted the decision of the commission because they knew it was correct. And many of those that did not choose to protest scored much higher than the 8 that are continuing to pursue litigation here. And what that means is under that original special legislation, that first incarnation of the bill that was before you the last couple of weeks, this committee would have been saying, we are going to give additional licenses to 8 protesters who were not among the highest qualified applicants for this important, unprecedented procurement because they protested. So let's talk about the process and how it worked. Yes, this was a unique procurement under Georgia law. Much of it was different than the procurements you've seen before, and a lot of it was fairly not subject to open records. That was by your design. You all passed the bill that said we want to do this, and presumably, and I wasn't here when it happened, but presumably that was out of recognition for the fact that you've got a handful of companies in the world who are engaged in this industry. They have spent millions, if not tens of millions of dollars to develop expertise, equipment, personnel to do this. In order to encourage them to be as forthcoming with the commission as possible in these applications, to tell the commission, this is who we are, this is how we do this, this is our experience, this is how we learned to do this nascent business, you had to protect them, right? You had to encourage them to give candid information to the commission, and every one of those 70 applicants did so. The commission had unredacted information. The competitors who were competing against each other, they did not have access to each other's applications for very good reasons. But once this went to the protest process, the rules empowered the commission and its designated hearing officer, who, as Mr. Berry said, is an administrative law judge who has served the state of Georgia with distinction now for over 17 years with the Office of State Administrative Hearings. She had an advanced nursing career before she became a judge here. She spent the entire month of July listening to the protests and ruling on them. And the commission and you empowered her to decide what information the parties got to see. And the truth is, she unredacted about 98% of every single application that was before her during the protests. And those were shared with the protesters. So the notion that the protesters have been deprived of information, or the commission didn't have good information, or was behind closed doors, or most important, that the independent administrative law judge who reviewed every one of these protests did not have good information, and all the information is false. Every single grievance that those lawyers brought to you a couple of weeks ago for the protesters, every grievance that is presently before the courts of the state of Georgia challenging this process as flawed and failed, was argued thoroughly to an independent administrative law judge, Stephanie Howells. Every single one of those grievances was systematically reviewed, argued, heard in a fact and evidentiary hearing, and then rejected in a 45-plus page decision for each and every protest. The judge addressed every single grievance and said, there is no merit here. The commission got it right. So the process continues. As is their right, the protesters, there were 15 of them, are allowed to then appeal Judge Howell's decision, which was, again, an evidentiary hearing, to the superior courts. Some of them did so. Half of them said, we get it. We had our day in court. We put our best foot forward. We made these arguments and we lost. And they've gone home. 8 of them, maybe 9, did not. 8 of them decided to exercise their right to appeal to the superior courts, and they did so. And that's where this is now. So my understanding is that this legislature is loath to tinker with legislation that is presently being litigated in the courts. We'll let the process run its course. We have a superior court judge who's about to decide whether Judge Howells and the commission got it right or got it wrong. And we have Court of Appeals judges that are going to decide whether the process that you all decided would be used to do those appeals was right or wrong. If you pass this bill, what you are going to do is merely invite more litigation because you are changing the rules of the road midstream. All 70 of those applicants relied on the rules that you created. They followed them. The losers didn't like it, and now they want the rules to change. But you can't change the rules after the fact without having a material negative impact on the parties who followed the rules and put their best applications forward. So it will conclude. It will conclude soon, and ultimately this product will get to the patients sooner. But this bill, this substitute bill, will be a roadblock to that. If you're going to slow it down, this is the way to do it. Let the appeal process run its course. The litigation will conclude, and the process will have functioned as it was supposed to, and independent judges are going to tell you that. Thank you.
So I'm sorry, are you opposing the substitute or opposing the original bill in favor of the
I'm opposing them both. I think this subcommittee should not. We are. This subcommittee should not tinker with a process that is almost concluded in the judicial review process. right? This is not the first procurement that's ended up in litigation. We're almost to the end of it, right? The appeals are there. We've weeded out the ones who have accepted the results. There are a few very vocal and well-funded protesters who are going to keep fighting this till the bitter end, but that bitter end is right around the corner. These judges are poised to make their decisions. Let them do it. And if you think there's a need for more licenses after this is up and running, give it a year. Let's see how many people show up on the registry. Let's see how much demand there is. Then you can open it up. But right now, you don't have any data to support a decision to increase the number of licenses, much less to give them to people that the commission, an ALJ, and soon a number of judges in the state are going to say, we're not qualified to receive this procurement.
Thank you. You have a question, Representative Kendrick?
Thank you. And again, this might be a question, clarifying question for the author. So because we're changing it, we changed it from shall to may. Isn't it true that, to your point, that we might be giving it to unqualified people? Since we changed that language, it is possible that the commission could not give it to those people that are otherwise, you say, disqualified or didn't have the correct scores. Am I misunderstanding?
I don't think so. But I think, we've only just gotten the substitute a couple hours before the hearing. But I think what that provision says
You had
now,
it before a lot of members of the committee.
That's true. Well, it's who you know, Mr. Chairman. I think what that provision now says is that the commission has discretion to issue a limited number of additional licenses if certain thresholds on the registry are met. So the way I read this now, it says, here we are increasing the cap. We had this, the original HOPE Act said 6 licenses, 2 Class 1s, 4 Class 2s. This says we're going to increase those caps for each class by a certain fixed amount. And the commission has discretion to issue the additional licenses up to that cap if certain thresholds are met based on data, on need. If patients sign up for this and we need more licenses, the commission may issue them. That's how I read that.
Okay, so the question that I'm asking is, to your point, you're saying that there were some unqualified people or people who did not get the highest scores. So since we changed it from shall to may, I'm just pushing back on your point that some kind of way we're automatically going to give them licenses because we changed that language.
Yeah, I don't think that's in here anymore.
Okay.
I need to study it, but I did not see anything in this substitute bill that says the commission either may or shall give the additional licenses to unqualified applicants.
Okay.
I don't think that's in here.
Okay, I just want to clarify that point because that's what I thought you were saying. My other question was, I'm not familiar too much with the pending cases right now, but you notated that you knew that these cases were going to be dismissed, and I'm trying to figure out how you know they're going to be dismissed.
Because I'm a good lawyer, and the law on these has been settled, right? So you've got 2 kinds of cases. One that are the proper mechanism for review of the commission's decision, right? Those are in the Superior Court of Fulton County on what's called a writ of certiorari, and I won't get into the weeds on it. But basically, you've got the Superior Court of Fulton County that sits in like an appellate position. So it's before Judge Krause on the Fulton Superior Court. She's not going to retry the case. She doesn't take evidence. She is confined to the record that Judge Howells had in the hearing below. And she's basically going to look at it and say, was there any evidence to support Judge Howells' decision, or was her decision arbitrary and capricious? And I'm telling you, there was a 45-page decision or more by Judge Krause in each one of these protests in which she systematically went through every grievance and explained why they were completely lacking in merit. And in a number of cases, because the applicants were so unqualified, she said, even if I credited all their complaints, they would not have won an award. They were that far out in the scoring that they could never have qualified. So I think it is, I would bet my youngest child's college fund account that Judge Krause is going to affirm Judge Howell's decisions in each of those protests.
And can I ask
Yes, ma'am, go
one
ahead.
more question? With respect to the scoring process, so I understand your argument that the scoring was so far removed from the winners, but we've been hearing testimony about the defect in the scoring process. So both what you say is true, and it could be true that there was a defect in the actual scoring process, so that if two applicants had the same information, they were scored differently. And so I would expect a judge to come to that decision, but there was a defect in the actual scoring process in the first place.
I'm so glad that you asked that question. And I would encourage the good representative to go read Judge Howell's decisions. They are public decisions. They are available either on the OSA website or on the Commission's website, but they're all public documents. Every one of those arguments was made to Judge Howell's. She had unhindered access to the entire record. Every application, all of the score sheets, all of the information that was used, every argument by the protesters that the scoring was arbitrary and made no sense was made to Judge Howell's in an evidentiary hearing with pre-hearing briefing and post-hearing briefing. And she systematically addressed every single one of those arguments. And in her order, she explained, this isn't true. This isn't arbitrary. Here's why that scoring happened, or if she couldn't explain it, why it didn't matter. But every single one of those grievances has been argued. The protesters have had their day in court, and they're about to get their appeal in court. There's absolutely no basis for the legislature to step in and say, particularly after the governor gave additional funding to the commission to pay for that administrative law judge to spend the entire month of July hearing these protests. She devoted an entire month to this. Why would the legislature then say to her, we don't care about your evaluation of this on facts, on evidence, on argument. We're going to take it away from you because some protesters came in here and complained. They've already made those arguments. That's the judicial process. That's how every procurement works. You don't like how you got scored, you challenge it. If you don't like how the challenge goes, you appeal it. And if you don't like what the judge does, you're out of luck. That's how every single procurement works, and that's how this one is working.
Can I bookend it by circling back to my original point, which is your argument seems to be based on the fact that the original language that we had in the bill, which was shall, which would have awarded it to these protesters. But now that we've changed it to may, you can't make the same argument, I don't think, that that we're awarding bad behavior because we've changed that word from shall to may. So
yes, that particular defect was cured, but there are other major defects with the substitute bill. Mm-hmm. Right? You can't possibly know at this point how much need there will be for additional licenses. We just don't have a clue. I mean, I feel like you would want to make this decision based on good data, and there's no reason to make it now when nobody's even started offering the product. The six companies that were selected as the best qualified to do it. But I think the bigger problem here is you're trying, this substitute bill tries to change the entire rules of the procurement after the fact, but before the procurement has even been completed. So, Mr. Powell said, well, now this makes it subject to the Administrative Procedure Act, but you guys designed a process that was a little different the first time around. Now it says everything the commission has is subject to the Open Records Act. Well, I think the problem with that is you're retroactively changing the rules of the game after companies have relied on the process that you created the first time for no reason. This notion that the process needs to be fixed, again, I think is fundamentally wrong. The process is working, and it's about to come to a conclusion in the courts, and I would urge the committee to let that happen.
Can I ask one more question? And I just drew a blank. Okay, never mind. I'll come back to it.
Thank you, Representative. Just to be clear, as I read the bill, this is not mandating the issuance of anything other than the initial licenses that were authorized in the initial act.
That's how I read this as well.
It is authorizing additional licenses if the demand is there, if there's additional people on the registry.
I read it that way too. I do think that the thresholds in here are not based on data or good facts. I mean, they seem arbitrary, and I do think they are way lower than the thresholds any other state has to expand the issuance of licenses. And that's why I think the committee would be well served to wait and see exactly how the first production goes, how many patients you have before you. So
is your argument that number is just bad policy, or are you arguing it somehow violates some procurement rule or reliance of your client?
Yeah, that's just, I won't say it's bad policy. I'll say it's uninformed policy at this point.
Fair enough, yes, sir. I just wanted to clarify your position.
Thank you.
All right, Representative Kendrick, like a dog with a bone over there.
Sorry. Okay, I remember my question. So, so you mentioned that we're might be changing the rules of the game midstream. So I think these contracts, do they last 5 years? Am I correct? They last 5 years. So, if this bill were to pass, are you saying that you would be amicable to keeping the same rules that you have right now, some kind of way being grandfathered in? This is hypothetical. And then being subject to whatever rules we pass under this legislation when the time it comes up for renewal. So your issue is having information and submitting your bid under those terms, and now having to submit under other terms.
Well, my client already has a notice of intent to award, right? It's already the top score on Class 2. It's just waiting for the litigation to resolve so that the commission isn't handcuffed from issuing the contract to it. So I don't anticipate my client would ever need to reapply for anything, right? They were the best of the Class 2s, and they're the winner, just waiting for the courts to give the commission the go-ahead. I think there are two problems with this with respect to changing the rules of the road. With respect to my client's interest, I think the main problem is creating a process on the front end that said, you all can submit your information redacted to the commission so that it's not subject to sharing with your competitors and not subject to basically pirating. And this is a big problem for this industry, because what happens is whoever wins a procurement of this significance, the competitors then want to take those applications, steal what trade secrets and proprietary design information they can, and use that to win the procurement in another state. So there's a real need to protect the trade secrets of these companies, and you designed a process that encouraged them to be as open and transparent with the commission as they could be when they submitted that information. This substitute bill now says, we're actually changing our mind about that. And after you've already given a huge amount of confidential and proprietary information to the commission to enable it to make a good decision, we might take that protection away from you, or at least in part. And I think that is a recipe for litigation. You've got a lot of companies who are going to say, you can't do that. We relied on the promise of the state that it was going to keep this information confidential, and now you're telling us you're going to change that rule. I think that's going to invite a lot of litigation.
Could you point what line that is?
Sure. It's going to be section 7. So we're looking at lines 164 to 171. And what you'll see here, Madam Representative, is that the original bill said, look, everything that you've given to the commission as part of this procurement, the HOPE Act, other than information that the commission publishes in an official report, it's going to be confidential. It's not subject to the Open Records Act. But any contract that we issue is going to be, right? So this provision said to the applicants, we understand that you're a novel business and you may not want to share highly proprietary and technical information about your business with your competitors. So what you send to the commission on this, so that we can see what you really are doing and how you are going to do it, we're going to keep it confidential. When we issue the contract, when we decide you're the winner and we tell the world you're getting a license, that all is going public. But what you tell us about your business, we're going to keep confidential while we evaluate these companies. That has now changed in your substitute bill. And it now says, and it doesn't address retroactive or whatever, it just says, nope, everything that was sent to the commission is now subject to the Open Records Act, which is a major game changer for those companies that relied on your promise to the contrary when they submitted their application several years ago. And I think that is going to invite litigation. I also think it's unnecessary. Everything that the public needs to know about these companies is going to be in that contract and will be subject to open records. Thank you.
Seeing no other questions, thank you for being with us today.
Thank you, sir. Appreciate you. Thank you.
All right. Let's see. Next, Attorney General Owens. Emeritus.
Well, it now is good evening, so good evening to all of you, and thank you for your time. I didn't really mind the hours that these hearings took. What I really minded more was the hardness of the floors that you walk on every day. My first session, I got plantar fasciitis thanks to the designers of this building.
It's rough on the knees too, Mr.
Well, yeah, and I only have one that's really worth talking about. So thank you, Mr. Chairman. I want to go a little bit big picture. I'm not going to be as sharp on some comments. I'm the outside counsel for botanical science. There was a maximum of 1,000 points. We scored 970. One of the companies that would have gotten a license under Chairman Powell's prior version got a 578. A 578. That doesn't get you to become a lawyer in Georgia. That doesn't get you much, but it would have given them a license to grow medical marijuana. So it's really important that, in fact, there be a rigorous and thorough process to determine who gets the licenses, because this is a quality health issue. At the end of the day, it's a health issue. When those patients buy the low THC oil, you as a representative of the state are telling them it's safe. I would suggest to you a 578 score is similar to taking an SAT and putting your name on the page. That's not reassuring to the citizens of our state. Our client, you've heard from some folks, one in particular at the prior hearing, talk about these companies aren't Georgian. My client is a career doctor at Piedmont Hospital. He practiced with Chairman Silcox's husband. His whole medical career is Piedmont. The facility is Glenville, Tattnall County, because when you read the original version of House Bill 324, it encouraged you to go to Tier 3 and Tier 4 counties. Our applications replete with MBEs, with women-owned, with everything that was desired when y'all passed House Bill 324. Satisfy all the requirements and more. Part of what was stated earlier, so at times when we'd be doing this compare and contrast, as folks were saying they weren't fair. They weren't fair. Well, one company, for instance, had 6 pages of local support. Half of them didn't relate to the county they were going to. We had like 35. We had the sheriff. We had the police chief. We had the board of commissioners. We had the development authority. We had all the local hospitals. We had everyone in the entire area with local support. Yes, that does get you a different score. That's the way it should be. Incidentally, factually today, there's 27,000 patients on the registry. That's the number today. Because during the course of this hearing, Chairman, I was able to ask how many are on the registry. It's 27,000.
You would have had time to do quite a bit of research, I think, during this hearing.
Yes, Chairman. It created a lot of sloppy writing, but yes. So you have a thorough review. You have companies that disagree. That's their right. They file a protest. Per the legislation, a hearing officer is determined, that being a very experienced OSA judge. And as you've heard before, the opinions were not 5 pages. They were long, and they were small print, too small print from my perspective. And you find words in those opinions like, the arguments were without merit. The arguments were unpersuasive. You don't see a close call. You don't see a single report by the hearing officer that says the evaluation team messed up. You've been told they did, but that's not what the hearing officer determined when she literally took a lot of time to make those decisions. Licensure by legislation is about as bad an idea as you could have come before you. Tell me another type bid situation where people that sue the state because they're unhappy get a reward, and not based on merit, just because they sued. What lesson are you telling folks in the future? And once again, I'll reference the 578. And yes, there were 6 scores in the 600s too. I'm just telling you what the lowest score was. So we have a signed contract. As Mr. Berry said, the 2 Class 1s have a signed contract. We're rolling. In the next month, the GMCC will send out applications for dispensaries. They will likely send out the application for a lab, and we're rolling. We expect to have all licenses in place April of this year. We expect then to be able to dispense April this year. And with regard to the litigation, and this was the subject of a question by Representative Kendrick, I expect all that litigation over this year. Keep in mind, as you know, on the House Judiciary Committee, this is, I know, non-civil, the standard is in any and all evidence. You have like a 45, 50-page report by a hearing officer that says nothing was wrong, and you're then telling this judge, overrule those 45 or 50 pages. Highly unlikely. Could it happen? The moon could not come up tonight, but is that something you want to count on? No. So where are we now? It's been reviewed by the GMCC. It's been reviewed by the hearing officer. A bunch of courts have already ruled against the protesters. There's not a single court that said GMCC did anything wrong through the state. Just more litigation, but not a single court has gone with the arguments that you've been given. Not one. I'll repeat at my peril. April will be able to dispense product. The only thing we're really waiting on is the issuance of the dispensary license, the lab to do the test, and then to sell to the needy patients in our state that have been waiting for it. That's the only thing we need. So in April, we're selling. We already have folks on the ground confirming locations, both with independent pharmacies, for dispensaries through the company, anything and everything consistent with your law. We followed House Bill 324. There have been numerous comments, and I'm sure you'll hear more, that the law was wrong or etc. Our job's to follow the law. We did. Now there's some people that want to change the law. That's the process. I get that. But if you go up to GMCC, they will tell you that there were applications, the pages looked exactly alike. Because where you permit unredacted parts of an application that deal directly with trade secret information, that's used in their next state's application if that company got a higher score. And GMCC will tell you point blank, they noted pages that were identical to other applications. That's why the open records issue is a real issue here. And as Mr. Berry stated, some of the very companies that have come up to you criticizing the redactions redacted more. I mean, literally, 96%. I don't even understand how you could come up with that being a valid response. So that's the vast majority of what I'd like to share with you. Automatic licensure without a rigorous review is malpractice. No new doctor walking into a hospital gets to show his license and get hospital privileges. And no applicant, because they sued this state, should be given a license without demonstrating the need. Now, Representative Reese, let me go back to a question you asked, God knows when. 15-5A-4 is the jurisdiction of business courts. To date, all those courts require consent of all parties. This was not worded in such a way that I really know whether 15-5A-4 is applicable or inapplicable. I don't think a lawyer could literally tell you 100% the answer to your question because it's not clear in this version of the bill when you look at the existing law. I would suggest to you there's a really strong argument that you'd still have to comply with 15-5A-4. But I would tell you from my perspective, it's not an issue. Because from my perspective, I would totally trust the judge in the business court. He frankly used to be in the state Senate years ago. But I just don't know the law as to whether you could do it that way. But in final, this was not a fly-by-night process. I know you've been told that by each company that's unhappy. Every company that loses a bid tells DOAS that and tells folks in the state of Georgia that. But I would ask you, especially after an OSA judge serving as a hearing officer does thorough reports saying these opinions, these prior actions are valid, please give her the benefit of the doubt for the time we asked her to put into this case. Thank you very much for your time.
Thank you, sir. Appreciate your testimony. Representative Kendrick.
I'm shocked.
Thank you, Mr. Chair. So I'm going to ask you the same question that I asked the last speaker. Do you agree that because we changed the language from shall to may, that there is no guarantee that if we pass this bill that we're going to award the people that you're saying are making the 500s and the 600s because we changed the language from shall to may? So they can award, one extra license if they want to. They can give it to somebody, maybe outside of who you're talking about.
Representative Kendrick, as a general statement, I think you're right. But I would tell you I'd be more 100% sure if the language of the proposed bill you're asked to vote on specifically said GMCC makes that call. What you have now is a may. The question is, who is the may that makes the decision? And in the version in front of you, it's silent. And I think that is it doesn't say GMCC may. Now, I don't have the bill in front of me because, frankly, I wasn't one of the blessed that got it hours ago. I got to stare at it a couple seconds at a time. But I think the may is much better than shall, but it needs to be clear that it's GMCC that's the may.
It says the commission. Am I missing something? It says the commission, right?
Yep.
And as I'm saying, I don't have the bill in front of me.
There you
Thanks. What
Page 6, line 140, 141.
And 153.
I'm sorry, this isn't the bill.
Oh.
I'm sure it's a nice bill.
Oh, no.
Thank you. Page 6.
In section 5 there, the beginning of the actual enacted portion on line 140.
You're correct. I stand corrected. I didn't have the bill in front of me, but you're correct.
Okay.
And I think that's a huge improvement because I don't want the 578 coming close to a license.
Mm-hmm.
I don't want the ones in the 6s either, and I'm not so sure I want the 7s.
Okay.
At that point. And the only other thing I'd say with your deference, Mr. Chair, in the new proposal, there's a new license for every 5,000 patients. I think we can all agree that there's a number upon which that should occur. I think we should also be leaving it to medical experts what that number should be. I have no idea where 5,000 came from. I have no idea whether it should be 10,000 or whether it should be 15,000. No one's told us where the 5 comes from. I know there's a desire to do more, and I think it was you, Representative Kendrick. In those states that have created vast oversupplies, yeah, there is diversion. There is illegal use of that substance. So please don't think that if you create a massive oversupply in the state, it's not going to be sold by some bad actors and be on our streets to folks that should not get it. That's human nature, maybe, unfortunately.
Any follow-up, Representative Kendrick?
Nope.
All right. Representative Reeves?
Who are those states? Is Florida one of those states? And if not, who are those states who do have an oversupply?
You know, candidly, I'm not trying to give you a bad answer or an unclear answer. I'm pretty busy dealing with Georgia law. And while I read articles that discuss it, I'm not comfortable in stating that an article I read is factually accurate in that regard.
Thank you. Any further questions of Mr. Olens?
Thank you very much for your
Thank
time.
you. Appreciate it. Chip Collins? There he is.
Good evening. Thank you, Mr. Chairman.
Good evening.
Members, it's late. Y'all have been here a long time. There's a lot of smart things that have been said, and so I will try not to repeat them. But there are a few things that I think need to get heard. But I'm going to try and tailor my comments to things that have been already said and questions that have been asked. But you've already gotten some really good information from my colleagues. But my name is Chip Collins. I'm an attorney with Byrne Foreman. I'm honored to have been representing Trevana Remedy, one of the Class 2 prospective licensees throughout this protest process. Just to be clear, Chairman, I am definitely speaking in opposition to both the substitute bill and its predecessor. First, let's just be honest about the group that's pushing this bill. And it's the applicants who went through the process but were not selected by the Cannabis Commission for a license. And specifically, the ones that are well funded enough to hire an army of lawyers and lobbyists to push both this legislation and also the lawsuits and appeals. But all these folks have had, as you've heard, they've had their day in court. They've had multiple opportunities to make their case. Chairman Powell mentioned bureaucracy. He said this thing has just been dragged down by bureaucracy. But I would put to you that what some call bureaucracy, we lawyers call due process. And it's inevitable in a procurement process. You're going to have a selection, and then there is an appeal process. And these folks have had multiple opportunities, and these folks being the losing applicants, to make their case. There was this detailed application process that you've heard about, thousands of pages in these things. The commission, duly appointed commissioners, experts in their various industries, examined all of these and selected what they deemed to be the most qualified applicants. That was the first bite of the apple. Second bite of the apple, there's an independent review by Administrative Judge Stephanie Howells, and Sam and Derek both talked about that. But she completely, well, first of all, she spent a lot of time, as you've heard, 14 hearings, I believe, in 22 days. I spent my whole July downtown. She reviewed everything. She unredacted, if that's a word, most of the applications. And after letting them say whatever they wanted to say in hearings for as long as they wanted to say it, she completely affirmed the commission decision and rejected all of the arguments that the losing applicants made and continue to make. But again, that's not bureaucracy. That is just good legislation. It's good procedure to have an independent internal review. But then it doesn't end there. You've heard about, well, there's all these lawsuits. How can we stop the lawsuits? Well, primarily, the lawsuits are just appeals. Again, a standard part of the procurement process. Nothing unusual about it. In fact, that's what we would all want, is to have an independent judge, Superior Court judge, review these things. And that's where most of these are now, in front of Judge Krause, Fulton County Superior Court. There's been no undue delay. I don't think anybody can even accuse any of these courts of having undue delay. They know it's important. And they're putting these cases at the front of the line. They're holding hearings. They're making decisions. The process is working. But then the due process doesn't end there. These unhappy applicants, then if they're dissatisfied with a ruling from the Superior Court, they get to apply for an appeal. It's not automatic, but they get to request an appeal to the Court of Appeals. Again, not bureaucracy, just due process, the way all procurement processes work and should work. So they've gotten to do all these things. And frankly, I'll tell you, they've lost at every turn. In fact, I think just about every decision that's come out on any issue has come out against the appealing applicants. So now what are they doing? They're not having any luck in court, so they're trying to conduct a legislative end run of the appeal process. And the chairman's telling me he's going to hold me to my 2 or 3 minutes, so I'll try to just hit some of the high points. I'm way past the 2 or 3 minutes. I understand completely. There was a statement about the lawsuits dealing with the failure of the Cannabis Commission. No, the lawsuits, again, are just an appeal. There was a question asked to Mr. Powell, or Chairman Powell, and I think this is important because the whole basis for this appeal is that the system it's bogged down. And Chairman Powell was asked, how does this end the current appeals? How does this get us to licensure faster? And I believe that I heard that he doesn't know. And that's because it doesn't. It doesn't solve the perceived problem. No matter what you do, you're going to create a new process that's going to lead to new appeals. And I think as Sam and Derek both said, that the only thing any legislation would do would be to prolong the process. Chairman Powell talked about money. He said, and that's right. And that's why the losing applicants are here fighting in every battlefield they can pick, whether it's court or in the legislature, to do whatever they can to get a license. But that's not the way the process is supposed to work. Chairman Powell also, and I don't mean to pick on you, Chairman Powell, but it seems like it's a foregone conclusion that errors were made. But so far, no jurist that has looked at this has agreed with that conclusion. And that's certainly not what the administrative judge found. In fact, she rejected all of the arguments. There was a statement about credibility. Well, the credibility of this body, to me, is at stake because it would show the citizens of Georgia that the legislature is not willing to stand behind the process that it created. Instead, it's willing to cave in to the pressure from lobbyists and losing applicants. Representative Kendrick asked a question, and a good one. Is it the law? Is it the original law, the HOPE Act, that's prohibiting the production of the THC oil? And no, the only thing that's prohibiting it right now is the process, the appeal process that was going to be in play no matter what the law said. And as Sam said, the process is nearing its end. So I would tell you, what's that? It is at the end. It is at the end. And in fact, Chairman, I will tell you, we're just past the Super Bowl. To use a football analogy, the award and the appeal process is on the 10-yard line. But to legislatively change the rules at this late stage will return the process back to midfield or even restart the game. I urge the subcommittee and the legislature to let the process play out so the winning applicants can begin to distribute medicine to the Georgia citizens in need. Thank you very much.
Thank you, Mr. Collins. We appreciate your testimony. I'm sorry to rush you. We're just trying to, we still
Understood.
have a few more witnesses and a few more bills. Don't leave the seat, though.
Oh, yeah.
Representative Kendrick's going to ask you a question.
Okay, it's going to be a running joke.
And I think buttering up's not going to do you any good. But
do you have the latest copy of the bill?
I do, Representative Kendrick.
Could you read the LC number?
LC 339416S, is that the one?
Yes. So I'm going to ask you the same question that I asked the previous witnesses, but on line 141 and on line 153,
Page 6.
since the word is may issue up to those additional licenses, where in the bill do you see that it requires the commission to issue it to the protesters?
I don't think it's in there, but, and I think that points to an issue of the vagueness of this bill. What is the process for issuing further licenses? One thing I did hear, I believe, was that the powers that be, well, and I believe Chairman Powell said he didn't have an answer to the question of how it would happen, except I heard something about the powers that be might exert pressure on the commission to do the right thing. But I think the bigger question is, what is the purpose, and Sam Olens alluded to this, what is the purpose of creating these new licenses? Well, the only purpose I've heard is not that there's a need, not that the original 6 are not going to produce enough medicine for the patients in the state. I've heard that the need for this legislation is to try and get rid of the lawsuits, but I have not heard any tying of how this legislation ends the lawsuits and gets us to licensure and production of medicine faster. And that's the question that this committee should be asking itself.
Follow up?
Yes. So help me understand. Maybe you're reading this line differently than I am.
And which line are we looking at, just to make sure?
Starting on line 140, the commission may issue up to 3 additional Class 1 production licenses. So they can issue 0, as I'm reading it, tell him if I'm reading it wrong, or they can issue 3. So all this does is give them the authorization to go up to 3.
Correct.
So they could issue 0.
I would, with the use of the word may, I would agree.
Okay.
But I would also say that there's no rhyme or reason to it. The HOPE Act, when it initially passed, the legislature decided that 6 was the right number, 2 Class 1s and 4 Class 2s. And so the question would be, well, what is the reason? Why are we even giving the commission the authorization to issue new licenses? And the only thing I've heard is we want to get rid of these appeals, which it's not going to get rid of the appeals. In fact, there's nothing in this legislation, especially the substitute. I think the first version wrongfully addressed the appeals, but this version doesn't say anything about the appeals and what happens to the current appeals. And what will likely happen is that they're going to just keep going, and the legislation will not solve the perceived problem. I hope that answers your question.
Thank you. Any further questions for this witness? I don't see any questions. Thank you very much for your testimony.
Thank you, Chairman.
Good to see you. All right, let's see. I believe the next witness we have that signed up is Les Schneider.
I'm not Les, but he's going to switch places with me.
Okay.
I know I've been here before. You guys are probably not happy to see me back. I will be
We're
as
delighted to see you as long as you
brief
try to be
as
over.
possible. And I will also say that I have brought handouts, but this is not a reflection of what I'm going to talk about. But I do think that what I have here would be helpful to the members that are still here. And I'm going to keep it quick and responsive to what you've heard. Again, my name's
we
Kristen
appreciate
Goodman,
that. Thank you.
and I know it's late. I've been here since 12 o'clock, and I know you've been here longer. I just want to make a couple of brief points, and I think they're responsive to what you've heard today. The first thing is, I've listened to all the lawyers testify, and I'm used to this now, because every time we've had anything, from the beginning of dealing with Executive Director Turnage to the one, and I will say it has been one hearing that has addressed the merits. You've heard 20 lawsuits and all these hearings and all the many times this has been considered absolute nonsense. It's been considered one time by one ALJ without giving us full access to records, to documents that we'd been asking for over a year. that when they were presented to us, and I have to chime a little bit in on Mr. Olin's indignance that he said he talked about all these redacted pages, and some of these people redacted 96% of their applications. 2 of the Class 2 winners redacted all but 15 pages of their 2,000-page applications. We were given a very limited access to partially unredacted applications prior to going into Judge Howell's hearing. We couldn't consult with our own experts, our own clients. As I said before, this is like me, an attorney, telling you, comparing for you whether an engine to an airplane has been properly built. You don't want to get on that plane. And I will submit to you that Judge Howell had no business determining, without any expert testimony, whether these applications had been granted properly, whether they had been evaluated properly. If she had, maybe some of the testimony you've heard today about the scoring disparities would also be eliminated, because they have assumed every time they've told you about low scores that their scores would have been the same. But what we know is that this was a flawed process, and that there is no guarantee that any of these scores would have been the same. The one full truth I have heard from every single other attorney who has sat at this table today, and I'm a lawyer and I speak and I testify and I know how lawyers work and we love to massage words, but I'm telling you very, very clearly that the one true statement you have heard today is what Mr. Bauer said when he said, clearly this is about money. Clearly it is about money. It is about the shareholders, it is about the market share, and it is about the revenue that the winners of these licenses, and I use winners loosely because 4 of these people don't even have a license yet. Okay, but what they are here for, the only transparency in this process, it hadn't been the commission, it's been the transparency of the motives of the people testifying who have tentatively received or signed contracts for these licenses to protect this process, to protect their market share. And that is what we're here for. There has been no rigorous review. The cases that have been filed for review of one review. They were dismissed on jurisdictional basis. No multiples of superior courts have heard whether this process was accurate or transparent or fair or even legal. And that is what the protesters are committed to pursuing. And I have news for everybody. It's not going to be over by this summer. So I'm not sure what litigation calendar they're banking on, but I know how litigation works. There was another lawsuit filed last week against the Department of Administrative Services and the GMCC, challenging the fact that they tossed out every rule they were supposed to respect in this process. It's just not going away. But to the point that I think has resonated with a lot of you, and I refer specifically to some questions that Representative Silcox, I would love to agree with you because I grew up in your district and I'm very fond of that neighborhood, but I'm afraid that we disagree, and I think that there have been some things that I have not heard said, and I want to bring to your attention 2 of those things. They're critically important. Number 1, to the subtle threat that there will be more litigation by those who are tentative winners if this bill is passed. And what is in your packet and what I would refer you to is the contract that is signed by every winner, both by the 2 who've already told you, I think great news, they're ready to distribute this medication as soon as they get the go-ahead. That's great. We'll be able to start getting this to patients who need it. But what they haven't told you, and what has been left out of the narrative today, is that the contract that those 2 companies have signed, and that the companies who are also the 4 licensees under the NOIA, specifically states that in agreeing to accept this license, they also agree to abide by all rules, laws, and regulations as amended by this body, by the GMCC, by the legislature. And I'm going to refer you, you can see them in your own. I've given you all a copy of the contracts. This license is conditional, it is time restricted, it is non-exclusive, it is revocable, and it is terminable without a hearing. And if you look at paragraph number 3, it says specifically that. If you look at paragraph number 5, it says licensee agrees to comply with and be bound by the HOPE Act as amended. The Cannabis Commission rules and regulations as amended, or policies and procedures as adopted. You flip to paragraph 13. It states very clearly their licenses can be terminated without any notice. Section 14, limitation of liability, states very clearly that notwithstanding anything contained herein to the contrary, the licensee's sole and exclusive remedy for any act of the Cannabis Commission related to the license or the licensee's work thereunder is limited to that which is expressly set forth in the HOPE Act. It also states very clearly that in no event shall the Cannabis Commission, the state of Georgia, or any of its officers, etc., be liable to the licensee for direct, consequential, indirect, special, or punitive damages, lost revenue, lost profits, lost income, and diminution in value. There are very specific limitations in these contracts and very specific statements that every person receiving a license has to abide by any changes made by this body or the GMCC. They don't get to say, you can't change the rules. That's not a fair statement of the law. It's not an accurate statement of the law, and it's not an accurate statement of the contract that they've already signed. Paragraph 18 says it best. This contract, including the HOPE Act and the Cannabis Commission rules and regulations, etc., during the term of this contract are the entire contract between the Cannabis Commission and the licensee. These are the rules that govern what the winners can and cannot complain about. They have specifically consented to move forward under those rules and under any amended rules set forth by this body. The second point that I want to make very quickly is specifically addressing Representative Silcox and others' objection to the increase in the number of licenses. And this is really important stuff that I'm going to hit bullet by bullet and then let you go. I think we have to understand that not only are these 6 licensees clustered in the center of the state, we have a limited amount of canopy space that has been given via these 6 licenses. It is important for every person voting on any bill to understand that the canopy space includes all space under the roof of a facility. In reality, only 1/2 to 2/3 of the facility space will actually be grow space. Each patient will need anywhere from 50 to 2,500 milligrams of medicine per day. Remember, this is not just crop that is smoked. This is oil that is extracted. It takes a high crop yield to extract a sufficient amount of oil to meet demand. The original 6 licenses, we've talked about numbers and thresholds, they were arbitrary. There was no registry basis for issuing 6 licenses. It was a compromise between 0 and 12, which is what the governor's office first pushed for. There is similarly no basis to assign arbitrary numbers to increases in the cannabis registry. It is also incredibly important to understand that if the market supply becomes tight, the natural response is to pack plants into the canopy space that you have. That makes them more vulnerable to disease and insects. It reduces the quality and the quantity of this medication. So why not just wait on a slow roll? We'll just decide as we go along. If there's a few more people, pick your number, because we've heard there's absolutely no basis for the numbers, no medical or other basis for the numbers, but pick a number and we'll decide that we need all of the sudden, because we've got people on our registry, more licensed facilities. It takes a year to 18 months from the time a license is granted to get a facility producing cannabis oil. What you have in the meantime is a shortage, and you have people waiting. People with some of the 18, 19 conditions we've talked about. And I will submit to you that we do not wait to build a fire station until the houses are burning down in front of us. What we do is we make sure we have an ample market, and we let the market take care of itself, as it has in other states. Truly, for example, could tell you that although there are 23 licenses in the state of of Florida, they have over 50% of the market share. Some of these businesses fail. Some of our businesses are going to fail. And we have to make sure when that happens that there is an adequate supply of quality medication at an accessible price. I have given to you a map that you will see that the original 6 you can see where the original 6 licensees are located, and I've given you a second map where you can see there would be far better coverage if additional licenses, and yes, they are connected to the protesters who, by the way, I can assure you that my hourly rate is far lower than Mr. Collins. So the statement that there is an army of lawyers that's being paid and how well funded these people are, that's simply not true. These are companies that have committed themselves to being Georgia-based companies to serve Georgians in the parts of the state that were left out of this process. Now, the last thing I want to share with you are a few statistics. We know from studies that have been done by Colliers Real Estate that a minimum of 100 dispensaries are needed to put a dispensary within a 20-minute drive of 90% of all Georgians. Right now, we have 30. We also have numbers that we can show you from how rapidly the registries in the other states that we could compare to the state of Georgia have grown. Florida, when the registry opened in late 16, they had 16,000 patients on the registry. By 2000, the licenses were awarded in 2018. 1 year later, when physicians knew this medication was going to be available, that registry tripled. More than now, 3 years later, there are more than 800,000 patients, close to 800,000 patients on that registry. Arkansas, first year of availability, the registry grew from 8,000 to over 90,000 patients. Missouri, first year of access, the registry grew to over 200,000 patients. That is a state with just over half of the population of the state of Georgia. And each of those states has fewer qualifying medical conditions than Georgia. So I will submit to you that this litigation is not going away. It is grounded in fact, it is grounded in law, and I will tell you that the best thing we can do for this state is to pass this legislation. The shareholders are going to be fine on those 6 companies, but the citizens in this state are not, if we do not provide for them an adequate supply and a fair and transparent process in getting there. So that's all I have to say.
Thank you, ma'am.
You bet.
Any questions for Ms. Goodman from members of the committee? Well, Representative Kendrick, you surprised me.
I'm going to thank you for that.
Thank you very much, Ms. Goodman. Les, are you testifying also?
We talked last time about why we're here, and I accept that, Jeremy Berry is representing his client. I like him. Sam Olens, we don't go to different synagogues, but I have nothing but affection for him. And Mr. Collins, I don't know that well, but no reason for animus. But I think at the end of the day, what we're still looking at is the fact that this issue has occurred in other places, and Florida waited an awfully long time to wait for a judge 2 or 3 years later to finally issue licenses to people who were claiming that the process was flawed. There was an issue of racial discrimination. There were other issues on the evaluation of the lines. And Representative Powell doesn't drop in bills for his health. I mean, he very well may have passed more bills in this chamber than anybody I ever know. But when he's dropping a bill, there's a reason for it. And it's a reason because he knows there is a problem. And he doesn't have to be a lawyer to know there is a problem here. And the intensity over supporting a monopolistic type situation and worrying more about companies than about patients is troubling to me. And I think at the end of the day, what we really have to focus on is the fact that the legislature is allowed to change its mind if they think there is something that was done that was incorrect. If there are diseases that have been left off that ought to be treatable with this medicine, if the process is flawed and we can find a solution, although, as I said last time, it doesn't have to be the perfect solution. It might be a grumpy solution. But to basically pull back and not do anything is an abdication of responsibility that you all have. I certainly endorse the first bill that Representative Powell represented. I'm not as crazy about the second bill, but I'm a realist. Something has to move. That this system has to be fixed. This is not the perfect part. Just a brief point about the lawsuits. We hear about this wonderful decision that was done by this administrative hearing officer. Well, obviously, we appealed that decision, the group did. And then when that was shut down, it went to the Court of Appeals, not on an automatic appeal, but on a discretionary appeal. And the Court of Appeals said, we may have to look at that perhaps these people did pursue the right level of appeal. And they're going to look at that issue. The DOAS suit, as Ms. Goodman talked about, has some serious merit. And again, you all can make the decision of whether we're going to try to fix this here and move forward. But I don't think these the sky is falling issues about these companies, none of them are qualified or many of them are not qualified, holds any merit. Wrong is wrong, and if the process was not followed properly, it needs to be remedied. So I would ask that you all, obviously I and a number of people on this would prefer the first bill that Representative Powell had, but at least we have to pass out something to get this thing fixed. And I'm hopeful that the House and the Senate, working collaboratively, will come up with a solution that's far better than where we are right now. But I do think the delay and not having a number of companies, more companies being involved in this would be a serious mistake. So I know the hour is late, and I'll be happy to go for answer any questions.
Thank you, Mr. Snyder. Representative Reeves.
Would it be fair to say that the bill and the substitute incorporate some of the experience from Florida?
The first bill or the second bill? I think the first bill really is a legislative solution to this. The second bill, because of the may instead of the shall, is not going to fix, I think, the litigation. But there are many instances that Congress, when there's lawsuits, come up with settlements that are legislative settlements where the litigation goes away. Even in the first bill that Representative Powell presented, if this committee felt or somebody else felt there needs to be additional language that you get the license, litigation goes away, and that needs to be in there, that would be certainly wording that I think would be helpful.
Thank you. Any further questions from Mr. Snyder? I don't see any. Thank you very much.
Thank you.
Richard Griffiths.
Yes, sir.
Please come forward, Mr. Griffiths. Appreciate you being here.
Thank you. I'm Richard Griffiths with the Georgia First Amendment Foundation. Thank you for waiting with us all for my testimony. I am a cancer patient, actually, and in the middle of immunotherapy, and this is a really big deal to hear today. And you're going to make a good decision, I know, whether it's may or shall. I'm actually much more interested in something for the First Amendment Foundation that goes to the heart of trust. And that is that HB 196, either form, I think, will go a long way towards providing some confidence that the Cannabis Commission is properly run, appropriately run, and that we, the public, can trust what's coming out of it. Right now, the process is totally opaque. You've heard Chairman Powell talk a little bit about it, but from my perspective, trying to figure out what's happening at the Commission is almost impossible. And I'm a smart guy. I worked as a journalist for 42 years. I still have not been able to weasel out the process within the commission. And the commission really seems to be losing the public's trust. You have to do something about that. And the Open Records Act portion and bringing them under the administrative portion can do a lot towards rebuilding that confidence. Now, that said, we at the First Amendment Foundation understand that some things are in fact legitimate trade secrets, that there are things that people don't necessarily need to know all the details of, relating to security, relating to perhaps some of the financing. But the participants, who the board members are, those shouldn't be redacted in the applications. We know that when it comes to trade secrets, there needs to be a process that allows those spurious items to be revealed. You know, the things that don't really need to be secret, that they can be shared, while legitimate things can be kept private. Well, the existing Open Records Act allows for that already. There's already a process within the Open Records Act for that. So we believe Georgia has been really, really well served by its long tradition, bipartisan tradition, of open and transparent government. The Open Records Act is a terrific act, which I am delighted to teach about every chance I get. And you guys have done such a good job of keeping it current. This bill, however, will fix a major flaw in it, where the Cannabis Commission just is not transparent. And I'll note that one of the cool things that I noted in the Cannabis Commission's annual report was its own recommendation that it be subject to the Open Records Act. So as you move forward with this bill, maybe it's only 2 paragraphs. If you can't agree on everything else, at least agree on getting it under the Open Records Act and under the Administrative Act. So that's all I have to say, except that I probably would have voted for John Adams because I'm an immigrant and I came from the other side, and my relatives might have been redcoats. So just saying.
As Louis Grizzard would say, I don't know if I told that one. Thank you very much for your testimony, though. Do you have any questions for Mr. Griffiths? I don't see any questions. Thank you so much.
Very, very much for the time.
All right, is there anyone else here to testify on House Bill 196? Okay. All right, I think we cleared the room. All right, I will, Mr. Chairman Powell, did you wish to say something in closing?
I would like to say something in closing. I want to thank the ladies and gentlemen of this committee. You know, I appeared in front of the full committee about 10 days ago. And I've listened to things here tonight, and, you know, I never had a desire to be on Judiciary, either one. And believe it or not, I still believe that.
We're the poor for your absence, Chairman Powell.
So I will tip my hat to y'all for your diligence and your patience, because y'all are certainly unique that y'all get to hear this. So many intricate parts of the legalese. And I want to talk a little bit about the testimony that y'all heard. And I will tell you up front that this was as grand a time as I have had today, because I feel like I've been sitting in a reincarnation of the Scopes monkey trial. The gentleman that spoke from Sam Olens, the grandfatherly senior delegation, who reached out to your heartstrings, to the other 2 lawyers, sharp guys. God knows that's the reason I never did get remarried, because I was afraid they'd be representing my wife. The last gentleman that spoke over there, the gray-haired guy, let me tell you something. I like these guys, but these guys are paid by the hour. And I want you to hear what I'm telling y'all. they're paid by the hour and I'm not. I make the same salary as an elected representative as y'all do. Now, some of y'all may consider me to be a little bit different, a little bit odd from some other members. But
Not
when
as far
I
as you
was
know,
elected as a child of the 60s and the 70s, I was a rebellious fellow, one of them hippie and pot smoking rascals that came along that was fighting the system. And I never forget why, when I ran for office, and for almost 34 years serving in the House, I've never forgot what my duties and obligations were. And that's to try to fix things, to try to make things better. Now, the attorneys that spoke today, they wanted to make this out to be all about the cannabis companies. Well, folks, I want to tell you something about the process. I was actively involved in this because I always said that anything that God makes is better than something that's made in a pharmacy. And when I saw these children and I saw these sick folks, and it wasn't just me, it mushroomed across the whole spectrum of the General Assembly. And we passed something and it was flawed. I've said it time and time again, it was flawed. Under the late Speaker Ralston, to fix this, it was sent to Reg Industries. And our committee dealt with it, and we dealt with it, and we worked on it. But I'll tell you something. The bill that you have, and I'll get to the two bills that you've got, but the solution to this problem wasn't necessarily to give anybody an extra license. It's about solving a problem, of fixing a problem. And the problem is that, yes, there's litigation, so there wouldn't be litigation if it hadn't been something that wasn't done right in the process. Those of us on Reg Industries, we heard testimony for a year and a half about the process over there and the stuff that was hidden and redacted and everything else. And we heard this. And I don't care who gets a license. But I believe in the free enterprise, but I believe in a system that's done correct. But I also believe that we have an obligation to fix a flawed system. Now, most of y'all are lawyers, or y'all certainly have more legalese experience than I do. But y'all have heard it, and I think a lot of y'all, I see the shaking of the heads that y'all know more about the litigation and the process of litigation. We've been dragging this thing out long enough. And I listened to the testimony from a couple of the lawyers. Well, you know what? If they're out there, if they're wanting to open up for the goodness of mankind and to the healing of the downtrodden, hell, they wouldn't be worried about filing more lawsuits. This is about a monopoly, folks. You got two companies that have a monopoly right now. You've got four of the companies that were tentatively approved. They ought to be all on board to fixing the solution, because the longer it drags out for the two monopolies, they're going to be held out that much longer. So it's fix the system. That's what this is about. I personally resent the idea and I'm sure none of these attorneys, good learned attorneys, meant to offend me in any way. But they don't know me well enough to know. I ain't doing this for any one company. I'm doing it to fix a system. Now, the two bills that I talked about, the bill that y'all passed was my original bill 196. Now listen, y'all know the system as well as I do. It was sent over to y'all to Judiciary to get a second look-see. Well, maybe I wasn't as, with my salty sense of humor when I made the comment to them, said, well, you see, now you've sent it to two committees that overwhelmingly passed the bill. So it wasn't just my personality or whatever. So it was passed. Well, then I was approached this morning, somewhere about 9:45, with this substitute. Now, we know the process. Well, listen, I'm only a chairman, but we all have to take direction from the policymakers. And all of a sudden, this substitute was brought to me. Well, I'll be honest with you, I looked at it, and I didn't care much for it. I didn't. But I got to be honest with you, the more I've looked at it now, and the more the attorneys representing the monopolies have gone against it, I'm beginning to like that bill as good as I did my own bill. So I say to whoever in the upper leadership that came up with that as a second solution, because nowhere in the last 2 years of dealing with this issue have I not opened it up and said, anybody that's got a solution, tell me what the solution is. and nobody came up with a solution. So that's where this bill comes from. And now you've got a substitute in front of you. I would encourage you to vote to pass this on, to get it into the system. I would put this, all the talk that you heard. I mean, with these guys, I love listening to this stuff. I was told yesterday that I was going to be besieged by all the slick-talking folks in the world that was going to threaten y'all and plant subliminal thoughts in your mind about how you're going to get sued again. But at the end of the day, if you do what's right, if you do what's right in the process, it's going to move forward. And it'll probably change along the way. I don't know how it's going to change, but it'll change. As we all know, legislation changes at every toss and turn of the road. But I would encourage you to pass this substitute forward so that we can move on with this and put all of this other stuff, this game playing and the shrewd talk that was put out. In the process of all of that, somewhere, if y'all pass this on forward, I would encourage each and every one of y'all to start asking some questions. Regulated industries, we heard a lot of things over the years that I haven't even said in here about things that the Cannabis Commission did about what companies were granted licenses that aren't really a Georgia-based company. They just went and got a ball player, or they got somebody local to invest. But they're out. They ain't in-state companies. Trust me, they're not. This is about money. I started the conversation off this afternoon. This is about money. And it's about 2 companies that want to keep a monopoly and 4 more that would like to be in a monopoly. But I will refute anybody's idea that said, when I heard a guy, one of the attorneys was talking about constitutionality, unconstitutional what y'all could do by doing this. You know, the first thought went through my mind is I always remember a lot of the good folks that I talked to along the way, constituents. And every time I hear one of them talk about, damn, it's against the Constitution, I wonder, well, where's your law license, buddy? Because if you want to scare somebody, just use the word unconstitutional. A lot of y'all are attorneys, and y'all know what I'm talking about. Don't submit to the threats and the intimidation. They were good speakers. I'd like to see all of them perform in a circus one day in maybe another courtroom. But let me tell you something. This is about helping people. This is about curing a problem that we had, and we come back every January to fix the issues that need to be fixed. Mr. Chairman, committee, I'm sorry that I waylaid this way longer than I meant to, but I certainly would appreciate your favorable consideration for the leadership bill to move this bill forward.
Thank you, Chairman Powell. We apologize for keeping you and all the folks who wanted to testify to this bill waiting so long. We've had a busy day with a lot of work going on. What I'd like to do first is just, Representative Reeves, did you have a comment?
I think you were going, I was just going to get the LC number and make sure that you took notes of Chairman Powell's and that somebody has a copy of that.
That's where I'm headed. Thank you. So just to review for everyone, we're looking at LC 339416S. That's what's before the committee. Chairman Powell proposed or requested some amendments, which I just want to review. They were on line 141 to change the word 3 to 4. That's on line 141. Change the word 3 to 4. And right below there in line 143 to change the numeral 14 to the numeral 15. That's 1-5. Then on page 7 on line 153, he proposed to change the word 6 to 7. And right below there in line 155 to change the numeral 14 to 15. We got 1 or 2 others on page 9 and line 209 to change the word substantial, where it says further proceedings if substantial rights, to change substantial to material. And then in line 212, after statutory provisions, the end of that line, to add before the semicolon, or applicable procurement rules. And then I believe the only other change was on the very last page. Basically, we're going to add as an additional condition in line as R, or and I don't know if Leg Council would want to, if those are in some kind of order. It doesn't seem that they're in alphabetical order. We would just add as R, myasthenia gravis. And then we would need to delete the or in line 287 and make the period on line 288 a semicolon and then add the word or there. And then we would have myasthenia gravis period, I'm sorry, as an additional item. So does everybody understand the amendments that were proposed? All right, so I think at this point I would like to know the pleasure of the committee and would entertain a motion. President Kendrick?
Move do pass.
I have a motion to pass. Do I have a second?
Second.
I have a second by Representative Reeves. Do we have a motion to amend? Representative Gullett, I have a second, and I'm proposed that amending as I kind of just described and outlined as Chairman Powell's requested. Any second to that motion? Second. I have a second. So I have a motion and a second. So on the motion to amend, and I won't go through it because I think we kind of went through it pretty well. Is there any further discussion? All right. I'll call the question. All those in favor of the motion to amend, please signify by saying aye. Aye. All those opposed, no. All right. The motion to amend passes, and now on the motion do pass with the amendments. I've got a motion and a second already. Is there any discussion on that motion? And I'll call the question. All in favor of the motion signify by saying aye. Aye. All opposed, like sign. Nay. Nay. Who we have a nay? Nay. Nay. Right there. Oh, so we have 2 nays. The motion passes. All right, and that bill is on the rule. Thank you, Chairman Powell, and thank you everybody who came and testified. All right. Thank you. All right, Mr. Chairman, did you want to address your bill tonight? All right, so we're going to hold House Bill 126. Okay. What's that?
Does it go to rules or your whole committee?
I'm sorry, it's true. It would go to full committee. Excuse me. I was usurping my authority. So we have, let's see, which one do we want to do? Let's see, oh, there's Scott. Okay, yeah, he's here. So Scott? Sure, I think you're okay.
We staying?
Huh? Yeah, I got 2 more bills to do. All right, Representative Holcomb, you have the floor.
Thank you, Mr. Chairman, members of the committee. Really appreciate you hearing this. I'll begin by saying I know you've been here for a long time, and I've been waiting for a long time to present this bill, but it was just a matter of hours. And in doing so, I thought about the people that I'm here to speak on behalf, and they waited years. I'm here to speak on behalf of those that were wrongfully convicted, for us to set up a system so that way we can compensate them. While we can never truly compensate them, I think that we can make the process one that is much better. So it is my pleasure on behalf of those who have been wrongfully convicted to present to you House Bill 364. As a backdrop, this bill was considered by the House last year. It passed with overwhelming support by a vote of 157 to 11. I don't recall any opposition in this committee, but I know that there are a number of new members, and so I'll walk through the process and what we're trying to do. The way that it currently works is if an individual is innocent, and I want to be very clear about that. We are not talking about those that are released because of some technicality. We are talking about people that did not commit the crime that they are convicted of and sentenced for. Right now, the process is a political one, where an individual has to find a legislator to sponsor their packet, and then each individual packet has to go through as a separate bill and go through the entire process, through committee, through appropriations. And last year, there were 2 that were in play. One was called at 12:09 a.m., the third to last one to be called, and the other was called at 12:11 a.m. And I think it was only because Chairman Hogan and I went over to the Senate and insisted that they be called. So we don't want that to happen. And I apologize for getting emotional, but when you spend time with people that spent 18 years, 20 years, it's impossible for it not to impact you. So with that, what this would do, to give you a very quick overview, is it would set up a board of experts, a wrongful conviction board, and the individuals who are on the board are listed on page 4, and it's a good cross-section of individuals that would bring specific expertise: judge, district attorney, defense attorney, person with forensic science background. And then what they would do is they would hear the information. They would make or conduct a review to ensure that the person was innocent. And then if so, they would make a recommendation to the claim advisory board. The claims advisory board is attached to the Secretary of State's office, and this is where you have to go right now. As a matter of course, they always reject these, and then it comes to the legislature to them take action. And so we're trying to fix that, and that would be done by this wrongful conviction review board. The legal standard, which has been vetted closely by the prosecutor and others, is to ensure, again, that these are those who are innocent, and that's through the bill, but you have to be exonerated. That whole process, the deck is stacked against those that have been convicted, and we've been very careful to make sure, again, that it's only going to be those who are innocent. And then the amount of compensation is found on page 7, and it would be a range between $50,000 to $100,000. And the board could then make a recommendation based on the person's work experience, based on the person's profession, and then consider those factors in coming up with a reasonable amount. As context and background, around $75,000 is the kind of going rate, for lack of a better term, across the country. So this would allow ranges that are within that range. And then after the recommendation, it would ultimately go to the Chief Justice of the Supreme Court. And then the Chief Justice, and this is on page 8, the Chief Justice would make the recommendation, send it to the Chief Justice of the Supreme Court. And then it would just be an administrative function where the Chief Justice would make the request on behalf of the wrongfully convicted in the budget request. And the idea behind that is, since the error occurred within the court system, we thought it made sense to have it be part or within the court's budget. And then the General Assembly would still have its full authority to consider that and to either approve it or not. But I'd like it to think that it would be approved, because we're setting in the safeguards and procedures to make sure that, 1, it's only those that are wrongfully convicted, and then 2, to have a system set up for it to move forward. So I know I kind of jumped around. I would have gone through it section by section, but since it's late, I wanted to give you the high-level overview. I'm more than happy to go into any of the details if there are any. And the last thing that I'll point out, which may be helpful to know as well, is the last 2 pages of the bill has an important carve out, because an individual could have a lawsuit for wrongful conviction, and this effectively has a credit. So if they do that, the state gets the benefit of that. And so I think we've covered all of the basis, and I don't know who's still here, but they support it. The prosecutors support it. The people that are impacted by it support it. And we've worked very hard to put together a good bill, and I really appreciate you all staying late to hear it.
Thank you, Representative Holcomb. I think you've got a few questions. Representative Kendrick.
Thank you, Representative Holcomb. For the benefit of those that may not have been here for a few years, I've seen you and Representative Hughley and others to try to pass these compensation bills of people wrongfully convicted. So isn't it true that one of the reasons why I think this bill is so helpful is because it removes sort of the politics out of getting these people who are wrongfully convicted, had to spend their lives behind bars, away from family, diminish their earning capacity. It takes it out of the politics and really puts it into the hands of people who are concentrating on the facts of the case, so that they can get the compensation that they deserve.
Exactly. And I didn't speak too much about why the compensation is important. Most of these people are losing the most important earning years of their lives. And then we're just setting them free and saying, all right, go and make up for it. So they lost all that time, all that experience, all that ability to save money. So it's, I mean, asked a different way, would any of you take this deal? None of us would take this deal.
Thank you. Any follow-up, Representative Kendrick? Chairman Saines.
Thank you, Representative Holcomb. I know that you worked hard on this with Chairman Hogan last year on a particular case. I wanted to note that I don't know if you were fortunate enough to be here 5 hours ago. We were discussing a parallel bill in terms of moving an action that we could take in the legislature and move it to a specialized committee that can possibly do something important more efficiently. Would you agree that that's what we're doing here, moving an act of the legislature into a board?
It is a specialized review panel. I don't know all the other circumstances that you're referencing, but yes, this would be a review panel because the Claims Advisory Board as it exists now, and I went through it last year with the person that I was to help. It's somebody from the Secretary of State's office. It's just individuals that don't have expertise on these areas. And really, I will say, I think just to get released and exonerated is such a heavy, heavy burden that in many ways, this committee, its work isn't going to be terribly hard, because the work is already done, because it's so hard to get exonerated.
Quick follow-up. Where is the fund for the compensation coming? The general fund?
General fund. Mm-hmm. Yep. Just it'll be a line item in the Chief Justice's budget, so it would come through the Public Safety Subcommittee of Appropriations.
Thank you, Chairman Saines. Leader Hong.
Thank you, Mr. Chair. Representative Saines took one of my questions, but I wanted to know where the funds were coming from, but also, would you be, I see the language as far as if they have a pending civil claim, that they will have to reimburse the state for the amount that they're receiving. Would you be open to possibly some kind of language where the state would have some kind of a lien on that claim? And I'm just saying, you just don't want a claimant to be in a situation where they would have received the funds and then later on get the funds, spend it, and not know about it, or et cetera, and then now the state's going after them for money. And we're not talking about small amount, I don't think, so that's just a suggestion, just to help, I think, both parties.
Yes. Do you have any thoughts on that?
In that circumstance, there is an award, to the I'll cut this one on for you over here if you like.
Actually, you know what?
Go ahead.
I think it addresses it, because if at the time a claim is made, the claimant has won, you reduce the award by that. And then it's lines 204 to 211. So if they've already gotten it, an award or judgment, then it reduces the amount that they would get through this. And then if it's made after, then it has a safeguard too. So I don't think that that situation would happen.
Where is that safeguard? I just read it as, if it happens after, then the claimant shall reimburse the state, less any sums paid to attorneys, et cetera.
I see.
And again, I think it's gonna, and it happens, and I'm just kind of thinking of different civil cases where it does happen, where they're supposed to pay, but they end up getting it, didn't know they were supposed to reimburse or pay certain medical bills, pay somebody else, and you just don't want to get them in a situation where, hey, now you owe the state a bunch of money, and they're like, I don't know.
One
So-
lawsuit at that point, once they have cash.
Right. I don't know the collection aspects of things. I think that this imposes a legal obligation for them to do that, and if they didn't, then certainly the state could take action. And whereas a lien, I think, is just a little bit different. I don't oppose the concept. I just don't know that it's necessary.
Right, where if there was a settlement, the attorney has to pay that lien, pay that state before dispersing the funds to the claimant, is to their client. That's kind of where I'm talking about as far as a lien. Just like any other, like medical lien in a civil case, attorneys have to pay those liens first before dispersing it to the client.
May I ask a question or two that might be relevant to this issue? So if you're, I would argue that the language requiring the payment to the state in the statute may in itself it creates an obligation which might be sufficient. If you have a lien, most of the liens, I think, to which you've referred are evidenced by some kind of filing, so the attorney can check the records to see what he or she has to pay, right? I mean, hospital liens, doctoral liens, that sort of stuff. So I'm wondering just how we would, I mean, I think it's easy enough to add language about the lien. The state shall have a lien for the amounts due to the state by a claimant under this code section. But then I guess the question is, how would it be enforced? Would we need to address that? It might be that language would be enough.
And that's kind of where I'm going at it. I think having that language in there will alert an attorney to say, okay, the state has a lien, without necessarily being, where's the paperwork? At least they're on alert and notice.
Yeah, I have no objection to that. I'm not an expert in liens, so if you all think that is needed, I certainly would not object. I think that's fine.
Thank you.
You're welcome.
Thank you, Leader Hung. Representative Reeves?
I don't want to complicate it, but since we're in subcommittee and there may be some time before committee, here's an idea. What about making the payment from this fund non-refundable, and it would just be set off from any verdict or settlement that occurs later? And here's some math on that. If the claim under the fund in this statute is $500,000, and then the verdict or settlement with the state is $1 million, that $500,000 would be credited to that. So the net that the state would pay would be $500,000. And then also make it non-refundable, where there's not going to be some, clawback of the money. If the verdict's $350,000, then it's already paid. But I don't know. I have a little bit of a concern about all the effort is made under the statute to award money to somebody, and then who was wrongfully convicted, and then there's a scenario where they'd be paying money back. I just don't get that concept.
Yeah. I think practically speaking, this was put in as a safeguard. If the board is set up, I think there will be very, very few cases on wrongful conviction because they will have a path to be compensated. And so the probability that this section is even implemented is likely pretty low, coupled with just the litigation aspects of most people that come out of jail, the last thing that they want to do is be spending more time in courtrooms. And so if we can have the wrongful conviction review board set up, it's a one-day hearing, it's very efficient, they'll get compensated and then move on. So do you disagree? And this is Stan Jones, who done a ton of work on pro bono basis for the Georgia Innocence Project and has helped.
Yeah, I mean, that actually sounds more practical to me.
Yeah.
Make it non-refundable. Because lien might carries other procedure, or at least it might. I think that's why we're hesitating, because they don't know all the pieces of it well enough. But a set-off sounds easily administered.
A non-refundable payment that would be set off in any excess verdict, something like that, excess verdict or settlement.
Yeah, I would support any of those. I think the concept is the same in terms of where we want to go.
We could get it right before full committee if we need to. I mean,
yeah.
I don't mean to cut off the discussion, but there's a little time to fix it.
All right, Mr. Chairman.
Thank you, Mr. Chairman. Representative Holcomb, thank you for this good bill that you brought before us. If you're willing to, and for the sake of time, would you be willing to work with me on this bill and us hammer out some changes to it?
Of course, Mr. Chairman.
Yeah. All right. Thank you.
All right, thank you. All right, so why don't we do that, and we'll try to shine up those last few provisions and see if we can get that out. Thank you, Representative Holcomb, and thank you, sir, for your testimony. All right, Representative Franklin, still lurking about, eh?
I think he was napping over there.
All right, you got House Bill 302.
I did. Thank you, Mr. Chairman and members of the committee. You guys are rock stars as far as I'm concerned. I appreciate you giving me the time to present
Flattery
this bill.
will get you everywhere. Keep going.
Yes, so this is Bill 302, LC 480815, and this talking about amendment to the code section 16-5-94, specifically relating to protective orders. And basically, all this bill does is just add the terminology in subsection D on a temporary or permanent basis. 16-5-90 already has that language in there. I'm not an attorney, but I spoke to a lot of them, and they tell me that it's basically, it should be a non-issue. You may see some issues with it, but the way that this bill came about was I had a constituent that brought an issue to me, and because of that, she was trying to get a permanent order, and because of that, I researched it, and everywhere I looked, I found problems along these areas. And the more I dug, the more I felt like that we needed to kind of tweak the language there to make it more obvious of what it can do. Because the main thing here is, when you get a stalking situation like that, it's intimidation, it's control, and it's fear. And a lot of the victims, don't want to come back to face their accuser again after a 12-month period or after a 3-year period. And there's even members of this House that are having that same issue. I've spoken to members of the House that are going through the same thing, and they're pretty frustrated about it. So I know that this may not be a solve-all problem, but at least it's a first step, and I'm hoping that by putting this language in there, it would give the judges a clear discretion of either, making it permanent at that time. And I'll
Thank you, Representative Franklin. So, and this is in the stalking protective order. It's in the stalking section of the code, right?
That's correct. Yes,
we're
sir.
not dealing with family violence. This is just purely stalking.
It's purely stalking.
And we're I guess trying to just make
Abundantly
absolutely clear what we think would be implied, but avoid any dispute over it in the future.
Yes, sir. That's correct.
Okay.
And the reason why this was brought up, there was situations where judges felt like they didn't know if they had the complete authority to do it to make it permanent at that time.
I see. Chairman Smith.
Thank you, Mr. Chairman. Representative Franklin, good to see you again. Thank you for your patience. Thank you to committee members' patience. My question, just to reiterate, you and I had a conversation about this, and when you brought this bill to me, we had a conversation about where we could read the statute as allowing them to already do this, but yet there's a problem of statutory interpretation. Is that basically the gist of what this bill is addressing?
Yes, sir. That's correct.
Okay. Thank you.
Thank you, Mr. Chairman. Chairman Saines.
Thank you, Mr. Chairman. Have you been here since the beginning of the subcommittee?
I have, yes, sir.
6 hours, and I count, I'm no attorney, but I count 6 words on your bill.
That's right. Well, constituent, has a problem. I want to help solve it. So.
Your rate is a word an hour up in the 40 words. Thank you.
Thank you. Thank you, Chairman Saines. Leader Hong.
Thank you, Mr. Chair. Thank you. I think Chairman Smith did address what we had a discussion about. And my next question is there a mechanism for after a permanent protective order is issued 5 years down the road, 50 years down the road, for either party to motion the court to say, I changed my mind, or, hey, we're good?
So I am told there is. I'm told that a judge could reverse it at his convenience or his whim, and also if the victim put in a request, that he could reverse it immediately. That's what I'm understanding.
Yeah, my understanding, and from having dealt with these on a few times, is that you can petition to modify or suspend it or terminate it. So, Representative Kendrick.
Oh, thank you, Mr. Chair.
Did you forget you wanted to ask a question?
No. Thank you for bringing this. So to Chairman Smith's point, so I actually had this happen to me a couple of years ago. I had a stalker, and when I went to get a protective order, this was one of the things that I was trying to get, something more permanent. And the judge, was very hesitant to give me something that was like over a year. I think they only gave me something like 30 days, and I had to reapply. So I appreciate this, because this is something that really affected me about 3 or 4 years ago. So thank you.
I appreciate that. And this testimony that you just gave is what I've heard over and over and over again. So thank you.
Thank you. Any further questions for the sponsor? I don't see any questions. Thank you very much.
Thank you, Mr. Chairman.
All right, Ms. Travis, you've been sitting here, and I don't think it's because you just like spending time with us. Did you want to? Chairman Saint says he thinks you do like spending time. It's kind of weird.
The really sad part is, I wish I didn't realize that was Representative Carpenter over there. I don't want to get comfortable here, but I would have gone and asked all these questions that you all were asking, because I had the same ones. And he explained it very well, and I should have said I have nothing to say, but thank you.
Thank you. Thank you. All right. Since there's not really anybody else in the room at this point, I'm assuming nobody else wants to testify. Yeah. Sponsor got out of here. Mr. Chairman.
Mr. Chairman, I apologize. That's on me. My knob over here decided that he wasn't needed anymore, so I had to go get him back. Mr. Chairman, I move at the appropriate time this bill do
Please,
pass.
I'll entertain that motion. I have a motion do pass. I have a second. I have a motion and a second. Any discussion? All in favor, say aye. Aye. And opposed, no. The motion passes. And I will. Thank you. Thank you for waiting with us. Well, at least it wasn't one bill. We had quite a few.
Yeah, that's true. Per bill, we still need to stay here.
We're adjourned. Thank you. Thank you, everybody.